serial number 4 ನವರು ಇದ್ದಾರಾ? ಏನ್ ಬೇಕು, ಏನ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ತೀರಾ ಏನು? ಕೌನ್ಸಿಲ್ 6 3 days time granted. 4 ಆಯ್ತಾ? serial number 3 ಅಂಜಣ್ಣ MS absent 1 week granted. serial number 5 Chetan Jadhav.
My lord, in this case, I apparently have the petitioner, my lord, pray for a week's time, my lord, to comply with office objection.
Week's time granted. Next.
Much obliged.
Jagdisha H. Here regarding maintainability and agent. Number 6.
My lord, I appear for the respondent in this for DRI. My name may kindly be shown. It is shown as SPP. For respondent,
allobru submission ಮಾಡ್ತಾ ಇದ್ದಾರೆ, ನೀವು ಒಬ್ರು ಮಾಡ್ತಾ ಇದ್ದೀರಿ. ರೆಸ್ಪಾಂಡೆಂಟ್ ಗೆ ಎಷ್ಟು ಜನ ಅಪಿಯರ್ ಆಗ್ತೀರಿ?
It is an investigation by the director of revenue, Directorate of Revenue Intelligence.
ನೀವು ವಕಾಲತ್ ಹಾಕಿದ್ದೀರಾ?
ಹೌದು ಸ್ವಾಮಿ, ನಮಗೆ we have the instructions to appear in this matter.
ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇದೆ, ನೀವು ವಕಾಲತ್ ಹಾಕಿದ್ದೀರಾ ಅಥವಾ ಎಮ್ಮೆ ಹಾಕಿದ್ದೀರಾ ಏನು ಹೇಳಿ?
ಹೌದು, ಮೆಮೋ ಆಫ್ ಅಪಿಯರೆನ್ಸ್ ಬೆಳಿಗ್ಗೆ ಕಳಿಸ್ಕೊಟ್ಟಿದ್ದಾರೆ, ಕೌಂಟರ್ಗೆ ಹಾಕ್ತೀನಿ ಇವತ್ತು.
ಇನ್ನು ಹಾಕಿಲ್ಲ,
ನಿನ್ನೆ ರಾತ್ರಿ ಕಳಿಸಿದ್ದಾರೆ.
ನೀವು ಹಾಕಿದ್ದೀರಾ? ನಿಮ್ಮ ಹೆಸರಲ್ಲಿ ಬಾಲಕೃಷ್ಣನ್ ಅವ್ರು ಆಲ್ರೆಡಿ ಹಾಕಿದಾರಂತೆ. ನೀವು ನೌ ಯು ಆರ್ ಕ್ಲೈಮಿಂಗ್ ದಟ್ ಯು ಆರ್ ಗೋಯಿಂಗ್ ಟು ಫೈಲ್ ಎಮ್ಮೆ. ಯಾರ ಹೆಸರು ತೋರಿಸ್ಬೇಕು ಹೇಳಿ?
ಸೀರಿಯಲ್ ನಂಬರ್ 6 ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ ನಂಬರ್ 1589 of 2022.
ಜಗದೀಶ್ ಹೆಚ್ ಇದಾರೇನ್ರಿ? ಇದೇನ ಡಬಲ್ ಪಿಟಿಷನ್ ಇದೆ ಅಂತ ನೋಡಿ. ರಿಟೈರ್ಮೆಂಟ್ ಯಾವಾಗ ನೆನೆ ಹಾಕಿದಾರ? ಅಲ್ಲ, ನೆನೆ ಏನಾಯ್ತು? ನೆನೆ ಮ್ಯಾಟ್ರ್ ಇತ್ತ? ಇದೇನ ಇನ್ನೊಂದು ಏನಾಯ್ತು ಮೇಡಮ್? ಏನಂತ ಏನಕ್ಕೆ ಅಂತ ಅವ್ರೇನ್ ಮೆಮೋ ಹಾಕಿದ್ದಾರೆ? ಅಕ್ನಾಲೇಜ್ಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದೀವಾ? ಅಲ್ಲ ರೀ, 2 ಪಿಟಿಷನ್ ಹೆಂಗ್ ಹಾಕಕ್ಕಾಗ್ತದೆ? NOC ಕೊಟ್ರೆ NOC ವಕಾಲತ್ ಹಾಕೊಂಡು ಅಪಿಯರ್ ಆಗ್ಬೇಕು. ವಿಡ್ರಾ ಮಾಡಿಲ್ಲ, ಅವರು ವಿಡ್ರಾ ಮಾಡಿಲ್ಲ. ಮೆಮೋ ಫಾರ್ ರಿಟೈರ್ಮೆಂಟ್ ಹಿ ಹ್ಯಾಸ್ ಫೈಲ್ಡ್ ಅಷ್ಟೇ. ಮತ್ತೆ ನೀವು ಅದ್ರಲ್ಲಿ NOC ಹೊಡಿತು ವಕಾಲತ್ ಹಾಕ್ಬೇಕು ಅಲ್ವಾ? ಆಯ್ತು ನೋಡಿ, ಈಗ ಏನ್ ಮಾಡ್ಬೇಕ್ರಿ? ನಿಮ್ಮಿಬ್ರು ಜಗಳ ನಾವ್ ಇತ್ಯರ್ಥ ಮಾಡ್ಬೇಕಾ ಏನು? ಆಲ್ರೆಡಿ ಫೈಲ್ಡ್. ಯಾವಾಗ ಹಾಕಿದಿರಿ? ಡೇ ಬಿಫೋರ್ ಎಸ್ಟರ್ಡೇ. ನೋಡಿ, ಕೌನ್ಸಿಲ್ ಶ್ರೀ ಬಿ ಬಾಲಕೃಷ್ಣ, MR ಬಾಲಕೃಷ್ಣ, MR ಬಾಲಕೃಷ್ಣ CGSC submits that he has already filed MA for respondents on 24th, and hence office is directed to put up the MA and show the name of counsel Sri MR Balakrishna for respondent. 23rd ಮಾಡ್ಕೊಳ್ಳಿ ಆಯ್ತಾ? ಕೌನ್ಸಿಲ್ ಶ್ರೀ ಹೇಳ್ರಿ.
ಬೇಡ, ಅವ್ರದಿರ್ಲಿ. ನೋ ಮಲಡ್, ಅವ್ರದಿರ್ಲಿ.
Post this matter next week along with ಅದೊಂದು ನಂಬರ್ ಹೇಳ್ಬಿಡಿ ಮೇಡಮ್. 3995 of 21 ಬರ್ಲಿ. ಅವಾಗ ಅದು ಯಾರ್ದು ಆಗುತ್ತೆ ಮಾಡಿರಾಯ್ತು ಅಷ್ಟು. ಆಯ್ತು. Fourth man, serial number 4th time, serial number 7 Sumant L Bharadwaj.
Objection complied with Malas except the production of type copy. I made submission that is legible and readable.
Fourth time ಅಂದ್ರೆ ಇಂತ ಕಾಸ್ಟ್ ಹಾಕಿದ್ ಕಟ್ಟಿದಾರ ಮೇಡಮ್?
paid Malas.
ಕಾಸ್ಟ್ ಹಾಕಿರ್ತೀವಿ ನೋಡಿ. ಈಗ ಏನು ಅಡ್ವೊಕೇಟ್ ಸಬ್ಮಿಷನ್ ಏನು ಕೊಡಿ?
The typed copy may kindly be dispensed.
Typed copy of manuscript ನೀವೇನ್ ಹಾಕಿದಿರಿ? ರೀಡಬಲ್ ರೀಡಬಲ್. ಯಾವ ಪೇಜ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದಾರೆ ನೋಡಿ ಮೇಡಮ್?
12 minutes.
ರೀಡಬಲ್ ನೋಡೋಣ. ಪೇಜ್ ಯಾವ್ದು ಹೇಳ್ತಾರ ಅವರು? ರೀಡಬಲ್ ಅಂತ
page 12 minutes.
page 12 ಅಂತ. Counsel submission is accepted. HCCP is directed to take notice and file objections, if any. This matter on date, madam. 8 March. First time orders 8 to 13. ಯಾವ್ದಾರು ನೋಟಿಸ್ ಹೋಗೋದಿದೆಯೇನ್ರಿ? ಕರ್ಸ್ಬಿಡಿ, ಕೆಲವು ಮ್ಯಾಟರ್ಸ್ ಇದೆ ತಗೊಂಡು. ಸೀರಿಯಲ್ ನಂಬರ್ 8 Prasanna, HCCP is directed to take notice and file objections, if any. This matter on 8. Next 9 Lakshmikant, HCGP is directed to take notice and file objections if any. 8th. Serial number 10. Chidananda Murthy.
Appearing for petitioner, my lord.
HCGP is directed to take notice and file objections if any. 8th. Sudarshan L. Sudarshan L. Same order. Number 12. KB Satish Chandra. Same order. 13. Jay Simha KP and KPJ Associates. HCGP is directed to take notice and file objections. 8th March. 8th March. ಆಯ್ತು. ನೆಕ್ಸ್ಟ್ ಗಿರೀಶ್ ಬಡದರ ನೋಡಿದ್ರೇನ್ರಿ CCTV ಫುಟೇಜ್? ಹಾ 14/2 ಆಯ್ತು. 27/3 ಆಯ್ತು. CCTV ಫುಟೇಜ್ ಪ್ರಶ್ನೆ ಒಂದೇ. CCTV ಫುಟೇಜ್ ಅಲ್ಲಿ ನಿಮ್ಮ ಅಕ್ಯೂಸ್ಡ್ ಎತ್ಕೊಂಡು ಹೋಗಿದ್ದಿದೆಯಾ ಇಲ್ಲ? ನನ್ ಪ್ರಶ್ನೆಗೆ ಉತ್ತರ ಕೊಡಿ, ಆಮೇಲೆ ನಿಮ್ ಸಬ್ಮಿಷನ್ 10 ಕೇಳ್ತೀನಿ ನಾನು. ಇದೆಯಾ? ಇದೆಯಾ ಅದ್ರಲ್ಲಿ? ಹಾ, ಯಾರ ಮುಖ ಕಾಣ್ತಾ ಇಲ್ಲ? ಹಾ ಯಾವ್ದು ಇಲ್ವಾ? ಹಾ ನೋಡ್ಬೋದು. ನಾನೀಗ ಲ್ಯಾಪ್ಟಾಪ್ ತರಿಸಿ ನೋಡ್ಬೇಕಾ? ಹಾ ಏನ್ರಿ ಇದೆಯಾ ಇಲ್ಲ ಡೇ ಟು ಟೈಮ್? ಹಾ ಹೇಳಿ. 72 to 70. ಹಾ ಹಾ ಹಾ
He only gave the statement before the IO regarding the seizure of the CCTV footage. Regarding date and time of dispute, to that extent, on 33/2021 only the CCTV footage was being seized. 33/2021. Regarding
33/2021. ಅವ್ರೇನ 14/2 ಅಂತಾರ?
ಸ್ಟೇಟ್ಮೆಂಟ್ ತಗೊಂಡು ಆ ಟೈಮ್ ಅಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಮಾಡುವಾಗ
CCTV ಫುಟೇಜ್ ಕೇಳ್ರಿ ಸ್ವಲ್ಪ. CCTV ಫುಟೇಜ್ ಸೀಸ್ ಮಾಡೋ ಸಂದರ್ಭದಲ್ಲಿ ದಿಸ್ ವಿಟ್ನೆಸ್ ಮಂಜುನಾಥ್ ವಾಸ್ ಪ್ರೆಸೆಂಟ್ ಅಕಾರ್ಡಿಂಗ್ ಟು ಯು ದಟ್ 30th March. Incident was taken place on 27th. 30th it was seized ಅಂತ. ಆಯ್ತು ಹೇಳಿ. ಹಾ
date of gap between the incident and
only 3 days. ಆಯ್ತು. ಹಾ ಆಯ್ತು. ಮೆಡಿಕಲ್ ಎವಿಡೆನ್ಸ್ ಏನಿದೆ? ಮೆಡಿಕಲ್ ಎವಿಡೆನ್ಸ್ ಎಗನೆಸ್ಟ್ ಇದೆ ಅಂದ್ರೆ ಪಿಟಿಷನರ್ಗೆ ಎಗನೆಸ್ಟ್ ಇದೆಯಾ? ಹಾ 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 ಅಷ್ಟೇ. ಅದನ್ನ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಅಬ್ಸರ್ವ್ ಮಾಡಿದ್ದಾರೆ. ಹಾ ಹಾ ಹಾ
So when that is the case, the investigation officer had laid the material witnesses statement during the course of filing the charge sheet. When that is the case, regarding the apprehension of the petitioner about the face of the petitioner is not visible, it's a matter of correct. So my submission to this honorable court, prima facie materials are used.
ಆಯ್ತು ತೋರ್ಸಿ ತೋರ್ಸಿ. ಏನ್ ತೋರಿಸ್ತೀರ ಅದ್ರಲ್ಲಿ? ಹಾ ಏನ್ರಿ 30th ಆದ್ರೆ ಡೇಟ್ ಇರ್ಬೇಕಲ್ರಿ? ಅಲ್ಲ ನೀವೀಗ ಏನ್ CCTV ಫುಟೇಜ್ ಕೊಟ್ಟಿದ್ದೀರಿ, ಅದರಲ್ಲಿ ಡೇಟ್ ಟು ಟೈಮ್ ಪ್ಲೇಸ್ ಇರ್ಬೇಕಲ್ಲ? Because you have not produced that along with, when this court asked you, have you placed the CCTV footage along with sheet? Then now you are placing that. Then it should be authenticated document and it should disclose. It should disclose the time and date. Everything should be there. ಮತ್ತೆ ಈ ಕೋರ್ಟ್ನವ್ರು ಕೇಳಿದ್ಮೇಲೆ ನೀವು ಅದನ್ನ ತಯಾರಿ ಮಾಡಿರ್ಬೋದು. ಮತ್ತೆ ಟೈಮ್ ಡೇಟ್ ಬೇಕಲ್ಲ. ಕ್ಲಾರಿಫೈ ಮಾಡಿ, ನನ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಡೇ ಟು ಟೈಮ್ ಇಲ್ಲ ಅಂತ ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್. ಈಗ ಆಲ್ರೆಡಿ ಆಗಿದೆ, ಆಗಿಲ್ವಾ? ಇದಾಕೆ ಹೊರಡ್ ಅಂತ ಇದೆಲ್ಲ ಹರ್ಡ್ ಇನ್ ಪಾರ್ಟ್ ಅಂತ ಹೇಳಿ ಮೇಡಮ್. CP regarding time which is not forthcoming in the CCTV footage, copy given to the petitioner counsel. This matter on next week outler on date kudi. Thursday kudi. Thursday. Astrology, 3rd of March. Secondly, you have not produced the same along with the charge sheet. 65B and charge sheet ಜೊತೆಲಿ ಹಾಕ್ಬೇಕು ಅಂತಾನು ಇಲ್ಲ. ಅದಕ್ಕೂ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಬರ್ದಿದ್ದಾರೆ ನೋಡಿ. ಇದ್ರ ಕೇಸಲ್ಲಿ ಮೋಸ್ಟ್ಲಿ ಯಾವ್ದೋ ಹಿರೇಮಠ ಕೇಸಲ್ಲಿ ಬರ್ದಿದ್ದಾರೆ. ಓನ್ಲಿ ಅಟ್ ದ ಟೈಮ್ ಆಫ್ ಅಡ್ಮಿಟಿಂಗ್ ದಿ material for evidence, they have to produce the 65B certificate. 29th of May 2021 ಹಿರೇಮಠ ಜಡ್ಜ್ಮೆಂಟ್ ಒಂದಿದೆ ನೋಡಿ ರಿಗಾರ್ಡಿಂಗ್ ಲೋಕಾಯುಕ್ತ ಮ್ಯಾಟರ್. ಅದ್ರಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅವ್ರು ಹೇಳ್ತಾರೆ, while filing the charge sheet, no need to file 65B certificate. It can be filed at the time of even recording the evidence. While admitting the document, but there must be a certificate. ಮೊನ್ನೆ ಪೋರ್ಟ್ಕರ್ ಕೇಸಲ್ಲೂ ಕೂಡ it is mandatory ಅಂತ ಮಾಡಿದ್ದಾರೆ. ಆಯ್ತು, PF ಈಗ ನಂತರದಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ ಆಫ್ಟರ್ ಫೈಲಿಂಗ್ ಆಫ್ ಚಾರ್ಜ್ ಶೀಟ್. ಅದೇ ಆಫ್ಟರ್ ಫೈಲಿಂಗ್ ಆಫ್ ಚಾರ್ಜ್ ಶೀಟ್. ನೀವು ಅಲ್ಲ ರೀ, ನೀವು ಈಗ 33 CCTV ಕಲೆಕ್ಟ್ ಮಾಡಿದ್ರೆ, ಇನ್ಸಿಡೆಂಟ್ ಆಗಿ 27/3 3 ದಿವಸದಲ್ಲಿ ಕಲೆಕ್ಟ್ ಮಾಡಿದ್ರೆ, ವೈ ಯು ಹ್ಯಾವ್ ನಾಟ್ ಎನ್ಕ್ಲೋಸ್ಡ್ ಇಟ್ ಅಲಾಂಗ್ ವಿತ್ ದಿ ಚಾರ್ಜ್ ಶೀಟ್? ಅದಕ್ಕೆ ಡೌಟ್ಫುಲ್ ನಿಮ್ ಕೇಸ್. ನೋಡೋಣ, ವಿಲ್ ಸಿ if it is genuine, I will consider it. ಯಾಕೆಂದ್ರೆ ಇದು ರೇಪ್ ಆನ್ ಎ ಚೈಲ್ಡ್ ಏಜ್ಡ್ ಅಬೌಟ್ 6 years, 6 ವರ್ಷದ ಮಗು, ತಂದೆ ತಾಯಿ ಜೊತೆ ಮಗು ಬಸ್ ಸ್ಟ್ಯಾಂಡ್ ಅಲ್ಲಿ ಮಲಗಿದ್ರೆ ಅವ್ನು ಹೊತ್ಕೊಂಡು ಹೋಗಿ ರೇಪ್ ಮಾಡ್ತಾನೆ ಅಂದ್ರೆ ಇಟ್ ಇಸ್ ಹೀನಸ್ ಅಫೆನ್ಸ್. ಐ ಆಲ್ಸೋ ಕನ್ಸಿಡರ್ ಇಟ್ ಇಸ್ ಸೀನಿಯರ್. ಅದಕ್ಕೆ ಜಿನೇನ್ ಇದ್ರೆ ವಿಲ್ ಕನ್ಸಿಡರ್ ಇಟ್ ಅಷ್ಟೇ. ನೆಕ್ಸ್ಟ್ PV ಬಿಟ್ಟು ಏನ್ರಿ ಇದು 4 ಮೊನ್ನೆ ಇದು ಕೂಡ ಏನೋ ಪಾರ್ಟ್ ಮಾಡಿದ್ವಿ. ಯಾರು ಹೇಳಿದ್ರು? ಅವರ ನೀವು ಟೈಮ್ ತಗೊಂಡಿದ್ದು ಕೊಡಿ, ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ ಮೇಡಮ್. Karnataka counsel for the petitioner submit that police have already completed investigation and filed charge sheet. Hence he seeks time to place the charge sheet material ಅಂತಿದೆ. ಹಾಕಿದೀರಾ? ಆಯ್ತು, ಈಗ ಏನ್ ಹೇಳಿ? ಮ್ಯಾರೇಜ್ ಆಗಿ ವಿತಿನ್ 3 months ಡೆತ್ ಆಗಿದೆಯಾ? 304B ಡೆತ್ ಏನು? suicide by hanging. Where suicide? ఇది ಮ್ಯಾಟ್ರಿಮೋನಿಯಲ್ ಹೋಮ. What time she committed suicide? Daytime. ಅದಾದ ಡೆತ್ ಬೈ ಆಸ್ಫಿಕ್ಸಿಯಾ, ಹ್ಯಾಂಗಿಂಗ್ ಹರ್ಸೆಲ್ಫ್ ಅಂತ. Demanded 2 rings. Mass marriage. ಮ್ಯಾರೇಜ್ ಅಟ್ ಧರ್ಮಸ್ಥಳ. ಆಯ್ತು. ದೇರ್ ಆಫ್ಟರ್ ಶಿ ಹಸ್ ಜಾಯಿಂಡ್ ದಿ ಮ್ಯಾಟ್ರಿಮೋನಿಯಲ್ ಹೋಮ್. ಪ್ಲೀಸ್. ಹಾ. ಅವಳು ಸುಯಿಸೈಡ್ ಮಾಡ್ಕೊಂಡಿದ್ ಯಾವಾಗ? ಅವತ್ತೇ ಏನೋ ಫೋನ್ ಮಾಡಿದಾಳಲ್ಲ ಅವಳು. ಅದೇನೆ 6 ಗಂಟೆ ಮಧ್ಯಾಹ್ನ 1 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ನನ್ನ ಮೊಬೈಲ್ ನಂಬರ್ ಸೋನ್ಸೋಗೆ ನನ್ನ ಮಗಳು ಆಕೆಯ ಮೊಬೈಲ್ ನಂಬರ್ ಸೋನ್ಸೋನ ಮೂಲಕ ಕರೆ ಮಾಡಿ ಒಂದೇ ಸಮಯ ಅಳುತ್ತಿದ್ದಳು. ಇದಾದ ಸ್ವಲ್ಪ ಹೊತ್ತಿನಲ್ಲಿ ಮಗಳು ಫೋನ್ ಕಟ್ ಮಾಡಿದ್ದಳು. ಇದಾದ ನಂತರ ನನ್ನ ಅಳಿಯನಿಗೆ ಕೆಲಸ ಏನೋ ಫೋನ್ ಮಾಡಿದಲ್ಲಿ ನನ್ನ ಅಳಿಯ ಫೋನ್ ತೆಗೆಯಲಿಲ್ಲ. ನಂತರ ಸಂಜೆ 5 ಗಂಟೆಗೆ ನನ್ನ ಮಗಳ ಮನೆಯ ಮೇಲೆ ಬಾಡಿಗೆಗೆ ಕಾವ್ಯಾರವರು ಮನೆಯವರು ಅವರ ಮೊಬೈಲ್ ನಂಬರಿಗೆ ಕರೆ ಮಾಡಿ ನಿಮ್ಮ ಮಗಳು ಆಕೆ ಇದ್ದ ರೂಮಿನಲ್ಲಿ ನೇಣು ಹಾಕಿಕೊಂಡಿದ್ದು. ಸರಿ ರೀ, ನಿಮ್ ಪ್ರಕಾರ ಹಸ್ಬೆಂಡ್ ಮನೇಲೇ ಇದ್ದ 1 ಗಂಟೆಯಲ್ಲಿ, ಹೆಂಡತಿ ನೇಣು ಹಾಕೊಂಡವಳ, ಸತ್ತೋಗಿದ್ದಾಳೆ. ವೈ ಯು ಆರ್ ನಾಟ್ ಇನ್ಫಾರ್ಮ್ ದಿ ಪೇರೆಂಟ್ಸ್ ಆಫ್ ದಿ ವಿಕ್ಟಿಮ್? ಓನ್ಲಿ ಯುವರ್ ಟೆನೆಂಟ್ ದಟ್ ಟು ಅಟ್ ಅರೌಂಡ್ 5 o'clock ಇನ್ಫಾರ್ಮ್ ದಿ ಸೇಮ್ ಓವರ್ ದಿ ಫೋನ್. ಅಲ್ಲ ರೀ, ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಇರೋ ಅಲಿಗೇಷನ್ ಇದು. ಸಂಜೆ 5 ಗಂಟೆನಲ್ಲಿ ಮನೆಯಲ್ಲಿ ಬಾಡಿಗೆಗಿದ್ದವರು ಫೋನ್ ಮಾಡಿ ಹೇಳಿರೋದು ಸತ್ತೋಗಿದ್ದಾಳೆ ಅಂತ. ನಿಮ್ ಪ್ರಕಾರ ನೀವು 5 ಗಂಟೆ ಮಧ್ಯಾಹ್ನ 1 ಗಂಟೆಲಿ ಮನೇಲಿ ಇದ್ರಿ, ಮಲ್ಗಿದಿರಿ, ನಿಮ್ ಪ್ರಕಾರ ವಾಟ್ ಇಸ್ ದಿ ವೈ ಕಾಂಡಕ್ಟ್ ಆಫ್ ದಿ ಏನಂತ? ಸುಯಿಸೈಡ್ ಫಾರ್ ವಾಟ್? ಸುಯಿಸೈಡ್ ಫಾರ್ ವೈ ಅಷ್ಟೇ. ಮಗಳ ಕಪಾಳಕ್ಕೆ 2 ಬಾರಿ ಹೊಡೆದಿದ್ದು ನನ್ನ ಮಗಳು ನನಗೆ ಫೋನ್ ಮಾಡಿ ಹೇಳಿ ಹತ್ತಿದ್ದಳು. ಅವಾಗ 17/5 ಆಯ್ತು ಆಯ್ತು ಆಯ್ತು. Who has no parents? He has no parents, sir. He has no parents, sir. They were staying in Bangalore in the house of the sister. Eight months are over. No money being there. No officer in the department has been created. ಏನಾದ್ರು ಪಂಚಾಯತ್ ಏನಾದ್ರು ನಡೆದಿದೆ ಬಗ್ಗೆ ಏನಾದ್ರು prior to committing suicide? ಏನಾದ್ರು ಡೆತ್ ನೋಟ್ ಇದೆಯಾ ಹೋಗ್ಲೇ? ಏನ್ ಪಂಚಾಯತ್ ಏನಾರು ಇದೆಯಾ? ಇಲ್ಲ. ಇವನ್ ಕೆಲಸ ಏನು? What is the job of this petitioner? What is the job of this private? ಡಿಪಾಸಿಟ್ ಮಾಡಿದಾನೆ ಹೆಂಡತಿ ಅಕೌಂಟಿಗೆ ಅಂತ ಹೇಳಿ, is it a ground for granting bail when the wife dies within a 3 months of marriage, that too in a matrimonial home? phone call details ಇದೆಯಾ? 6/6/2021 ಹೇಳಿ. Call details ಆಯ್ತು. ಹಾ. ಹಾ.
On 6/6/2000, the victim has called the father of the father at 1:06.
ಅದೇ ಒಂದು ಅದೇ ಇದೆ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಇದೆ ರೀ ಅದು. ಹಾ ದಟ್ ಇಸ್ ಕಾಲ್ ಡೀಟೇಲ್ ಕೂಡ ಇದೆ.
Call made by Kavya, 6 to complainant. That call detail also is there. As far as the panchayat with regard to the application software, this honorable court, whether is there any panchayat? My equal submission to this honorable court. Marriage was taken place 3 months prior to the incident.
ಆಯ್ತು.
During the course of these 3 months only, the deceased has many times over phone informed both of the mother and father about the illegal being caused by the petitioner. So that effect, the statements of the family members, that the mother and father statements was being recorded about the treatment in the given by and console being made by the parents of the victim. So considering the advantage in material and that is the all details records was available. Submission of the, there is a proximity with regard to the medical also being given by the petitioner, for which the deceased has called the father and that extent material is.
ಅಲ್ಲ ರೀ, ಮದ್ವೆ ಆಗಿರೋದೇ 3 ತಿಂಗಳ ಹಿಂದೆ. ನಿಮ್ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ನೋಡಿ 2 ತಿಂಗಳು ಚೆನ್ನಾಗಿ ನೋಡ್ಕೊಂಡ್ರು. ಮದುವೆ ಆದ ನಂತರ ನನ್ನ ಮಗಳು ಗಂಡನಾದ ಕೃಷ್ಣಮೂರ್ತಿಯು ಮತ್ತು ಅಕ್ಕ ವಿಜಯಲಕ್ಷ್ಮಿ ಅವರ ಜೊತೆಯಲ್ಲಿ ಬೆಂಗಳೂರಿನ ಟಿ ದಾಸರಹಳ್ಳಿ ಮನೆಯಲ್ಲಿ ವಾಸವಾಗಿ ಮಾಡಿಕೊಂಡಿದ್ರು. ಎಲ್ಲ ಒಟ್ಟಿಗೆ ವಾಸ ಇದ್ರ. ಅವನ ಅಕ್ಕ ನಂತರ ನನ್ನ ಮಗಳನ್ನು 2 ತಿಂಗಳುಗಳ ಕಾಲ ನನ್ನ ಮಗಳ ಗಂಡ ಮತ್ತು ಆತನ ಅಕ್ಕಂದಿರು ಚೆನ್ನಾಗಿ ನೋಡಿಕೊಂಡಿದ್ದು. ಪೇಜ್ 19, ಐ ಆಮ್ ರೀಡಿಂಗ್ ಪೇಜ್ ನಂಬರ್ 19. ನಂತರ ದಿನಗಳಲ್ಲಿ ನನ್ನ ಮಗಳ ಗಂಡ ಈತನು ನನ್ನ ಮಗಳಿಗೆ ನನ್ನ ಚಿಕ್ಕಮ್ಮನ ಮಗನ ಹೆಂಡತಿಗೆ ಹಣ ಮತ್ತು 2 ಮಾಂಗಲ್ಯ ಚೈನು ಕೊಟ್ಟಿದ್ದಾರೆ. 2 ಮಾಂಗಲ್ಯ ಚೈನ್ ಬೇಕಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. ನಿಮ್ಮ ಅಮ್ಮ ನನಗೆ ಕೊಟ್ಟಿಲ್ಲ. ನನಗೆ ಹಣ ಮತ್ತು ಮಾಂಗಲ್ಯ ಚೈನ್ ಅನ್ನು ಹೆಚ್ಚಿನ ವರದಕ್ಷಿಣೆಯಾಗಿ ಕೊಡಿಸು ಎಂದು ನನ್ನ ಮಗಳ ಮೇಲೆ ಹೆಗಲ ತೆಗೆದು ಅವಾಚ್ಯ ಶಬ್ದಗಳಿಂದ ಬೈತಿದ್ದ, ಹೊಡೆಯುತ್ತಾ ಮಾನಸಿಕ ದೈಹಿಕವಾಗಿ ಹಿಂಸೆಯನ್ನು ನೀಡುತ್ತಿದ್ದು. ನನ್ನ ಮಗಳ ಗಂಡನ ಮಕ್ಕಳಾದ ವಿಜಯಲಕ್ಷ್ಮಿ ಈಕೆಯು ನಮ್ಮ ಮನೆಗೆ ಬಂದು ತನ್ನ ತಮ್ಮನಿಗೆ ವರದಕ್ಷಿಣೆಯಾಗಿ ಹಣ ಕೊಡ್ಲಿಲ್ಲ. ಈಗಲಾದ್ರೂ ನನ್ನ ತಮ್ಮನಿಗೆ ನಿನ್ನ ತಾಯಿ ಕಡೆಯಿಂದ ಆತನು ಇದ್ದಾನೆ ಎಂದು ನನ್ನನ್ನು ಹೀನ ಮಾರ್ಗವಾಗಿ ಮಾನಸಿಕವಾಗಿ ಕೊಟ್ಟಿದ್ದರು. ನನ್ನ ಮಗಳು ಎಲ್ಲಾ ವಿಚಾರವನ್ನು ನನಗೆ ಫೋನ್ ಮೂಲಕ ತಿಳಿಸಿದ್ದಳು. ದಿನಾಂಕ 3/6 ನಮ್ಮ ಮನೆಗೆ ನನ್ನ ಮಗಳು ಮತ್ತು ಆಕೆಯ ಗಂಡ ಕೃಷ್ಣಮೂರ್ತಿ ಬಂದಿದ್ರು. ಈ ಸಮಯದಲ್ಲಿ ನನ್ನ ಮಗಳಿಗೆ ನಿನ್ನ ತಾಯಿಯಿಂದ ಹೆಚ್ಚಿನ ಹಣ ಮತ್ತು ಮಾಂಗಲ್ಯವನ್ನು ಕೊಡುವಂತೆ ಕೇಳು ಎಂದು ಹೇಳಿತ್ತು. ಅದಕ್ಕೆ ನನ್ನ ಮಗಳು ಒಪ್ಪದೇ ಇದ್ದರು. ಅದೇ ದಿನ ಅವರ ಮನೆಗೆ ಹೋದರು. ಮನೆಗೆ ಹೋದ ನಂತರ ನನ್ನ ಮಗಳ ಗಂಡ ನೀನು ಹಣ ಮತ್ತು ಒಡೆಗಳನ್ನು ನಿನ್ನ ತಾಯಿ ಹತ್ತಿರ ಕೇಳಲಿಲ್ಲ ಎಂದು ಜಗಳ ಮಾಡಿ ನನ್ನ ಮಗಳ ಕಪಾಳಕ್ಕೆ 2 ಬಾರಿ ಕೈಯಿಂದ ಹೊಡೆದಿದ್ದು. ಈ ವಿಚಾರವನ್ನು ನನ್ನ ಮಗಳು ನನಗೆ ಫೋನ್ ಮಾಡಿ ಹೇಳಿ. ಈ ದಿನಾಂಕ 6/6/21 ಮಧ್ಯಾಹ್ನ 1 ಗಂಟೆಗೆ ಫೋನ್ ಮಾಡಿ ಹೇಳಿದ್ರು. ಫೋನ್ ರಿಸೀವ್ ಮಾಡ್ಲಿಲ್ಲ. ಮನೆ ಮೇಲ್ಗಡೆ ಇವರು ಇಂಟಿಮೇಟ್ ಮಾಡಿದ್ರು ಅಂತ. ತೊಗೊಳ್ಳಿ. FIR state. ಆಯ್ತು. Heard the petitioner, counsel, and also the counsel against the state. The factual matters of the case of the prosecution is that marriage of the victim was solemnized 3 years prior to the victim. Sorry, 3 months. 3 months. 3 months. The marriage, this petitioner matrana. This petitioner thought her very well for a period of 2 months and thereafter started harassing her, demanding additional gold ornaments. And also the sister with whom the victim and this petitioner are residing at Bangalore also insisted get additional dowry, not given any dowry at the time of marriage, and the petitioner is having loan. In order to clear the loan, insisted get additional dowry. It is also an allegation that on 3/6/2021 also both petitioner as well as victim came to the house of parents of the victim, and at that time also he insisted to demand the dowry and gold ornaments, and when she refused, he took her back on the same day and subjected for assault. The same was also informed to the parents. But on 6/6/2021 at 1 p.m. again the parents and informed about the same, and also she was crying. Phone was also disconnected. And on the same day, the tenant at around 5 p.m. called and informed that she has committed suicide. Complaint is lodged against the petitioner. Police have also filed the charge sheet for the offences committee 304B read with section 34 of IPC and also section 3 and 4 of DP Act. The counsel appearing for the petitioner would submit that the bail petition filed by the petitioner was rejected only on the ground that matter is under crime stage. Hence, the present petition is filed now. The police have also filed the charge sheet, and this petitioner is in custody from last 8 months. The counsel also brought to notice of this court that in the complaint, it is mentioned that the victim for a period of 2 months and the other allegation only for a period of 1 month. Of custodial trial with regard to both mental and physical cruelty as well as dowry harassment, and the same has to be tested in trial. Hence, he may be enlarged on bail. Per contra, the counsel appearing for the state would submit that the death is taken place with of a marriage. And also the complaint government very specific that on the date of the death also actually called and informed about the act of this petitioner. And, thereafter, at around 5 o'clock, they have received the information from the tenant. Court has to take note of the conduct of petitioner as well as subjecting her for repeatedly for dowry harassment. Mere filing of charge sheet is not enough. Grant the bail in a serious offense of 304B. Also take note of in span of 3 months. Having heard the respective counsel and also on perusal of material available on record, this petitioner present in the state of committing suicide. And the counsel appearing for the petitioner would submit that at around 1 o'clock, this petitioner was sleeping outside. Outside the house or outside? Sleeping in the room. In the house. In the house. ಆಮೇಲೆ ಆಸ್ಪತ್ರೆ ಕರ್ಕೊಂಡು ಹೋಗಿದ್ದಾರೋ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಸತ್ತವಳೆ ಅಂತ ಡಿಕ್ಲೇರ್ ಮಾಡಿದ್ದಾರೆ. ಹೊರಟು ದಿ ಹಾಸ್ಪಿಟಲ್. ನಿಮ್ ಪ್ರಕಾರ ನೀವು ಮಲಗಿದ್ರಲ್ಲ ಮನೆಯಲ್ಲೇ ಏನ್ರಿ ಯಾರ್ರಿ ತಗೊಂಡೋಗಿದ್ರು ಆಸ್ಪತ್ರೆಗೆ? ನೀವೇ ಇದ್ರಲ್ಲ 1 ಗಂಟೆ ನೀವ್ ಹೇಳ್ಬೇಕು, ನಿಮ್ಗೆ ಗೊತ್ತಿರುತ್ತಲ್ಲ. ಯು ಆರ್ ದೇರ್ ಇನ್ ದಿ ಹೌಸ್ ಅಟ್ 1 o'clock. ಸರಿ ರೀ, ಮಲಗಿದ್ರಿ ಮನೆಯಲ್ಲೆಲ್ಲ ಕೂಗಾಡಿ ಕರ್ಕೊಂಡು ಹೋಗುವಾಗ ಆಸ್ಪತ್ರೆಗೆಲ್ಲ ಗೊತ್ತಾಗುತ್ತಲ್ಲ. ನೀವಂತೂ ಕರ್ಕೊಂಡು ಹೋಗ್ಲಿಲ್ಲ ಆಸ್ಪತ್ರೆಗೆ. Who took the victim to the hospital when she committed suicide? ಏನಿದೆ ರೀ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಕೇಸ್ ಏನ್ರಿ? ಮನೆ ಮೇಲ್ಗಡೆ ಬಾಡಿಗೆಗಿದ್ದವ್ರು ಬಂದು ಹೇಳಿರೋದು ಸತ್ತೋಗಿದ್ದಾಳೆ ಅಂತ. ಕ್ಲಾಸ್ ಇವ್ರು ಹೋಗಿ ಅಷ್ಟೊಳಗೆ ಸತ್ತೋಗಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರಲ್ವಾ? ಆಯ್ತ್ರಿ, ಅವ್ರು ಹೋಗೋವರೆಗೂ ನಿಮ್ಮವ್ರು ಏನ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಮನೇಲಿ? ಕಾಂಡಕ್ಟ್ ಆಫ್ ಎನ್ ಹಸ್ಬೆಂಡ್ ವೆನ್ ವೈಫ್ ಈಸ್ ನಾಟ್ ಕೀಪಿಂಗ್ ವೆಲ್. ಹೌದಿಲ್ಲ? ನಿಮ್ಗೆ ಈಗ 8 ತಿಂಗಳು ಒಳಗಿದ್ದಿದ್ದೆ ದೊಡ್ಡ ಇದು. ಹೆಂಡತಿ ಜೀವ ಹೋಗುವಾಗ ಅಥವಾ ಅಟ್ಲೀಸ್ಟ್ ಏನಾರು ಅಟೆಂಡ್ ಮಾಡಿದಾನ? ಅವಳು ಸೂಸೈಡ್ ಮಾಡ್ಕೊಳಕ ಅಟ್ಲೀಸ್ಟ್ ತಗೊಂಡೋಗ್ಬೇಕಲ್ಲ, ಏನೇ ಆಗ್ಲಿ ಅವಳು. ಇವನ್ ಅಟೆಂಪ್ಟ್ ಮಾಡಿದ್ಲು, ಸತ್ತೋಗಿದವಳು, ಬದುಕಿದವಳು. ಇಸ್ ಇಟ್ ನಾಟ್ ದಿ ಕಾಂಡಕ್ಟ್ ಆಫ್ ಎನ್ ಹಸ್ಬೆಂಡ್ ಟು ಟೇಕ್ ಹರ್ ಟು ದಿ ಹಾಸ್ಪಿಟಲ್? ವಾಲಂಟರಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಬಿಟ್ಬಿಡಿ. ನಾ ವಾಲಂಟರಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಎಲ್ಲ ಈಗ ನೋಡೋದೇ ಇಲ್ಲ. ಪೊಲೀಸ್ನವ್ರು ಏನ್ ರೆಕಾರ್ಡ್ಸು ನೋಡೋದಿಲ್ಲ. ಬಟ್ ಕಾಂಡಕ್ಟ್ ಹೇಳಿ, ಕಾಂಡಕ್ಟ್ ಆಫ್ ಎನ್ ಅಕ್ಯೂಸ್ಡ್. ಹೋಗ್ಲಿ, ಹೆಂಡತಿ ಸಿಟ್ ಮಾಡ್ಕೊಂಡು ಹೋದ್ ರೂಮಿಗೆ ಬಾಗ್ಲ ಹಾಕೊಂಡು ನೀವೇನ್ ಮಾಡ್ತಾ ಇದ್ರಿ? ಅಟ್ಲೀಸ್ಟ್ ನೀವು ಹೋಗಿ ಮಲ್ಕೊಬಿಟ್ರ ರೂಮಲ್ಲಿ 1 ಗಂಟೆಲೆ? ಇಸ್ ಇಟ್ ಎ ಕಾಮನ್ ಕಾಂಡಕ್ಟ್ ಆಫ್ ಎನ್ ಆರ್ಡಿನರಿ ಪ್ರೂಡೆಂಟ್ ಮ್ಯಾನ್? ಅಂಡ್ ಆಲ್ಸೋ ಯು ಹ್ಯಾವ್ ನಾಟ್ ಇನ್ಫಾರ್ಮ್ಡ್ ದಿ ಪೇರೆಂಟ್ಸ್ ಅಂಡ್ ಟೆನೆಂಟ್ ಇನ್ಫಾರ್ಮ್ಸ್ ಅಟ್ 5 o'clock. ಆಯ್ತಾಯ್ತು ಮೇಡಮ್, ತಗೊಳ್ಳಿ.
Dispute that the petitioner was present in the house on the date of committing suicide and the consent of the petitioner submits at 1 o'clock. This petitioner was sleeping in the room in the house.
Sleeping in the room. The council also brought to notice of this court by filing memo along with documents that prior to committing suicide, he only credited the amount of rupees 2 lakh on different occasions to the account of the deceased. The same cannot be a ground to enlarge the petitioner in a heinous offense of death was taken place within 3 months of his marriage. The court has to take note of the normal conduct of the husband in the house itself, and also at the very same time the victim made phone call and informed about the act of the petitioner over the phone. And also the IO had collected the call details of the deceased. And on the very same day at 1 o'clock only, the wife called and informed about the conduct of the petitioner hearing. When such being the factual aspects of the case, it is not a fit case to exercise the powers in 439 of CRPC. The contention that charge sheet already been filed and he has been in custody from last 8 months is not a ground to enlarge the petitioner on bail. If you have the discussions, madam, I pass the following order. Bail petition is rejected. ಏನ್ರಿ ಜಗದೀಶ್, ಇದು ಯಾಕೆ ಪಾರ್ಟೆಡ್ ಆಗಿದೆ ಇದನ್ನು? ವೈ ಇಟ್ ವಾಸ್ ಪಾರ್ಟೆಡ್? ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡ್ತೀನಿ. ಆಲ್ ಲಿಸ್ಟ್ ಡೀಟೇಲ್ಸ್ ಏನಾಯ್ತು? ಆರ್ಡಿನ್ ಪಾರ್ಟ್ ಅಷ್ಟೇ ಇದೆಯಾ? ನೋಟ್ಸ್ ಏನಿಲ್ಲಲ್ಲ? ಸಮನ್ ಕಾಲ್ಡ್ ಅಂತ. ಯಾವ್ದೋ ನಿರ್ಮಲಾನ್ ಅವ್ರಿಗೇನೋ ಹೇಳಿದ್ರು ಅಂತಲೇನೋ ಇತ್ತು ಇಮಿಡಿಯೇಟ್ ಆಗಿ. ಅವನೇನ್ರಿ ಐ ವಿಟ್ನೆಸ್ ಮನೇನ ನೋಡಿದ್ವಲ್ಲ, ಅದೇನಾ? ನಿನ್ನೆನಾ? ಇದೇನಾ? ಯಾರೋ ನಿರ್ಮಲ present eyewitness says that he had witnessed the incident, and after that he had also informed the office. One Nirmala received the phone call anta. His contention is that there was a long gap between the ಇನ್ಸಿಡೆಂಟ್ ಆಸ್ ವೆಲ್ ಆಸ್ ರೆಕಾರ್ಡಿಂಗ್ ಆಫ್ ಐ ವಿಟ್ನೆಸ್ ವಿಚ್ ಯು ಆರ್ ರಿಲೈಂಗ್ ಅಪಾನ್ ಹಿ ಇಸ್ ಎನ್ ಐ ವಿಟ್ನೆಸ್ ಅಂತ. ಅದಕ್ಕೆ ದೇರ್ ವಾಸ್ ಎ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ದಿ ಐ ವಿಟ್ನೆಸ್ ಸೇಯಿಂಗ್ ದಟ್ ಇಮಿಡಿಯೇಟ್ಲಿ ಆಫ್ಟರ್ ವಿಟ್ನೆಸಿಂಗ್ ದಿಸ್ ಇನ್ಸಿಡೆಂಟ್ ಐ ಇನ್ಫಾರ್ಮ್ಡ್ ದಿ ಆಫೀಸ್ ಅಂತ ಅವ್ನ ಸ್ಟೇಟ್ಮೆಂಟ್. ಅದಕ್ಕೆ ನಾನು ಕಾಲ್ ಡೀಟೇಲ್ಸ್ ಕೇಳಿದ್ದು. ಏನಾಯ್ತು? ಹಾ ಹಾ ಆಯ್ತು. A1 to 5 ನಲ್ಲಿ ಏನಿದೆ ಕಾಲ್ ಡೀಟೇಲ್ಸ್? ಲೊಕೇಶನ್. A1. ಹಾ ಡಿಸೀಸ್ಡ್ ಆ ಟೈಮ್ ಅಲ್ಲಿ ಇದೆಯಾ? ಅಲ್ಲಿ ಫೋನ್ ಇದೆಯಾ? ಹಾ ಅವನಿಗೆ ಏನೋ ಕಾಲ್, ಅವನಿಗೆ A1 ಕಾಲ್ ಮಾಡಿದಾನ ಮತ್ತೆ? ಹಾ he was there at the time of, at the scene of occurrence ಇದ್ದ ಅಂತ. ಇಲ್ಲ ಡಿಸೀಸ್ಡ್ ಬೇಡ, ಸ್ಪಾಟ್ ಅಲ್ಲಿ A1 ಕಾಲ್ ಡೀಟೇಲ್ಸ್ ಇದೆ. ನೋ ಒನ್ ಸೀನ್. ಯಾರೋ ಒಬ್ಬರು CW1 ಏನೋ ಮಾಡಿದಾರಲ್ಲ, CW1 ಅಲ್ಲ, CW7 ಇರ್ಬೇಕು. ಹಾ ಹಾ who is having affair? Deceased or accused number 1? ಹೌದು, A1 and CW7. ಹೌದು. ಹಾ deceased is a married person. CW7. ಯಾರು ಈ CW7 ಡಿಸೀಸ್ ಕರ್ಕೊಂಡು ಹೋದ? ಹಾ this lover has not tolerated the conduct of the deceased ಅಂತ. ಹಾ motive for committing murder. ಹಾ ರಿಕವರಿ ಲೈನ್ ಏನಿದೆ ರೀ? ಈಗ ನಾವು ಯು ಆರ್ ರಿಲೈಯಿಂಗ್ ಅಪಾನ್ ದಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ CW ಕ್ಲೈಮಿಂಗ್ ಐ ವಿಟ್ನೆಸ್. ಯಾರು ಅವನು? CW2 ನಾ? ಎಷ್ಟು ಜನ ಇದಾರೆ ಐ ವಿಟ್ನೆಸ್ ಅಕಾರ್ಡಿಂಗ್ ಟು ದಮ್? ಲಾಸ್ಟ್ ಸೀನ್ ಬಿಟ್ಬಿಡ್ರಿ, ಈಗ ಲಾಸ್ಟ್ ಸೀನ್ ಬೇಡ, ನಾನ್ ಕೇಳ್ತಾರೆ. ಒಬ್ರದ್ದು ಯಾರು ಐ ವಿಟ್ನೆಸ್ ರಿಲೈ ಮಾಡ್ತಾರೆ. ಟ್ರೈನಲ್ಲಿ ಇದೆ ನೋಡಿ. ಎಷ್ಟು ಅವನು? ಬೇರೆಯವ್ರಿಗೆಲ್ಲ ಬೇಲ್ ಆಗಿದೆಯಾ? ಎಲ್ಲಾರ್ಗು ಅಪ್ಲೈ ಮಾಡಿಲ್ಲ. ಹಾ ಐದನೇ ಆರೋಪಿಗಳು ಇಟಿಎಸ್ ಫಾರ್ಮ್ ತಡೆದು ಎರಡನೇ ಆರೋಪಿಗಳು ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದ ಕಬಳಿಸಿಕೊಂಡು ಕೊಂಡೊಯ್ದಿದ್ದು ಕಾರ್ಯಯಾತ್ರೆಗೆ ಕರ್ಕೊಂಡು ಹೋದ್ವಿ. ನೈಸ್ ಕೇಸ್ ಅಂತ ಖಾಲಿ ಗೋಮಾಳ ಕರ್ಕೊಂಡು ಹೋಗಿ ಅಲ್ಲಿ ಒಂದನೇ ಆರೋಪಿ ಹೇಳಿದಂತೆ ಎರಡನೇ ಆರೋಪಿ ರವಿಕುಮಾರ್ ಅವರನ್ನು ಹಿಡಿದುಕೊಂಡು ಮೂರನೇ ಆರೋಪಿ ಕಣ್ಣು ಮತ್ತು ಬಾಯನ್ನು ಬಟ್ಟೆಯಿಂದ ಕಟ್ಟಿ ಮತ್ತೆ ಕೈಗೆ ಹಗ್ಗ ಕಟ್ಟಿ ಅಲ್ಲೇ ಬಿದ್ದಿದ್ದ ಕಲ್ಲನ್ನು ಒಂದನೇ ಆರೋಪಿಯು ತೆಗೆದುಕೊಂಡು ರವಿಕುಮಾರ್ ಅವರ ತಲೆಗೆ ಹೊಡೆದಾಗ ರವಿಕುಮಾರ್ ಅವರು ತಪ್ಪಿಸಿಕೊಳ್ಳಲು ಪ್ರಾರಂಭಿಸಿದಾಗ ಎರಡನೇ ಆರೋಪಿಯವರು ಹಿಂಬಾಲಿಸಿ ಹಿಡಿದು ಮೂರನೇ ಆರೋಪಿ ಸ್ಥಳದಲ್ಲೇ ಬಿದ್ದಿದ್ದ ಬಿಯರ್ ಬಾಟ್ಲಿಂದ ರವಿಕುಮಾರ್ ತಲೆಗೆ ಹೊಡೆದು ಮುಂದಿನ ಆರೋಪಿ ಅದೇ ಕಲ್ಲನ್ನು ತೆಗೆದುಕೊಂಡು ರವಿಕುಮಾರ್ ಅವರ ತಲೆಯ ಮೇಲೆ ಹೊಡೆದು ನಂತರ ಮತ್ತೊಮ್ಮೆ ದೊಡ್ಡ ಕಲ್ಲನ್ನು ರವಿಕುಮಾರ್ ತಲೆಯ ಮೇಲೆ ಹೊಡೆದು ತನ್ನ ರಕ್ತ ಸಿಕ್ತ ಬಟ್ಟೆಗಳನ್ನು ಅಲ್ಲಿಯೇ ಕ್ವಾರಿ ಬಳಿ ಬೆಂಕಿಗೆ ಹಾಕಿ ಹಾಗೂ ರವಿಕುಮಾರ್ ಅವರ ಮೊಬೈಲ್ ಮತ್ತು ರಸ್ತೆಯಲ್ಲಿ ಯಾವುದೋ ಒಂದು ದೊಡ್ಡ ಮೋರಿಯಲ್ಲಿ ಬಿಸಾಡಿ ಸಾಕ್ಷ್ಯ ನಾಡಷ್ಟು ಪಡಿಸಿದ್ದು. ಹೋಗ್ಲಿ, ಅದರ ರಿಕವರಿ ಆಯ್ತಾ? ಅಲ್ಲ ATM ಇವನು ರವಿಕುಮಾರ್ ATM ಬಿಸಾಕಿದ್ರಂತಲ್ಲ ದೊಡ್ಡ ಮೋರಿಯಲ್ಲಿ. ಮೊಬೈಲು ರಿಕವರಿ ಆಗಿಲ್ಲ, ಮೊಬೈಲು ATM ಎರಡೂ. ಮತ್ತೆ ಏನ್ ರಿಕವರಿ ಮಾಡಿದ್ರಿ ನೀವು? ಇದು ಏನು 41 ಆಯ್ತು, ಏನ್ ರಿಕವರಿ? ಕಲ್ಲ ಸ್ಪಾಟ್ ಅಲ್ಲೇ ಇತ್ತು. ಈಗ ಸ್ಟೈನ್ ಕ್ಲಾತ್ ಇಲ್ಲ. ಆಮೇಲೆ ರಿಕವರಿ ಆಫ್ ಸ್ಟೋನ್ ಆಲ್ಸೋ ಅಟ್ ದಿ ಸ್ಪಾಟ್. ವಾಟ್ ಈಸ್ ದಿ ಕನೆಕ್ಟಿಂಗ್ ಮೆಟೀರಿಯಲ್ ಗೊತ್ತಾ? ಎಕ್ಸೆಪ್ಟ್ ದಿ CW2 ಸ್ಟೇಟ್ಮೆಂಟ್. CW2 ಸ್ಟೇಟ್ಮೆಂಟ್ ಯಾರನ್ನ? ಬೇರೆ ವೆಹಿಕಲ್ ಅದೇನೆ. ತೊಳಿ ಮೇಡಮ್. Or the petitioner counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution is that petitioner was well in love with CW7 and the deceased, who is the husband of CW1, took the CW7 to Murudeshwara and other places. The A1 comes to know of this. He had he was having an ill will against the deceased and decided to eliminate the deceased. Why? On 19/11/2020, the husband of CW1, that is victim, went to drop company employees since he was working as driver. And while returning, accused number 1 to 5 kidnapped the deceased, or the accused number 5. Taken to the room of the accused number 2 and wrongfully confined him. That on 20/11/2020 at around 9 a.m., accused number 1 to 3 with the common intention took near Chandramohana Reddy quarry situated near the nice in survey number 55. Instructions of accused number 2 held him. Number 3 close to the eyes and mouth of the victim, tied him with a rope. And accused number 1 took out the stone which is lying at the spot, with the stone on his head, and when he tried to escape from the said blow, accused number 2 he also again took out the beer bottle which was lying at the spot, and again accused number 1 that the stone at the spot assault, and also dropped a big stone on his head. committed the murder. The accused number 1 also destroyed his blood-stained cloth, setting the fire on the same. And the mobile belongs to the deceased, and also the ATM card was also thrown in the drainage. Thereafter, as per the instructions of accused number 1, accused number 2 and 4 have changed plate of the vehicle belongs to the deceased. The counsel of petitioner submitted that the investigation has already been completed and charge sheet is filed, and this petitioner is in custody. And accused number 1, accused number 2, 4 and 5, 3 and 5. 2, 3 and 5 have been enlarged on bail by the trial court. And the similar allegation is made against this petitioner also, that he inflicted injury with a stone. And also the allegation against accused number 3 also is same. And hence the petitioner is also entitled for bail on the ground of parity. The counsel also submits that the prosecution is mainly relying upon the statement of one witness CW to the eyewitness, but his statement is recorded on (23/11/2020), and incident was taken place on 20/11/2020 within 3 days. 18 ಅಲ್ರಿ 20ಕ್ಕೆ ನಡೆದಿರೋದು. ಅದೇ ನನಗೆ ಬರ್ದಿದ್ದಲ್ಲ, ಅದೇನೆ 19ಕ್ಕೆ ಅವನ್ನ ಕಿಡ್ನಾಪ್ ಮಾಡ್ಕೊಂಡು ತಗೊಂಡೋಗಿ ಅಕ್ಯೂಸ್ ನಂಬರ್ 2 ರೂಮ್ ಅಲ್ಲಿ ಇಟ್ಕೊಳ್ತಾರೆ. ಮಾರನೇ ದಿನ ಬೆಳಗ್ಗೆ 20ನೇ ತಾರೀಕು ಕರ್ಕೊಂಡು ವಿತಿನ್ 3 days. ಆಯ್ತು ನೋಡಿ.
Statement is recorded on
23/11/2020. And prosecution also relies upon the statement of other witnesses. ಅವರು ಐ ವಿಟ್ನೆಸ್ ಅಂತ ಹೇಳ್ತಾರೆ. ಏನು ಯಾರ್ಯಾರು ಐ ವಿಟ್ನೆಸ್? ಅದೇ 7 ಇಲ್ಲ, 7 ಅವಳು ಅವನ ಜೊತೆ ಅವಳಿಂದಲೇ ಆಗಿದ್ದು ಅಂತ ಇದೆಲ್ಲ. ಅವಳು ಐ ವಿಟ್ನೆಸ್ ಅಲ್ಲ. CW6 CW2 and 6 according to the prosecution eye witnesses, and CW6 also witnessed the incident. Under this alleged claim of the prosecution that CW2 and 6 are the eye witnesses cannot be believed, and only after thought the statements of these 2 witnesses. Yes, it is a fit case to exercise the powers of 439 of CRPC. Per contra, the counsel appearing for the state would submit that the motive for committing the murder, that the victim girlfriend of accused number 1 different places, and there is a strong motive. And apart from that, CW2 and 6 have witnessed the incident. Eyewitness alva. Accused only ಇವನು ಒಬ್ಬನೇನಾ? ಒಬ್ಬನೇ ತಗೊಂಡೋಗಿದ್ದ ಅಥವಾ ಬೇರೆ ಎಲ್ಲ ಸೇರಿ ತಗೊಂಡು? ಕೇಸ್ ಆಫ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಇವರೆಲ್ಲರೂ ಸೇರಿ ಅವನನ್ನ ತಡೆ ಹಿಡಿದು ಆಮೇಲೆ ಕರ್ಕೊಂಡು ಹೋದ್ರು ಅಂತಾನೆ ನಿಮ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಕೇಸ್. ಮತ್ ನಿಮ್ದು ಹೇಳಿ ಆ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹೆಂಗ? ಲಾಸ್ಟ್ ಸೀನ್ ವಿಟ್ನೆಸ್ ನಿಮ್ ಪ್ರಕಾರ ನೀವು ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳ್ರಿ. ಐ ವಿಟ್ನೆಸ್ ಲಾಸ್ಟ್ ಸೀನ್ ವಿಟ್ನೆಸ್. ಬೆಳಗಿನ ಬಿಟ್ಬಿಟ್ರೆ ಹಿಂದಿನ ದಿವಸ ಅವ್ನು ತಗೊಂಡೋಗಿದ್ದ. ಹೌದಾ? ಯಾರು ನೋಡಿದ್ರು ಅದನ್ನ? 2 ಮಾತ್ರನಾ? 6 half boiled food ಇದು. ಎಲ್ಲಿದೆ ಹೋಗ್ಲಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ನ ತೋರಿಸಿ ಏನ್ ಮಾಡೋದು ನಿಮ್ಮ ಅಸಿಸ್ಟೆಂಟ್ ನಮ್ಗೆ ಸಿಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನಾವೇ ಓದ್ಕೋಬೇಕು. CW2 and 6 ಸ್ಟೇಟ್ಮೆಂಟ್ ಎಲ್ಲಿದೆ ರೀ? 41 ಕೋರ್ಟಿಗೆ ಪ್ರೆಸೆಂಟ್ ಮಾಡುವಾಗ ಪರ್ಫೆಕ್ಟ್ ಆಗಿ ಹೇಳ್ಬೇಕು ಏನು ಅಂತ. 41 ನಾನ್ 90 ಕೇಸನ್ನು ಪೂರ್ತಿ ಎಲ್ಲಾ ಸ್ಟೇಟ್ಮೆಂಟ್ ಓದಕ್ ಆಗಲ್ರಿ. ಧರ್ಮಾಧಿಕಾರಿನಾ? ಇವ್ರು ವಾಚ್ಮನ್ ಅಲ್ವೇ? ಡ್ರಾಪ್ ಮಾಡಲ್ ಹೋಗಿದ್ದ ಅಂತ ಅವ್ನು ಹೇಳ್ತಾನೆ. ಬಿಟ್ರೆ ಬೈಯಪ್ಪನಹಳ್ಳಿ ಮೆಟ್ರೋ ಸ್ಟೇಷನ್ ಹತ್ತಿರ ಬಂದಾಗ ಯಾರು 4 ಜನ ಅಪರಿಚಿತರು ವಾಹನವನ್ನು ನಿಲ್ಲಿಸಿದರು. ರವಿಕುಮಾರ್ ಅವರು ವಾಹನವನ್ನು ನಿಲ್ಲಿಸಿದಾಗ ಅದರಲ್ಲೊಬ್ಬ ಆಸಾಮಿ ಬಂದು ರವಿಕುಮಾರ್ ಅವರ ಮೊಬೈಲ್ ಫೋನ್ ಅನ್ನು ಕಿತ್ಕೊಂಡ. ಕೆಳಗೆ ಇಳಿಸಿ ಚಾಲಕನ ಕಡೆ ಪಾರ್ಟಿಷನ್ ಮಾಡಿದ್ದರಿಂದ ಒಳಗಡೆ ಹೋಗಲು ಆಗುವುದಿಲ್ಲವೆಂದು ಮತ್ತೊಂದು ಡೋರ್ ಬಳಿ ಬಂದು ನನ್ನನ್ನು ಇಳಿಸಿ ರವಿಕುಮಾರ್ ಅವರನ್ನು ವಾಹನದ ಒಳಗೆ ಕರೆದುಕೊಂಡು ನನ್ನನ್ನು ದಾರಿಯಲ್ಲಿ ಬಿಟ್ಟು 4 ಜನರಲ್ಲಿ ಒಬ್ಬ ಆಸಾಮಿ ವಾಹನವನ್ನು ಚಾಲನೆ ಮಾಡಿಕೊಂಡು ಹೊರಟೋದಂತ. ಹಿ ವಾಸ್ ಆಲ್ಸೋ ದೇರ್ ಅಲಾಂಗ್ ವಿತ್ ದಿ ವೆಹಿಕಲ್ ಅಂತ. ನಾನು ಕರೆ ಮಾಡಿ ನಿರ್ಮಲ್ ಅವರಿಗೆ ತಿಳಿಸಿದೆ. ಇದು ನಾನು ಡೀಟೇಲ್ಸ್ ಕೇಳಿದ್ ನಿನ್ನೆ. ನೋಡಿ, TT ವಾಹನವನ್ನು ಅಪಹರಿಸಿಕೊಂಡು ಹೋದವರನ್ನು ನಾನು ಗುರುತಿಸುತ್ತೇನೆ ಅಂತಿದ್ದೆ. ಟೆಸ್ಟ್ ಐಡೆಂಟಿಫಿಕೇಶನ್ ಪೀರಿಯಡ್ ಆಗಿದೆಯಾ? ಇನ್ನೊಬ್ಬ ಯಾರ ಇದ್ದಾನಲ್ಲ, ಅವನ ಯಾರು? CW ಇನ್ನೊಂದು ಸ್ಟೇಟ್ಮೆಂಟ್ ಇದೆ. CW ಇವಂದೇನೆ ಪೇಜ್ ನಂಬರ್ 104 ಅಲ್ಲ, ಅವಂದೇನಾ? 2 ಅವಂದೇನಾ ಸ್ಟೇಟ್ಮೆಂಟ್? ಫರ್ದರ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ನಿರ್ಮಲ್ ಅವರು ತಿಳಿಸಿ ಸರಮಾನದಲ್ಲಿ ವಾಪಸ್ ಕಂಪನಿಗೆ ಬಂದೇನು, ರವಿಕುಮಾರ್ ಕರ್ಕೊಂಡು ಹೋಗಿ ಅಷ್ಟೇ. ಇನ್ನೊಂದಿದೆ ಫರ್ದರ್ ಸ್ಟೇಟ್ಮೆಂಟ್, ಅದೇನೇ. ಒಂದು TI ಪೀರಿಯಡ್ ಇಲ್ಲ, ಮೊಬೈಲ್ ಇಲ್ಲ, ಮೊಬೈಲ್ ರಿಕವರಿ ಇಲ್ಲ, ಏನಿಲ್ಲ. ತೊಳಿ ಮೇಡಮ್.
Apart from that, CW2 to 6 have witnessed the incident.
CW2 and 6 have witnessed the incident of taking the deceased. The vehicle belongs to the deceased itself on the previous day, that is on 19/11/2020. And the CW2 also immediately informed the officers of the company in which the deceased is working as driver. Hence, there is a prima facie material against the petitioner, the respective counsel, and also on perusal of material. Main claim of the prosecution is that the CW2 witnessed the incident of taking the victim by unknown persons, 5 persons, unknown 4 to 5 persons. The prosecution mainly relies upon the statement of CW2. No test identification period is conducted. He has not identified the assailants. The counsel appearing for the state would submit that A1 phone location clearly discloses that where the murder was committed. The time of committing the murder, phone location discloses the presence of this petitioner. Also, the case that a mobile and ATM card of the deceased also thrown in a drainage, and the same is also not recovered. The case is rest upon the circumstantial evidence, no direct evidence. Only prosecution relies upon the CW2 evidence that he witnessed taking the deceased by unknown persons, and in order to identification of those accused persons also material is not collected by the IO. Yavanri IO on mobile recovery ಮಾಡೋದಿಲ್ಲ, ಮೊಬೈಲ್ ರಿಕವರಿ ಮಾಡೋದಿಲ್ಲ, ATM ಕಾರ್ಡ್ ರಿಕವರಿ ಮಾಡೋದಿಲ್ಲ, ಟೆಸ್ಟ್ ಐಡೆಂಟಿಫಿಕೇಶನ್ ಮಾಡಿಸೋದಿಲ್ಲ. CW2 who witnessed this.
to identify those accused persons.
Accused persons, and when the case is rested upon the circumstantial evidence, when there is no eyewitnesses to the committing of the murder on 23/11/2020, the bail granted in favor of accused number already by the to exercise the powers in 439 of CRPC conditions. ಏನ ಸೈಟೇಷನ್ಸ್ ಕೊಡ್ತೀನಿ ಅಂದ್ರೆ ಏನದು ಕೊಡಿ. ನೆನ್ನೆ ಕೊಟ್ಟಿದ್ದ. ಆಯ್ತು. ಉದಯ ಕೇಸು ಆಯ್ತು. ಅದು ಉದಯ ಕೇಸಲ್ಲಿ ಇಟ್ ಅಟ್ರಾಕ್ಟ್ ಆಗೋದಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು. ಆಯ್ತು. ನೆಕ್ಸ್ಟ್ 2011 2021 ಹೇಳ್ತೀನಿ ನಿಮ್ಗೆ ಈಗ ಹೊಸದು ಹೇಳಿ. 31
responded developed friendship with Kapalan and he assured that he would marry her. He had then stated that he was exploited physically for 1.5 years. And the second respondent had also spoken to the parents and sisters of Kapalan. And he stated that the father of the Kapalan had informed the arranged marriage of Kapalan. Made a phone call to the second respondent. The second respondent has been there to proceed to Jhansi, but on the basis of their rights were informed that the appellant does not wish to marry them. The appellant father also stated that the appellant did not marry them. Asked her to take some money and leave them. The FIR further records that the second respondent was assaulted. Throughout, the statement of the second respondent was recorded 64. The said statement is extracted. Then you are the argument that paragraph 4, paragraph 7 is being on the basis of the rival submissions and with assistance of the counsel, we have reviewed the FIR. The FIR specifically reports that the second respondent had developed a friendship with the appellant. He assured that he would marry her. The FIR then reports that the appellant and the second respondent developed physical relationship for a period of 1.5 years. The respondent conversed with the parents and the sisters of the appellant. That is in the FIR that the parents of the appellant were agreeable to the couple getting married. As a matter of fact, the appellant returned to his hometown and he asked when he had made a phone call to the on traveling to Jhansi at the behest of the second respondent with the father. And it got this attendance of the statement under 160 that the second respondent voluntarily developed relationship of husband and wife. The second respondent has stated that no one being family member are refusing to marry with him. The second respondent has stated that my soul remains in that soul will be but then the distillation, the FIR has been specified at Karnataka. Contents of the FIR that was the statement under section 164 of CRPC, no manner doubt on the basis of the allegation as it stands. 3 important elements. The relationship between the appellant and second the relationship for about a period of 1.5 years. Subsequently, he had expressed disinclination to marry the second respondent, which led to the registration of the FIR. That the earlier judgment has been impaired.
That is the ratio. That is the ratio.
Yes.
That is the ratio.
Yes. Bearing in mind that test which was enunciated. That even allegations in the FIR are correct, the purpose of offense has been established. There is no allegation to the effect that the promise to marry the second respondent was false assumption. On the contrary, it would appear from the contents of the FIR. The second respondent will give rise to registration. All these facts we are giving up to you. The High Court was ever in decline to intervene on the basis of which was only the evidence at trial, which would have better then it was related on the Supreme Court. But relying on this judgment, all the High Court has granted case 35.
Here also, what is the conclusion by the Supreme Court? There was no offense. There was no any offense. And also comes to the conclusion that there is no allegation to the effect that promise to marry given to the second respondent was false at the inception. But here is a case. What is your case? Now they say that is the allegation. That is the allegation. How this principle is applicable to your case? But conclusion of the Supreme Court in this judgment, while invoking section 482, that there is no allegation to the effect that promise to marry given to the second respondent was false at the inception. Nim case alla. ನಿಮ್ ಕೇಸಲ್ಲಿ ಮದುವೆ ಮಾಡ್ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿ ನೀವು ಸೆಕ್ಸ್ ಮಾಡಿದ್ರಿ ಅಷ್ಟೇ ಅಲ್ಲ, ಚೆನ್ನೈಗೆ ಹೋದ್ರಿ, ಚೆನ್ನೈಯಿಂದಲೂ ಬಂದ್ರಿ, ಮತ್ತೆ ಎಲ್ಲ ಮಾಡ್ತಾ ಇದ್ರಿ ಅಂತಾನೆ ಅಲಿಗೇಷನ್ ನಿಮ್ ಮೇಲೆ. ಮತ್ತೆ ಆಯ್ತು ನೀವು ನೆನ್ನೆ ಹೇಳಿದ್ರಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಅಂತ. ಆಯ್ತು, ದಟ್ ಇಸ್ ಎ ಮ್ಯಾಟರ್ ಆಫ್ ಟ್ರಯಲ್. Bombay judgment is only a persuasive, not binding on this court. ಇನ್ಯಾವ್ದು ಜಡ್ಜ್ಮೆಂಟ್ ಏನಾರು ಇದೆಯಾ? ಆಯ್ತು, 35 ಹೇಳಿ. ಯಾವ್ದ್ರದ್ದು? ಬಾಂಬೆದ? ಬಾಂಬೆದ ಏನ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅವ್ರು ಏನ್ ಬರ್ದವ್ರು ಅದ್ ನೋಡ್ಕೊಂಡು ಅವ್ರು ಬರ್ದವ್ರು ಅಷ್ಟೇ. ಅಷ್ಟೇ. ಆಯ್ತು. ಅಲ್ಲಿ ಮ್ಯಾರೇಜ್ ಮದುವೆ ಮಾಡ್ಕೊಳ್ತೀನಿ ಅಂತ ಹೇಳಿ ಇತ್ತ ಇಲ್ಲ? ಆಯ್ತು, ಹೇಳಿ ಏನು ಹೇಳಿ ಏನು ಹೇಳಿದ್ರು? ಯಾವ ಪ್ಯಾರ? 38 ಪ್ಯಾರ ಯಾವ್ದು ಹೇಳಿ?
The complainant applicants were having relations with each other since thereafter the applicant proposed a complaint for marriage in the year 2016. It was also stated in the first information. So they brought in 2015. It had made a promise her to marry. Thereafter both of them stayed together in the residence of the company. It is alleged that the applicant promised to marry her. Thereafter had sexual relations with her, and our relations continued in January 2020. It is contained in the first information in the month of January. The complainant met with an accident, hence he went to her native place. The applicant was serving in the railway department. He used to visit the house of the complainant and used to have sexual relations with her. It also alleged that the applicant had given understanding to the parents of the complainant that he would marry the complainant after the marriage of his sister. It is also alleged that till 24/2021, the applicant was having sexual relations with the complainant. It also appears from the first information that the applicant had invited the parents of the complainant for certificate of marriage. Accordingly, the parents and relatives of the complainant had been seen, but his father refused to settle the marriage of the applicant to the complainant. Hence, the first information being notified. So, this is also the same that the High Court has relied on to promote the power which has also been. So, then kindly come to paragraph 12, page 41.
ಕೇಸ್ ಸೋನು ಕೇಸ್ ಅದೇ ಇದೆ, ಈ ಜಡ್ಜ್ಮೆಂಟ್ ಹೇಳಿದ್ರಲ್ಲ ಅದೇ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಕೇಸ್. ಆಯ್ತು.
Wherein the facts of the case similar to the facts of the present case. Also, the applicant and respondent can have a physical relationship for a long time. Because at least there in that the applicant had given a false promise of marriage. Hence, the respondent continued her physical relationship with him. Thereafter, he refused to marry. In the facts of the said case, the apex court has held that there was no material record established. False promise was given since inception. In the present case, also there are indications of false promise, but on the revision of the first information, the complainant and applicants they have there may be a promise to marry given by the applicant, but looking into the cannot mean that the applicant the complainant on the basis of false promise of marriage. Therefore, in the above case, here recorded both that given by the complaint for sexual relationship with the applicant to be based on the promise to marry. That is a consensual relationship. Therefore, applicant is entitled to a surveillance. Applicant is allowed to condition. I spoke to submission that your questions sitting in the consider this matter in the case.
ಆಯ್ತು, ಆಲ್ರೆಡಿ ನೆನ್ನೆ ಓದಿದ್ದೀರಿ, ಮತ್ತೆ ಡೋಂಟ್ ವೇಸ್ಟ್ ದಿ ಟೈಮ್, ಡೋಂಟ್ ವೇಸ್ಟ್ ದಿ ಟೈಮ್.
This is the reading of the complaint that it shows that they were in relationship from 2019.
You go to page 24. You go to page 24 of your complaint.
Yes. But page 19 or
19 ಇಂದ 24 ಹೋಗ್ರಿ. 19 ಅದು ಟೈಪ್ಡ್ ಕಾಪಿ, 24 ಗೆ ಹೋಗಿ. ಏನು ಫಸ್ಟ್ ಪ್ಯಾರಾ ಓದಿ ಗೊತ್ತಾಗ್ತದೆ.
yes.
Is it a consensual sex or by force? ರೂಮ್ ಖಾಲಿ ಮಾಡ್ತೀನಿ, ನಾನು ಚೆನ್ನೈಗೆ ಹೋಗ್ತೀನಿ ಬಾ ಅಂತ ಹೇಳಿ ಕರ್ಸ್ಕೊಬಿಟ್ಟು ರೂಮಿಗೆ, ಅದೇ ದಿನ ಮನೆಗೆ ಹೋಗೋದು ಬೇಡ, ಇವಾಗ ರಾತ್ರಿ ಆಗ್ತದೆ ಹೇಳಿರ್ತಾರೆ. ನಂತರ ಅದೇ ರಾತ್ರಿ ದೈಹಿಕವಾಗಿ ಬಳಸಿಕೊಳ್ಳಲು ಬಲವಂತ ಮಾಡಿರ್ತಾರೆ. ನಾನು ದೈಹಿಕ ಸಂಪರ್ಕವನ್ನು ಮದುವೆಯಾದ ಮಾಡಿಕೊಳ್ಳೋಣ ಭರತ್ಕುಮಾರ್ ಅವರು ನನ್ನ ಜೊತೆ ಸದರಿ ರೂಮ್ ನಲ್ಲಿ ಬಲವಂತವಾಗಿ ನನ್ನ ಇಷ್ಟಕ್ಕೆ ವಿರುದ್ಧವಾಗಿ ನನ್ನ ಜೊತೆ ಸದರಿ ರೂಮ್ ನಲ್ಲಿ ದೈಹಿಕ ಸಂಪರ್ಕ ಬೆಳೆಸಿರುತ್ತಾರೆ. ನಂತರ ನಾನು ನಿನ್ನನ್ನೇ ಮದುವೆ ಮಾಡಿಕೊಳ್ಳುತ್ತೇನೆ ಅಂತ ಹೇಳಿ ರೂಮ್ ಖಾಲಿ ಮಾಡಿ ಚೆನ್ನೈಗೆ ಕೆಲಸ ನಿಮಿತ್ತ ಹೋಗಿರುತ್ತಾರೆ. ಹೌದು, 19 only. 19 ಅದೇ ರೀ, ನಿಮ್ಮ ಮ್ಯಾನ್ಸ್ಕ್ರಿಪ್ಟ್ ಅಲ್ಲಿ ಇದೆ, ಅದನ್ನೇ ನೀವು ಟೈಪ್ ಮಾಡಿ ಹಾಕಿದಿರಿ ಹೇಳಿ. ಆಯ್ತು, ಆಮೇಲೆ ಆಯ್ತು, ಅದೆಲ್ಲ ಆಯ್ತು. ಆಮೇಲೆ ಡಿಫ್ರೆಂಟ್ ಪ್ಲೇಸಸ್ಗೆಲ್ಲ ಹೋದ್ರು. ಹೌದು, ಡಿಫ್ರೆಂಟ್ ಪ್ಲೇಸಸ್ ಕರ್ಕೊಂಡು ಹೋಗಿದ್ದಾನೆ ಅಂತ. ಆಯ್ತು, ದಟ್ಸ್ ಆಲ್. ತೊಗೊಳ್ಳಿ. ಆರ್ಡರ್ ದಿ ಪಿಟಿಷನರ್ ಕೌನ್ಸಿಲ್ ಅಂಡ್ ಆಲ್ಸೋ ದಿ ಕೌನ್ಸಿಲ್ ಅಪಿಯರಿಂಗ್ ಫಾರ್ ದ ಸ್ಟೇಟ್. 438 ಎರಡೆರಡು ದಿವಸ ಗಂಟೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಕೇಳ್ಬೇಕು ಕೌನ್ಸಿಲ್. ಮತ್ತೆ ಆಯ್ತು ಆಯ್ತು. ಆಯ್ತು. ಆಯ್ತು ಆಯ್ತು. It depends upon the facts of each case. Ratio is applicable, depends upon the facts of each case. That's all. ಆಯ್ತು ಆಯ್ತು. ಐಡೆಂಟಿಕಲ್ ಅಂತ ನೀವು ಹೇಳಿದಿರಿ ಐಡೆಂಟಿಕಲ್ ಅಂತ ನೋಡೋಣ. ವಿಲ್ ಸಿ. ಎಲ್ಲರೂ ಹೆಂಗ್ ಮ್ಯಾನೆ ರೀ? ಎಲ್ಲರೂ ಹೆಂಗ್ ಮ್ಯಾನ? 438 ಯಾವಾಗ ಎಕ್ಸರ್ಸೈಸ್ ಮಾಡುತ್ತೆ ಅದಿದ್ದಾಗ ಮಾತ್ರ.
Now you are see in that you are 25 years old, you are according to that. Now secondly, there is a delay filing a complaint of more than years.
Right.
So 2019 and she files a complaint in the year 2022. And the allegations clearly shows that they had a bodily relationship on several occasions. At least there is a consensual sex. Therefore, that is not removed from that. Rape under section 376.
Right.
And 420 that promise to marry and breach of that promise. 420 will not come. What remains there? 5 or 9 or 6. So that will negate the allegations on the basis of the exercise the power of the court.
Yes, yes, ಹೇಳ್ರಿ ನಿಮ್ದೇನು.
Yes. Very has stated about the sequence of incident taking place in different places. Even the mental witness also, medical examination report also discloses contrary to the case of the petition. Still the investigation is under progress, and the investigation of the incident is required to investigate pertaining to the different place of Bangalore, Chennai. Reality of the offense, and now with regard to the unconventional sex, as addressed by Leonard Brent, since at the inception only at threat and inducement, there was a sexual intercourse made by the petitioner. After the first act being made under threat, subsequently any other alteration,
He gave consent anta.
the victim has been indulged with the petitioner. So considering the case on hand, the allegation made against the petitioner may under submission to this petition.
Heard the petitioner counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution based on the complaint of victim stated that both the petitioner as well as victim are working in the same company from June 2019. The petitioner proposed her in the month of February 2020 when he called her to Korean Mall. And hence the victim replied that she belongs to Veerashaiva community and petitioner belongs to Vakiliga community, and family members will not agree for the marriage. However, she took time to give consent for love affair. It is specifically mentioned in the complaint that on February 15, 2020, found that he got the job at Chennai and he get the hence he called her to help her in vacating the room, and on that day he had forcible sexual intercourse with her. Even though he refused that, after the marriage only they can have the said relationship as against her wish in the said room. Forcibly he committed rape on her, and thereafter he promised that he would marry her and not to worry about the same. And after vacating the house, he went to Chennai. While coming to Bangalore, he informed her and called her and took her to different places, and both of them. So, in spite of he continued the said act and agreed to marry her. But even he had promised that even if the parents not agrees, he will take her to Maharashtra, marry her. And also he had promised and assured that he will not leave her. And in the month of January 26, they promised to come to their house to see parents along with her relatives. And they refused to for marriage and hence caused the life threat. Based on the complaint, police have registered the case and the matter is under investigation. The counsel appearing to the petitioner would vehemently contend that the said act was taken place in 2020. Complaint is given 2020 February of the specific not 19. This complaint is given 31/1/2022 after lapse of 2 years. Apart from that, it is a consensual sex, not the forcible sex, and also they were subjected to sex on different occasions and different places. And when such being the factual aspects, it will not attract section 376. Counsel also in support of his argument, he has relied upon judgment of the apex court reported in 2003 for Supreme Court cases 46 Uday versus State of Karnataka, where the apex court comes to the conclusion that it doesn't attract section 376 of IPC. At the most, it attracts section 417 of IPC. The counsel also relied upon the judgment of the Supreme Court reported in 2011 within bracket 14 SEC 475, wherein also the apex court discussed with regard to the offense under section 376 and 417, wherein found that a view is reasonably possible that prosecutrix had sex with appellant with her consent, and hence there was no offense under section 376. Because sex with a woman above 16 years of age with her consent is not rape. The counsel also relied upon the judgment reported in 2019-18 SEC 191. Dhruvaram, Muralidhar, Sonar versus State of Maharashtra and others, wherein also the apex court held the conscious decision of victim to be involved in sexual relationship with accused without pressure or misconception on part of accused, relationship not involving passive submission of victim, offense of rape not made out. Counsel also relied upon the judgment reported in 2021 SEC online SC 181 Sonu versus State of UP. Note of brought to the notice of this court, particularly paragraph number 3 and also 11 regarding factual aspects of the case and also the ratio, wherein in paragraph number 11, while exercising the powers under 482 of CRPC, the apex court held that no offense has been established. There is no allegation to the effect that promise to marry given to the second respondent was false at the inception. Hence, invoke section 482. The counsel also brought to notice of this court the judgment of the Bombay High Court, wherein in a identical case, the counsel would contend that referring the judgment of the apex court in Sonu case, the Bombay High Court allowed the petition under section 438 of CRPC. The counsel also brought to notice of this court the order passed by this court in Dharwad bench in criminal petition number 100391 of 2019, wherein in offense under section 376, this court granted bail in favor of the petitioner. In paragraph number 7 has held that the victim is aged about 24 years and the complainant also discloses that they were fair, and also it appears the said fact came to the knowledge of the family members and the family members also given consent for marriage and she was subjected to sexual intercourse. And thereafter he has turned hostile and hence discretion is exercised. Counter the counsel appealing for the state submits that the court has to look into the factual aspects of each case and also considering the ratio laid down by the apex court and also this court. The counsel would vehemently contend that in the it is very specific that committed the rape against her wish. That is 15 February 2020. And thereafter, he has promised her that he would marry her. And thereafter, also, both of them visited different places and have the sex. And apart, victim has narrated that circumstances she gave consent. That is, after committing the rape against her wish, to give a consent for sexual intercourse, she had promised, and only on the promise she was subjected to sexual act with this petitioner, and hence not a fit case to exercise the powers under section 413(8) of CRPC. Having heard the petitioner counsel and also the counsel appearing for the state, and also looking into the factual aspects of each case and also the ratio laid down in the judgments referred supra by the petitioner counsel, it is not in dispute that the principle laid down in the judgments referred supra is with regard to the of section 376 as well as section 417. Case before the trial, before this court, 438 of CRPC. And while invoking section 438, it is settled law that court has to look into the nature of offences as well as seriousness allegations made in the complaint. Coming to the contents of the complaint, particularly in paragraph number 2, in paragraph number 1 is the contents of the complaint that them are working in the same company, and this petitioner proposed her, and she took time. When the petitioner got the job at Chennai, he called her to his room to help her to vacate the room. And in paragraph number 2, specific allegation is made that on that day he had sexual intercourse against her will, against her wish, and forcible sexual act he has committed. And thereafter he had promised her to marry her, and also informed that he is going to Chennai. And after his visit to Chennai, also frequently he is calling and making phone call, and also whenever he used to come to Bangalore, he used to visit her and subjected her for sexual act and also taken her to different places. And thereafter he has turned hostile. When such being the factual aspects, when the specific allegation is made that he subjected her for sexual act against her wish, thereafter he had promised her he would marry, and continuously with that promise had sexual intercourse with her and subsequently turned hostile. The court has to take note of seriousness of allegations, and the allegations is also against him that he had sexual intercourse against her wish forcibly. And when such being the factual aspects, the principles laid down in the judgments referred supra is not applicable to the facts of the case on hand. The apex court also in the recent judgment in Sonu versus State of UP, while exercising the powers under section 482 of CRPC in paragraph number 11, comes to the conclusion that no offense has been established. And furthermore, an observation is made that there is no allegation to the effect that promise to marry given to the second respondent was false at the inception. But here is a case that specific allegation is made that he committed rape on her forcibly against her wish, and thereafter he had promised. And hence, whether it attracts section 376 or 417, it is a matter of trial, and hence it is not a fit case to exercise the powers under 438 of CRPC. You know the discussions made up, I pass the following order. Bail petition is rejected. Madhukar Deshpande. Henry Counsel. Last time you took time on the ground that unable to secure the correct address. Have you secured the correct address?
Yes, with security assistance, we are tracing the address. Melody is stated in
Waste time.
Also,
Petitioner counsel again seeks time to ascertain the correct address, and hence this matter after 2 weeks.
sure.
19. ಏನಿದೆ ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಯಾರು ಮೇಡಮ್ ಇದು? ಹಾ ಕೊಡಿ. ಹಾ having perused the explanation of District Judge Kalburgi dated right through letter dated 21/2/2022, an attempt is made to shift the allegation against the official. The perusal of the order sheet, perusal of the order sheet dated trial court sheet madam ಅದರಲ್ಲಿ ಕೊಡಿ ಆರ್ಡರ್ ಶೀಟ್ ಇನ್ನೊಂದು ಇದೆ ಕೊಡಿ. ಆರ್ಡರ್ ಶೀಟ್ dated 18/8/2020. Immediately after passing the order, the copy was the order was communicated to the trial court, and the PO himself perused the order. The order sheet, and in the order sheet he himself has noted that perused the order in criminal petition number 3002 of 2020, dated 24/7/2020, and also noted that A2 bail was rejected and dismissed, but tried to blame on the staff. But when the PO perused the order and noted that there was a direction, other order copy madam, that there was a direction by this court. ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದೀವಲ್ಲ ಆರ್ಡರ್.
Explanation from presiding officer.
ಮೊದಲು ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದೀವಲ್ಲ ಮೇಡಮ್, ಕಂಪ್ಲೀಟ್ ದಿ ಟ್ರಯಲ್ ವಿತ್ ಇನ್ ದಿ ಸ್ಟಿಪ್ಯುಲೇಟೆಡ್ ಟೈಮ್ ಅಂತ ಆರ್ಡರ್ ಕೊಡಿ 24/7/2020. ಹೌದಲ್ಲ? ಅದೇ ಇರ್ಬೇಕು ನೋಡಿ. 27 ಅಂತ ಇದೆ, 24/7 ಅದೇ 24/7/2020. Specific order is passed that trial judge shall dispose of the matter expeditiously within an outer limit of not more than 6 months from the date of receipt of a copy of this order. When the order was brought to the notice of the presiding officer on 18/8/2020, and when the official put up the same, and the presiding officer perused the order and even mentioned the date of the order, instead of taking the matter by the court, simply adjourn the matter and not taken any decision to comply with the order of this court. The explanation given by the presiding officer that the staff not brought to the notice of the court is incorrect, and he had the knowledge of the order, as well as he has noted in the order sheet that perused the order and also mentioned the date of the order passed by this court. And instead of, when the same is brought to the notice of this court, the presiding officer even not care the order passed by this court, and hence it amounts to as well as non-compliance of the order passed by the High Court. And hence, it is a fit case to initiate proceedings against the presiding officer. Registry is directed to place the order sheet as well as explanation given by the presiding officer before the Honorable Chief Justice, and get an order, call for explanation from the presiding officer to initiate the proceedings against him. And hence the explanation given by the presiding officer is not accepted. The official had put up the order passed by this court dated 2020, and on perusal of the order sheet also it is evident that the trial court also mentioned in the order that he has perused the order passed by this court, and hence the explanation given by the official is accepted and not requires any initiation of proceedings against the official, since the official put up brought to the notice of the court. Now we have given directions to complete the trial within 6 months. Last application merits only ground that trial has not been completed anta. Our explanation ನಿಮ್ಮೆಲ್ಲೂ ಹೇಳಿದ್ದಾರೆ ಏನಂತ ಅಂದ್ರೆ ಲಾಯರ್ ಒಂದ್ಸರಿ ಡೈರೆಕ್ಷನ್ ತಗೊಂಡ್ಮೇಲೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ 6 months ಅಲ್ಲಿ it is the duty of the advocate also bring you to the notice ಅಂತ. ಕೋರ್ಟ್ ನೋಟಿಸ್ ಇದೆ ಆದ್ರೂ you have also not insisted the court to fix the trial, but now you comes before the court that trial is not commenced anta. No, is it a ground? Already I have given direction, dispose of the matter. ಆಯ್ತು ಗ್ರೌಂಡ್ ಏನ್ರಿ ಈಗ ನಿಮ್ದು ಅದನ್ನೇ ಹೇಳ್ಬಿಡಿದ್ರಿ ಅಷ್ಟೇ ಸರ್ ತಗೊಳ್ಳಿ ಅಷ್ಟೇ ಗ್ರೌಂಡ್ ಅಲ್ಲ. heard the petitioner counsel and also the counsel appearing for the state. ಕಂಡೀಷನ್ ಏನ್ ಪ್ರಶ್ನೆ ಬರೋದೇ ಇಲ್ಲ. ದಿಸ್ ಆಲ್ರೆಡಿ ರಿಜೆಕ್ಟೆಡ್ ಯುವರ್ ಬೇಲ್ ಪಿಟಿಷನ್ ಆನ್ ಮೆರಿಟ್ಸ್. ಹೌದಾ? ಹೌದಲ್ಲ. ಆಮೇಲೆ ಡೈರೆಕ್ಷನ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಡೈರೆಕ್ಷನ್ಸ್ ನಾಟ್ ಕಂಪ್ಲೈಡ್. ನೌ ಐ ಹ್ಯಾವ್ ಇನಿಷಿಯೇಟೆಡ್ ದಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಗೇನ್ಸ್ಟ್ ದಿ ಪ್ರಿಸೈಡಿಂಗ್ ಆಫೀಸರ್, even though he had the knowledge, he has not cared to the order passed by this court. Let him face the consequence. Now what is the ground for granting of bail? Held ಅಲ್ಲ ರೀ, ನಿಮ್ ನಾಲೆಡ್ಜ್ ಅಲ್ಲಿ ಇದೆ, ಡೈರೆಕ್ಷನ್ಸ್ ಕೊಟ್ಟಿದೆ ಅನ್ನೋದು ಗೊತ್ತು, ಅಲ್ಲಿ ಹೋಗಿ ಟ್ರಯಲ್ ಅಸಿಸ್ಟ್ ಮಾಡೋದಿಲ್ಲ ಕೋರ್ಟ್ಗೆ. And also you have not requested the trial court to fix the trial. Now you are coming before the court stating that the trial is not completed anta. That's what you are doing here. But it is not only duty on the presiding officer, it is also the duty of the advocate also to insist for fixing the trial. You are an officer of the court. But ಅವ್ರೇನ್ ಮಾಡಿಲ್ಲ, ಪುಟಪ್ ಆಗಿದೆ, ಕಾಪಿ ಹೋಗಿದೆ, ಎಲ್ಲ ಆಗಿದೆ. ನಮ್ ಪುಣ್ಯಾತ್ಮ ಜಡ್ಜು ಪೆರೂಸ್ಡ್ ಆರ್ಡರ್, ಡೇಟ್ ಎಲ್ಲ ಬರೆದ್ಬಿಟ್ಟು ಡೇಟ್. ಚಾನ್ಸ್ ಏನ್ ಹೇಳಿ, ನೀವು ಗ್ರೌಂಡ್ ಏನ್ ಹೇಳಿ, ಈಗ ನಂಗೆ ಅಷ್ಟೇ ಬೇಕು. Present petition is successive bail petition before this court. The counsel appearing for the petitioner vehemently contend that bail petition earlier filed was rejected in criminal petition number 3002 of 2020, and he was arrested on 22/10/2018, and he is undergoing hardship. Except the sweeping statement made by the alleged witnesses, there is no specific court act is attributed against the petitioner herein. He is in custody from 2.5 years, and no likelihood of trial being completed within short. 18 only ಬರ್ದಿರೋದು ನಾನು. And he is ready to willing to offer surety for his release. When the successive bail petition is filed before the court, the petitioner has to make out a case for changed circumstances. And admittedly, this court rejected the bail petition on merits in criminal petition number 3002 of 2020. And the direction was also given to the trial court to dispose of the matter expeditiously. And counsel, the trial has not been commenced. Commence agila. Trial has not been commenced and commenced even in spite of specific direction. And hence this court called the explanation from the PO, and the explanation also not accepted, since the PO was having the knowledge of the order passed by this court. This only on the ground that the trial has not been commenced is not a ground, unless the changed circumstances made out in a successive bail petition before this court. The council also would submit that accused number 5 and 7 have been enlarged on bail. And this court, while dismissing the application in paragraph number 10 and 11 and 12 also, to the conclusion that witnesses number 2 and 3 also attacked. The offense has been as such serious and that the petitioner had pre-planned along with other accused persons and dismissed the petition on merits. When such being the factual aspects, the very contention that trial has not been commenced and directed cannot be a ground. It is also the part of the counsel who appears on behalf of the petitioner also bring you to the court notice that there was a direction and also insist for fixing the date for trial, being the officer of the court, and the same is also not done. Same is also not done, and hence it is not a fit case to exercise the discretion under Section 439 of CRPC in a successive bail petition to discretion in favor of the petitioner. This court already time ಕೊಟ್ಟಿದ್ದೀವಲ್ಲ ಈಗ ಮೊನ್ನೆ ಆರ್ಡರ್ ಕೊಡಿ. ಹಾಗೆ ಬೇಲ್ ಪಿಟಿಷನ್ ಬಂದಾಗ ಇದು ಮಾಡಿದ್ರು ಬೇರೆದ್ರಲ್ಲಿ ಆದ್ರೂ ಆಗಬೇಡ. ಯು ಹ್ಯಾವ್ ದ ಡಿಸ್ಕಷನ್ಸ್ ಮೇಡ್ ಅಪ್ ಐ ಪಾಸ್ ದಿ ಫಾಲೋಯಿಂಗ್ ಆರ್ಡರ್. ಬೇಲ್ ಪಿಟಿಷನ್ ಇಸ್ ರಿಜೆಕ್ಟೆಡ್. ಇನ್ನೇನ್ ಲಿಬರ್ಟಿ ಬರ್ತದ್ರಿ? then ಲಿಬರ್ಟಿ ನಿಮ್ಗೆ ಇದ್ದಿದೆ, ನಾವೇನ್ ಲಿಬರ್ಟಿ ಕೊಡೋ ಅವಶ್ಯಕತೆ ಇಲ್ಲ. ಯು ಕ್ಯಾನ್ ಕಮ್ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್. 20 ಮೋಹನ್ ಕುಮಾರ್ ಡಿ.
For petitioner in this case, my
Yes,
lord,
madam.
I undertake to file NOC wakalat, my lord.
Undertake.
Yes, sir. Yes, my lord.
Have you received the NOC?
Yes, my lord. Yesterday we received the NOC wakalat, my lord.
What's your good name?
Dikshita, my lord.
Dikshita. Counsel Dikshita submits that yesterday she has received the NOC wakalat from earlier counsel. Undertakes to file wakalat within yesterday.
1 week, my lord.
In 1 week. And if wakalat is filed, show the name of the counsel. List this matter week after. Or wakalat hakade innu ಒಂದು ವಾರ ಅಂತ. Week after. 22 Hari Prasad MB. Non-compliance of office objection at check. ಏನಾಗಿದೆ ಇದರಲ್ಲಿ? ಏನೋ ಕಾಸ್ಟ್ ಹಾಕಿದ್ವಿ, ಕಾಸ್ಟ್ ಕಟ್ಟಿದಾರ? ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ ಡಿಸ್ಮಿಸ್ಡ್ ಇದಲ್ಲ, ರೆಸ್ಟೋರ್ ಆ ಕೇಸ್ ಇರ್ಬೇಕು, ಕಟ್ಟಿದಾರ? ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಆಫ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಟ್ ಸ್ಕ್ರೂಟಿನಿ ಸ್ಟೇಜ್ ಅಲ್ಲೇ ಇದೆ ಅದು. ಕಾಸ್ಟ್ ಪೇಯ್ಡ್. ಪಾಸ್ ಓವರ್ ಮಾಡಿ ಬಂದಿಲ್ಲ, ಮತ್ತೆ ಡಿಸ್ಮಿಸ್ ಮಾಡೋಣ ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ಗೆ. ಏನ್ರಿ SVP ನಾನ್ ಫರ್ನಿಶಿಂಗ್ ಆಫ್ ಕಾಪಿ. HCGP 6 3 days time to furnish the petition copy along with annexures. And if furnished, correct address ಕೇಳಿಲ್ಲ ಇಲ್ಲಿ ನೋಡಿ. And if furnished, issue notice against respondent. Or otherwise this matter on one date ಕೊಟ್ಬಿಡಿ. ಇಲ್ಲ ಸುಮ್ಮನೆ ಪ್ರೋಸೆಸ್ ಅಲ್ಲೇ 2-3 ವರ್ಷ ಇರ್ತದೆ. 14/3. 24 Robin Christopher.
Beg to appear for the petition.
Venkatesh ಹೇಳಿ.
Beg to appear for the petition.
Last time price time to file charge sheet. Have you filed the charge
My
sheet?
colleague is there, my lord, in the court. He'll furnish the
ಕಾಪೀಸ್ ಕೊಟ್ಟಿದ್ದೀರಾ ಅದರ್ ಸೈಡ್ಗೆ?
ಕೊಡಿ.
ಈ ಕೊಟ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕ್ರಿ? ತೊಗೊಳ್ಳಿ. Petitioner counsel now files the charge sheet before the court and also copy served on the. Let's list this matter week after next. 25 Pawan Kumar ji ಹೇಳ್ರಿ. ಹೇಳಿ. ಕೋಟಿಗೆ ನೀವೇನ ಪವನ್ ಕುಮಾರ್? ನೀವೇನ ಕೋಟಿಗೆ ಬರೋ ಅಭ್ಯಾಸ ಇಲ್ವಾ? 2 ಕೇಸ್ ಬಿಟ್ಬಿಟ್ರಿ, ಇದೇ ಕೇಸು ಡಿಸ್ಮಿಸಲ್ ಆರ್ಡರ್ ಬರ್ದಿದ್ದೀನಿ ನೋಡಿ, ಆರ್ಡರ್ ಶೀಟ್. ನಾಟ್ 2 ಕೇಸು, ಈ ಕೇಸನ್ನು ಆರ್ಡರ್ ನೋಡಿದೀರಾ? ಯಾವ್ದೋ ಬೇರೆ ಕೇಸ್ ಹಾಕಿ ಹೇಳ್ತೀನಿ, ಇದೇ ಕೇಸ್. ಆಯ್ತು ಹೇಳಿ, ಹೋಗಿ ಬಂದಿದಾರಲ್ಲ ಇವತ್ತು, ನಮ್ಮ ಅದೃಷ್ಟ. ಹೇಳಿ. ಅಫೆನ್ಸ್ ಏನು ಪೋಕ್ಸೋನಾ? ಹಾ, ಐಟಿ ಆಕ್ಟ್ ಆಲ್ಸೋ. ಏನ್ ಅಲಿಗೇಷನ್ ನಿಮ್ಮ ಮೇಲೆ? ಈಗ ಇನ್ನು ಕ್ರೈಮ್ ಸ್ಟೇಜ್. ಚಾರ್ಜ್ ಶೀಟ್ ಆಲ್ಸೋ ಫೈಲ್ಡ್. ವೇರ್ ಇಸ್ ದಿ ಕಾಲಮ್ ನಂಬರ್ 17? ಹಾ, ಓನ್ಲಿ ಅಸಾಲ್ಟ್ ಅಂಡ್ ವಿಡಿಯೋಗ್ರಾಫ್. ಸಾಕ್ಷಿ 1 ಮತ್ತು 3 ಅವರ ಮಗಳನ್ನು ಹೆಣ್ಣು ಕೇಳಲು ಬಂದಿದ್ದ ಸಾಕ್ಷಿ 1 ಮತ್ತು 3 ಅವರು ನಾವು ಇನ್ನೂ 5 ವರ್ಷಗಳ ಕಾಲ ಮದುವೆ ಮಾಡ್ತಾರೆ. ಇದಾದ 1 ವಾರದ ನಂತರ ಫೋನ್ ಮಾಡಿ ಮನೆಗೆ ಕರೆಸಿಕೊಂಡಿದ್ದು ಸಾಕ್ಷಿ 1, 2 ಮತ್ತು 3 ರವರು ಸಾಕ್ಷಿ ಮನೆಗೆ ಹೋಗಿದ್ದು ಸಾಕ್ಷಿ 6 ರವರ ಮನೆಯಲ್ಲಿ ಸಾಕ್ಷಿ ಸೋನ್ಸೋ ಏನು ವಿಚಾರ ಕೇಳಿದಾಗ ಸಾಕ್ಷಿರವರು ಮೊಬೈಲ್ ಪಡೆದುಕೊಂಡು 1, 2 ಮಗು ತೋರಿಸಿ ಈ ವಿಡಿಯೋದಲ್ಲಿರುವವರು ಯಾರು ಎಂದು ಕೇಳಿದಾಗ ವಿಡಿಯೋದಲ್ಲಿದ್ದ ಸಾಕ್ಷಿ ಮಗಳ ಮೇಲೆ ಅತ್ಯಾಚಾರವಾಗಿರುವ ವಿಡಿಯೋವನ್ನು ಸಾಕ್ಷಿ 1, 2, 3 ರವರುಗಳ ನೋಡಿ ತುಂಬಾ ಗಾಬರಿಯಾಗಿದ್ದು ಸಾಕ್ಷಿ 5 ರವರ ವಿಡಿಯೋವನ್ನು ಕಳಿಸಿ ಸಂಗೀತ ನಾನು ಅತ್ಯಾಚಾರ ಮಾಡಿದ್ದೇನೆ, ಅವಳನ್ನು ಮದುವೆಯಾಗಬೇಡ ಎಂದು ಹೇಳಿದ್ದೇನೆ ಎಂದು ವಿಚಾರ ತಿಳಿದಿರುವುದಾಗುತ್ತದೆ. ಆಯ್ತು, ಹೇಳಿ. ಕಮಿಟೆಡ್ ರೇಪ್ ಅಂಡ್ ವಿಡಿಯೋಗ್ರಾಫ್ಡ್ ಆಲ್ಸೋ. ವಾಟ್ ಈಸ್ ದ ರೇಟ್? Years. What is the medical evidence? Each and our advocate comes and says no injuries, sir. What ಬೇರೆ genital examination ಹೇಳ್ರಿ. Genital examination ಹೇಳ್ರಿ. ಹಾ 13, 20 ಕಮೆಂಟ್ಸ್ ಆಗೋದೆ 20 ಅಲ್ಲಿ. 30 ಆಯ್ತು. 30. ವಾಟ್ ಇಸ್ ದಿ ರಿಪೋರ್ಟ್? ರಪ್ಚರ್ಡ್. ವಾಟ್ ಇಸ್ ದಿ ಪ್ರಾವಿಷನಲ್ ಒಪಿನಿಯನ್? Final opinion. There also no opinion. Right. What is the 164 statement? Page number 3. What she says? Page number 2. ಏಕಾಏಕಿ ಸದ್ದಿಲ್ಲದೆ ಬಂದು ನನ್ನ ಮೇಲೆ ಮಲಗಿ ಬಾಯಿಯನ್ನು ಮುಚ್ಚಿ ಅಸಭ್ಯವಾಗಿ ನಡೆದುಕೊಂಡ. ನಾನು ತಡೆಯಲು ಕೈಯಿಂದ ತಳ್ಳಲು ಹೋದಾಗ ಹೊಡೆದ. ಕೈಯಲ್ಲಿ ನಾನು ಕಿರಿಚದಂತೆ ಬಾಯಿಯನ್ನು ಮುಚ್ಚಿ ನನ್ನೊಂದಿಗೆ ವಿಡಿಯೋ ಮಾಡಿಕೊಂಡ. ಯಾರಿಗಾದ್ರೂ ಹೇಳಿದರೆ ವಿಡಿಯೋವನ್ನು ಆನ್ಲೈನ್ ಕ್ಲಾಸ್ಗೆ ಹಾಗೂ ನನ್ನ ಸ್ನೇಹಿತರಿಗೆ ಕಳಿಸುವುದಾಗಿ ಬೆದರಿಸಿರುತ್ತಾನೆ. Yes, counsel, ಹೇಳ್ರಿ. Arguments, grounds ಹೇಳಿ.
No such, the first instance, no allegation was made. Was not informed to the parents as to who was sexually assaulted with the traditional parent in the first instance. Second submission, the Lord is in custody
5721. Yes, ಹೇಳ್ರಿ.
7 days. He has narrated the actual thing. Apart from that, the petition has videos of the act
Put it or only the threatened? Has he uploaded anywhere? Only he had videographed it. Whether that videographed is seized. Application is that he had videographed. ಅದನ್ನ ಸೀಸ್ ಮಾಡಿದಾರ ಇಲ್ಲ then ಮೊಬೈಲ್ ಸೀಸ್ ಮೊಬೈಲ್ ಆಫ್ ದಿ ಅಕ್ಯೂಸ್ಡ್ ಅದರ ಆಮೇಲೆ ಆಯ್ತು whether it is sent to the FSL or have you taken any truth lab report? FSL ಬಂದಿದೆಯಾ ಕಳಿಸಿದೀರಾ ಹೋಗ್ಲಿ ಕಳಿಸಿದಿರಿ ರಿಪೋರ್ಟ್ ಅವೈಟೆಡ್ ಅಷ್ಟೇನಾ ನಿಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್ ಅಷ್ಟೇನಾ ಆಯ್ತು or the petitioner counsel and also the counsel appearing to the state. The factual matters of the case of the prosecution is that this petitioner subjected the victim girl who is aged about 16 years, 8 months and 7 days for sexual act. And apart from subjecting her for sexual act, he also videographed the said incident and also went and showed the same to the charge sheet witnesses that he had already raped on her and also showed the pictures and caused the threat. He insisted from the marriage of the victim along with him, the life threat. And based on the complaint and police have investigated the file of the charge sheet, invoking the offences punishable under section 4614 of the POCSO Act, also under section 67B, A and B, 67B, B is capital, small a and B bracket. Still appearing for the petitioner would submit that the very alleged and in the set of parents were there and no allegation is made when the act was committed and also not complained about the said incident. Though medical examination report is that hymen is ruptured, but no provisional opinion is given by the counsel also submits that investigation already been completed and charge sheet is filed and no need of continuing him in custody since 5/7/2021 and hence he may be enlarged on bail. The counsel appearing for the state would submit that the age of the victim was 16 years 8 alleged act of against the minor girl. Apart from that, he subjected her for sexual act and also videographed the said incident. The mobile of the accused is also seized and the same is sent for FSL and FSL report is awaited. The counsel also submits that in 164 statement, victim girl categorically stated that this petition subjected her for sexual act and also videographed the same and also threatened that he would send the videograph to online class or to her friends cause the threat. And not only committed heinous offense and also threatened he would send the same to the online class as well as her friends. And apart from that, he went and showed the said act pictures to the witnesses. And hence it is not a fit case to exercise the discretion under 439 of CRPC. Having heard the respective counsel and also on perusal of material, the age of the victim is 16 years, 8 months, 7 days is not. The medical evidence also discloses that hymen was ruptured. And no doubt immediately after the incident, no complaint is given as contended by the petitioner counsel. And it is an offense against a minor child, which is defined under section 2D of POCSO Act. And apart from that, 164 statement of the victim recorded before the learned magistrate under section 164(5) of CRPC, wherein also she categorically reiterated that this petitioner subjected a videograph the said incident and also caused threat that he would send the same to the online class as well as her friends. Such being the materials available before the court, the very contention of the petitioner counsel that this petitioner is in custody from 5/7/2021 is not a ground when an heinous offense of subjecting the child for sexual act to enlarge him on bail. The other contention that investigation has been completed and charge sheet is filed and no need of custodial trial also cannot be a ground when the prima facie material is available against the petitioner, and apart from that, even the videographed picture videographed in the mobile of the petitioner was also seized, and the same is also seize ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ ಮೊಬೈಲ್ ಅನ್ನೇ ಸೀಜ್ ಮಾಡಿರೋದೇ ಹೇಳ್ತಾ ಇರೋದು. ಯಾರಿಗೆ ತೊಂದ್ರೆ? ನನಗೇನ್ ತೊಂದ್ರೆ ಇಲ್ಲ, ನಿಮಗೆ ತೊಂದ್ರೆ ಇಲ್ಲ ಮತ್ತೆ ಹೇಳಿ. ಮೊಬೈಲ್ ಸೀಸ್ ಮಾಡಿದ್ದಾರೆ, ಮೊಬೈಲ್ ಅಲ್ಲಿ ಅವನು ರೆಕಾರ್ಡ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾನೆ ಅಂತ ಅವ್ರ ಕೇಸು. ಆಯ್ತು, ಏನಾಯ್ತು ಮೇಡಮ್? ನಾನು ಕಂಪ್ಲೀಟ್ ಮಾಡೋವರೆಗೂ ಇರ್ರಿ ಸ್ವಲ್ಪ ಹೊತ್ತು. ಅದ್ ಯಾಕೆ ಹಂಗ ಆಡ್ತೀರಿ? ನಿಮ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಕೇಳಿದೀನಿ ಬಿಫೋರ್ ಕಮೆನ್ಸ್ಮೆಂಟ್ ಆಫ್ ಡಿಕ್ಟೇಟಿಂಗ್ ದಿ ಆರ್ಡರ್. ಇದೊಂದು ಕೆಟ್ಟ ಚಾಳಿ, ಡಿಕ್ಟೇಷನ್ ಕೊಡುವಾಗ ಬಾಯ್ ಹಾಕೋದು. ನಾನು ಕಂಪ್ಲೀಟ್ ಮಾಡೋವರೆಗೂ ಸುಮ್ಮನೆ ಇರಿ, ಆಮೇಲೆ ಏನಾರು ಇದ್ರೆ ಹೇಳಿ. ಆಯ್ತು, ಏನಾಯ್ತು ಮೇಡಮ್?
Apart from that, videograph in the mobile of the petitioner was also seized.
Apart from that, mobile of the petitioner was seized, and the same is also sent for FSL, and FSL report is also awaited. And hence it is not a fit case to exercise the powers of 439 of CRPC. Rajan Nasi. So last time we press time, the press time. ಏನ್ರಿ ಇದು SPP 399 402 ನಲ್ಲಿ ಏನ್ ಕ್ಯಾನ್ಸಲೇಷನ್ ಆಫ್ ಬೇಲ್? ಯಾರಿದು? ಸ್ಟೀಫನ್ ಸರುಡ್. ಅನ್ಸರ್ವ್ಡ್ ನೋಟಿಸ್ ಸರ್ವ್ ಆಗಿದೆ ಈಗ. ಸ್ಟೀಫನ್ ಸರ್ವ್ ಆಗಿದೆ, ಆಯ್ತು. ಮೆರಿಟ್ ಮೇಲೆ ಹೇಳಿ. ವಾಟ್ ಇಸ್ ದಿ ಗ್ರೌಂಡ್ ಫಾರ್ ಕ್ಯಾನ್ಸಲೇಷನ್ ಇನ್ ಎ ಕೇಸ್ ಆಫ್ ಪ್ರಿಪರೇಷನ್ ಆಫ್ ಕಮಿಟಿಂಗ್ ದಿ ಡಕಾಯ್ತಿನಲ್ಲಿ? ಗ್ರೌಂಡ್ ಏನ್ರಿ? ಗ್ರೌಂಡ್ಸ್ application of mind. ಆಮೇಲೆ apprehended readily while trying to commit ಡಕಾಯ್ತಿ. ಏನಾದ್ರು ಕ್ರಿಮಿನಲ್ ಆಂಟಿಸಿಡೆಂಟ್ಸ್ ಇದೆಯಾ? ಮೂರ್ ಗ್ರೌಂಡ್ ಇದೆ. In a case of an attempting to commit ಡಕಾಯ್ತಿ, you have approached this court for cancellation of bail. Dismissed with cost of rupees 1 lakh state ಗೆ. ಇದೆಯಾ ನಿಮ್ ಗ್ರೌಂಡ್ಸ್ ಏನಾರು ಇದೆಯಾ? Is there any grounds in the petition? Then why you have invoked section 439(2)? ಹೇಳಿ. Apprehended red-handedly while trying to commit ಡಕಾಯ್ತಿ. If the accused really released on bail, he may abscond and obstruct the proceedings of the trial court by not appearing before the trial court, and there are chances that he may indulge in similar other offences. ಏನ್ರಿ ಗ್ರೌಂಡ್ ಕ್ಯಾನ್ಸಲೇಷನ್ ಆಫ್ ಬೇಲ್ಗೆ 439(2) ನಲ್ಲಿ? In a casual manner you have approached the court and why you have filed this 439(2) in a case of attempting to commit ಡಕಾಯ್ತಿ ಕೇಸ್ ಅಲ್ಲಿ ಬೇಲ್ ಕೊಟ್ರೆ 439 ಅಲ್ಲಿ ಕೊಟ್ಟಿರೋದು ಅದನ್ನು. ಮತ್ತೆ ವಾಟ್ ಇಸ್ ದಿ ಎರರ್? ಎಲ್ಲಿದೆ ಕ್ರಿಮಿನಲ್ ಆಂಟಿಸಿಡೆಂಟ್ಸ್? ಏನು ಇಲ್ವೇ ಇಲ್ವಾ? ಇವನ್ ನಿಮ್ಮ ಪಿಟಿಷನ್ ಅಲ್ಲೂ ಕೂಡ ಇಲ್ಲ. ಮತ್ತೆ ಏನ್ ನೋ ಟೈಮ್ ತಗೊಳ್ಳಿ. ಡಿಸ್ಮಿಸ್ಡ್ ವಿತ್ ಕಾಸ್ಟ್ ಆಫ್ rupees 1 lakh. The council appearing to the state. The present petition is filed under Section 439 2 of CRPC for cancellation of bail. With order dated 13/10/2020, invoking the jurisdiction under Section 439 of CRPC for the alleged offences under Section 399 and 402 of IPC. The factual matters of the case of the prosecution is that the respondent Seven 2018 at about 8 p.m. was indulged in making preparation to commit the dacoity, holding deadly weapons in their hands by hatching plan near bushes of the said place, and by themselves and waiting for the people to come near there in order to rob them. And credible information apprehended them, and an inquiry they revealed that they are intending to rob the public. And hence crime number 158 of 2018 is registered and invoked offence under Section 399 and 402 of IPC. The respond number 1, 102 na, respond number 1. That is accused number 1 had approached by filing criminal misdemeanor number 567 of 2020. And the trial court allowed the bail petition invoking the jurisdiction of CRPC, and hence the petition is filed for cancellation of bail. Counsel appearing for the state would submit that the trial judge passed the impugned order without application of mind and caused miscarriage of justice. Offences alleged against them are serious against the society. The judge has committed grave error in observing that alleged offences are exclusively triable by learned magistrate. In view of granting of bail, the chances of absconding and obstructing the trial proceedings. And hence, bail requires to be cancelled. ಹೌದು. ಆಯ್ತು. ಆಯ್ತು. Before filing up.
At this stage, prima facie there are no sufficient materials to believe that with a lamp in his hand.
Right.
So when that being the case, those have not been.
I intend to impose cost of rupees 1 lakh. Now I will make it as 2 lakhs.
Those reasons.
The counsel appearing for the state also vehemently contend that the trial judge, while passing the order before filing the charge sheet, comes to a conclusion in paragraph number 10 that has not made out. Charge sheet ಆಗಿತ್ತೆ ಇಲ್ವಾ?
Incident took place in June.
Parade ಮಾಡಿದ್ರೆ ಇಲ್ಲ ಅವನು ಯಾವಾಗ ಮಾಡಿದ parade ಪ್ರಕಾರ ಜೂನ್ ಏನ್ ನಿಮಗೆ ಜೂನ್ ಇಂದ ಡಿಸೆಂಬರ್ ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಮಾಡಕ್ಕೆ once the accused is in custody. Now you are making submission that charge sheet was filed in the month of December. Arrest agide yavaga this respondent when he was arrested, under which provision you are having 6 months time to file the charge sheet. ಮತ್ತೆ ಹೇಳಿ ಯಾವಾಗ ಕೋರ್ಟ್ನವರು ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದಾರೆ ಅಂತ ಬರ್ದಿದ್ದಾರೆ. Where is the document to show that charge sheet was filed in the month of December? ದಾಖಲೆ ಎಲ್ಲಿದೆ? ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿರೋದು ನಿಮ್ ಪ್ರಕಾರ 30/12. ಎಲ್ಲಿದೆ ಅದು? ಕೇಸ್ ಆಫ್ an attempt to robbery 390 offense. ಎಲ್ಲ ಯಾರನ್ನ ಒಂದು 4 ದೊಡ್ಡ ಇದನ್ನು ಕೊಟ್ಟು ಕೇಸ್ ಹಾಕಿರೋ ಕೇಸ್ ಇದು. ಹೇಳಿ, ಅದು ಕ್ಯಾನ್ಸಲೇಷನ್ ಆಫ್ ಬೇಲಿಗೆ ಬಂದಿದ್ದೀರಿ ಕೋರ್ಟ್ಗೆ. No any antecedents. When the court has exercised the discretion and attempt to this court the charge sheet was December when the accused is in custody. Told how you have filed the charge sheet in the month of December when he was arrested in the month of June itself. You arrest ಆಗಿದ್ದೆ ಯಾವಾಗ್ರಿ? A1 ನೀವು ಬಂದಿರೋದೇ A1 ಕ್ಯಾನ್ಸಲೇಷನ್. ಹೌದಾ? ಅರೆಸ್ಟ್ ಆಗಿದೆ ಯಾವಾಗ ನಿಮ್ ಪ್ರಕಾರ? ಕಾರ್ಡ್ ರೆಡ್ ಹ್ಯಾಂಡೆಡ್ ಇದ್ರೆ ಯಾವಾಗಲ್ರಿ ಇದು? when he is even assuming that charge sheet was filed on 2018, whether this petitioner was in custody, he is entitled for default bail or not. Then why you have filed this petition on 439(2)? You give reasons. If charge sheet was filed on 2018, when he was arrested in the month of June, whether he is entitled for default bail or not. You are not answering to my question, counsel, whether he is entitled for 167(2) or not. Howda? Master, that's all.
And the charge sheet ಅಂತ ಹೇಳ್ತಾರೆ. ಅದು charge sheet ಫೈಲ್ ಆಗಿದೆ.
ಆಯ್ತು ನೋಡ್ರಿ, ಏನಾಯ್ತು ಮೇಡಮ್?
I put in paragraph number 10 concluding that the prosecution has not made out
Case against the respondent and alleged offences are exclusively triable by the learned magistrate and they are not punishable with death or imprisonment for life. The council also submits that even though the trial judge made an averment in the paragraph number 10 that the FIR, charge sheet and other is erroneous. The council also brought to the notice of this court that the charge sheet was filed on 2012-2018. First date of arrest ಹೇಳಿದೆ 7/8. ಆಯ್ತು, ಅವನು ಅರೆಸ್ಟ್ ಮಾಡಿದ ಡೇಟ್ ಯಾವತ್ತು? 7/8 ಆದ್ರೂ ಎಷ್ಟು ದಿವಸ ಆಯ್ತು ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಮಾಡಿ? ಆಯ್ತ್ರಿ, ನಾನ್ ಕೇಳ್ತಾ ಇರೋದು ನಿಮಗೆ. ಮತ್ತೆ ಹಾಕೊಂಡಿದ್ದಿ. ಕೌನ್ಸಿಲ್ ಆಲ್ಸೋ ಸಬ್ಮಿಟ್ಸ್ ದಟ್ ದ FIR was registered on 3/8/2000 7/8/2018. And order was passed on 13th day of October 2020 within a period of 3 months. Within a period of 45 days ಹೆಂಗಾಗುತ್ತೆ? ಡೇಟ್ 7/8 ಅಲ್ವಾ? 7/8 more than 2 months.
it was passed on 13/10/2020.
13th October 2020. FIR ಯಾವಾಗ? 7/8 ಅಂತಾರ.
18/2020.
7/8/2018 ಅಂತಾರ. 7ನೇ ತಾರೀಕಲ್ವೇನ್ರಿ? 7/8 13/10 ಎಷ್ಟು ದಿವಸ ಆಗುತ್ತೆ? 63 ದಿವಸ ಆಗುತ್ತೆ. 63 ದಿವಸ ಆಗುತ್ತೆ.
Year change ಆಗಿದೆ 2020 ಅಂತ.
2 ವರ್ಷ ಆಗಿದೆ. ಅಫೆನ್ಸ್ 18/20 ರೀ, ನೋಡ್ರಿ ಕರೆಕ್ಟ್ ಆಗಿ. FIR ಎಲ್ಲಿದೆ? ಹೋಗ್ಲಿ ತೋರಿಸಿ, ನಾನೇ ನೋಡ್ಕೊತೀನಿ. FIR 2018. 7/8/2018. This accused was arrested on what date? ಅವತ್ತೇನಾ? The order also passed in the month of 2020 ರೀ, after filing of charge sheet ಆಗಿ 20 after almost 2 years 2 months charge sheet ಆಗಿದೆ ಇಲ್ಲ ಮತ್ತೆ? ಲಾಸ್ಟ್ ಸೆಂಟೆನ್ಸ್ ಲಾಸ್ಟ್ ಆಗ್ತೀನಿ ಅಂದ ತಕ್ಷಣ ಅವ್ರು ಎಲ್ಲೆಲ್ಲೋ ಹೋದ್ರು. ನಮ್ಮನ್ನೇ ಅದಕ್ಕೆ ಈಗ ಒಂದು ಕಾಲೇಜಲ್ಲಿ ಪಾಠ ಮಾಡ್ತಾರಲ್ಲ, ಜಡ್ಜಿ ಕನ್ವಿನ್ಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಕನ್ಫ್ಯೂಸ್ ಮಾಡ್ಬೇಕು. ಈಗ ಎಲ್ಲಾ ಕಾಲೇಜಲ್ಲಿ ಅದಂತ ಹಂಗೆ ನೀವು ಏನಾರು ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಅಂತ ಕೋರ್ಟ್ಗೆ. ಆಯ್ತು, ಏನಾಯ್ತು?
The order was passed on 13/10/2020 within
ವಿತಿನ್ ಅಂತ ಬರೋದಿಲ್ಲ, ಅದೆಲ್ಲ ಹೋಯ್ತು. ಏನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಹೇಳಿದೆಲ್ಲ 13th day of October 2020. ಅದಕ್ಕೆ ಕೇಳಿದ್ರೆ ಅವ್ನು ಕಸ್ಟಡಿಯಲ್ಲಿ ಎಷ್ಟು ದಿವಸ ಇದ್ದ ಅಂತ ಕೇಳಿದ. ಅದಕ್ಕೆ ಅರೆಸ್ಟ್ ಯಾವಾಗ? 7-8 2.5 ವರ್ಷ ಜೈಲಲ್ಲಿ ಇದ್ದಾನೆ ಅವನು. 399 302 402ಗೆ ಅಫೆನ್ಸ್ 5 ಲಕ್ಷ ಹಾಕ್ಬೇಕಲ್ಲ ಕಾಸ್ಟ್ ಈಗ. ಏನ್ ಕ್ರಿಮಿನಲ್ ಆಂಟಿಸಿಡೆಂಟ್ಸ್ 5 ವರ್ಷದ ಮೇಲೆ ತಗೊಳೋದು ನೀವು? 4 ವರ್ಷದ ಮೇಲೆ ಏನಾಯ್ತ್ರಿ?
the order was passed on 13/10/2020.
13/10/2020 after almost 2 years 2 months of the alleged offense. The accused was in custody and ಇನ್ನು ಇದರಲ್ಲಿ ಅವ್ರನ್ನ ಆರ್ಗ್ಯುಮೆಂಟ್ ಬರೀತಾ ಇದ್ದಾನೆ. ಏನಾಯ್ತು? ಎಲ್ಲ ಹೋಯ್ತು ಅವ್ರ ಆರ್ಗ್ಯುಮೆಂಟ್. 439 for the state. And also looking into the factual aspects of the case, records reveals that crime number 158 of 2000 is registered for the offense punishment under 390 of IPC. Accused oblique respondent was also apprehended on the same date, and he was in custody for a period of months since the order was passed on 2020. And counsel appearing for the state would submit that charge sheet was filed on 2018. And the HCCP mistakenly argued sheet was filed. Passing of the order. During the crime stage, the bail was granted. Having taken note of the offense alleged against the respondent, only an allegation is that the offense under section 399 and 402 of IPC, and was in custody for a period of 2 years 2 months. And the present petition is filed invoking 439(2) of CRPC. Contention that in paragraph number 10, the trial court has an error in referring that the FIR as well as charge sheet is erroneous. Contention also accepted. Charge sheet admittedly filed on 2020. Okay. ಬೇರೆ ಕೇಸ್ ಯಾವ ಕೇಸ್ ಇಲ್ಲ. Nothing is averred in the petition that the respondent is having any criminal antecedents against the petitioner here. And now the counsel appearing for the state submits that presently respondent is in custody in view of the crime number ಯಾವ ಎಸಿ ಕೇಸ್ ಅಲ್ರಿ? ಯಾವ ಎಸಿ ಕೇಸ್ ಅದು? 2022 ಇದು. 2022 how you are going to connect this for cancellation of bail? Order was passed in 2020. ಏನ ಇವ್ರ ಮೇಲೆ ನಿಮ್ಮ ಏನೋ ಪೊಲೀಸ್ನವ್ರಿಗೆ ಹಾಗೆ ಇದ್ದಂಗಿದೆ ನೋಡಿ. ಮತ್ತೆ ಆಯ್ತ್ರಿ, ಈ ಕೇಸ್ ಯಾವಾಗ? 2022 ಆಯ್ತು ಇದು.
ಆ SC ಕೇಸಲ್ಲಿ ಇದು ಗುರುತು ಕೇಳಿದಾಗ ಅಲ್ಲೂ ಅರೆಸ್ಟ್ ಆಗಿದೆ.
ಇದೆಲ್ಲ ಆಯ್ತು ಬಿಡ್ರಿ. ಈಗ ನೀವು 399 ಅಫೆನ್ಸ್ 399 ನಾವು 402 ಏನ್ ಗ್ರೌಂಡ್ಸ್ ಹೇಳಿ ಆಯ್ತು. ನೀವು ಜಾಸ್ತಿ ಹೊತ್ತು ತಗೊಂಡಾದಂಗ ಕಾಸ್ಟ್ ಜಾಸ್ತಿ ಆಗ್ತಾ ಇರ್ತದೆ. ಹೇಳಿ. ಹಾ ಹೇಳಿ. ಐ ವಿಲ್ ಹಿಯರ್ ಯು. ಹಾ ಆಯ್ತು. ಏನಾಯ್ತು ಮೇಡಮ್?
Now the learned counsel for the state.
ಹ್ಮ್
Now the learned counsel for the state submits that presently the respondent is in custody.
ಇನ್ ಕಸ್ಟಡಿ ಯಾವ್ದ್ರಿ? ಕ್ರೈಮ್ ನಂಬರ್ ಯಾವ್ದ್ರಿ? ಹೋಗ್ಲಿ. ಯಾವ್ದ್ರಲ್ಲಿ ಅವ್ನಿಗೆ ಒಳಗ ಹಾಕಿದ್ರಿ ಹೇಳಿ. ಅಲ್ಲಿ ಬೇಲ್ ಕೊಟ್ರು ಅಂತ ಇಲ್ಲಿ ಯಾವ್ದನ್ನ ಒಂದು ಹಿಡ್ದಾಕಿರ್ತೀರಿ ಹೇಳಿ. ನೀವು ಮಾಡೋದೆಲ್ಲ ಇಂಥದ್ದೇ. ಹೇಳಿ. ಹಾ ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ ನಂಬರ್ 8672/21 ರಲ್ಲಿ ಅದೇನೋ ಬರ್ದಿದ್ರಿ ಇದ್ರಲ್ಲಿ ನಿವೇದನೆ. ಅದೇ ಈ ಕೇಸ್.
ಈ ಕೇಸಲ್ಲಿ ನೋಟಿಸ್ ಜಾರಿ ಮಾಡಕ್ ಹೋದಾಗ
ಈಗ ಜಾರಿ ಆಗಿದೆ ಬಿಡ್ರಿ. ಈಗ ನೀವು ಜಾರಿ ಆಗಿದೆ, ಕೋರ್ಟ್ ಮುಂದೆ ಬಂದಿದೆ ಅಷ್ಟೇ ಅಲ್ಲ. ಆಯ್ತು ಹೇಳಿ.
Crime number.
ಹಾ ನೋ ಕ್ರೈಮ್, ನಥಿಂಗ್. And in order to substantiate the same, nothing is placed on record. Having considered the material available on record, it is nothing but an abuse of court process. When the respondent was in custody for a period of 2 years, 2 months, for the offence punishable under section 399 and 402 of IPC, the petition for cancellation of bail, and the trial court also, while exercising the discretion under section 439 of CRPC, taken note of, he has taken to custody on the date of the incident itself. Also, records reveals that charge sheet was filed on 30/12/2018. And also formed an opinion that looking into the materials on record, no prima facie case is made out and there are no sufficient materials to believe that the accused has committed the alleged offences. Whether the allegations made against the accused is true or not has to be decided only after full-fledged trial. Hence, granted bail. Having considered the material on record and also looking into the factual aspects, the incident was taken place on 7/8/2018, and the accused was also in a custody for a period of 2 years, 2 months. Even after filing of charge sheet on 30/12/18, when the trial court has exercised the discretion and given the reasons in paragraph number 10, without any material before this court, invoke the offense under 430 offense alla. Invoke section 439(2) of CRPC, and hence it is a fit case to the petition with exemplary cast. 430 the provision under section 439(2) of CRPC has to be exercised sparingly, and in apex court in Dolaram case held that exercise of discretion granting bail is different from cancellation of bail invoking under 439(2) of CRPC. The trial court can only invoke section 439(2) of CRPC if the trial court not considered the material available on record. In the case on hand, the trial court considered the material after filing of charge sheet, and even the charge sheet was filed on 30/12/2018, and the discretion was exercised on 13/10/2020 and 20. And when such the case, an abuse of process by the state machinery by filing this under 439(2) of CRPC, and hence petition exemplary cost 3 lakhs.
We have filed a memo along with the report of having served the notice to the
ಆಯ್ತು ಒಳ್ಳೆದು. The notice the HCGP file HCGP ಯಾವಾಗ ಹಾಕಿದಿರಿ? HCGP has filed memo on 16/2/2022, having served the notice on the respondent, and respondent not appeared before this court personally or engaged any counsel. ಮತ್ ಇಲ್ಲ ಸರ್ಕಾರದಿಂದ ಕಾಸ್ಟ್ ಬಂದಿದ್ ಮತ್ ಸರ್ಕಾರಕ್ಕೆ ಹೋಗುತ್ತೆ. ಕಾಸ್ಟ್ ಹಾಕಿದ್ರು 2 ಲಕ್ಷ ಯಾವ್ದಾದ್ರು ಕೊಡೋಣ ಬೇರೆ. ಸರ್ಕಾರ ತಾನೇ ಕಟ್ಟೋದ್ ಕಾಸ್ಟ್. ಲೆಟ್ ಇಟ್ ಗೋ ಟು ಯಾವ್ದಾದ್ರು ಆಶ್ರಮನ, ಯಾವ್ದಾದ್ರು ಒಂದು ಬೆಗ್ಗರ್ಸ್ ಏನಾರು ಇದೆಯಾ ನೋಡಿ, ಯಾವ್ದಕ್ ಕೊಡ್ಬೋದು. ಇಲ್ಲಿ ಕೊಡೋಣ ಯಾವ್ದಾದ್ರು ಫಂಡ್. ಈಗ ಸರ್ವಿಸ್ ಅಥಾರಿಟಿದು ಅವರೇ ಕೊಡೋದು ದುಡ್ಡು. ಅದಕ್ಕೆ ಹೋಗ್ಬಾರ್ದು. ಆರ್ಫನೈಜ್ ಕೊಡೋದು ಬೆಸ್ಟ್. ಯಾವ್ದಾರು ಒಂದು ರಿಜಿಸ್ಟರ್ಡ್ ಯಾವ್ದಾರು ಆರ್ಫನೈಜ್ ಇದೆಯಾ ತೆಗೀರಿ ನೋಡ, ಅದು ಕೊಡೋಣ. ಏನ್ರಿ 3/4 ಗಂಟೆ ವೇಸ್ಟ್ ಮಾಡಿದಿರಿ 439 ಪಿಟಿಷನ್ ಅಲ್ಲಿ. ಇನ್ ಎ ಕೇಸ್ ಆಫ್ 399 402 ಅಫೆನ್ಸ್ ಅಲ್ಲಿ ಕ್ಯಾನ್ಸಲೇಷನ್ ಆಫ್ ಬೇಲಿಗೆ ಬಂದಿದ್ದೀರಿ. ಬೇಲ್ ಕೊಟ್ಟಿರೋದು 2.5 ವರ್ಷದ ಮೇಲೆ. ಐ ಡೋಂಟ್ ನೋ ಹೂ ಹ್ಯಾಸ್ ಡ್ರಾಫ್ಟೆಡ್ ದಿಸ್ ಪಿಟಿಷನ್ ಅಂಡ್ ಹೂ ರೆಕಮೆಂಡೆಡ್ ದಿಸ್ ಪಿಟಿಷನ್. ನಿಮ್ಮಲ್ಲಿ ಇದೆಯಲ್ಲ ಒಂದು ಒಪಿನಿಯನ್ ಇರುತ್ತೆ ಕ್ಯಾನ್ಸಲೇಷನ್ ಆಫ್ ಬೇಲಿಗೆ. ಅವ್ರು ಎಲ್ಲಾರ ಕಡೆಯಿಂದಲೂ ವಸೂಲಿ ಮಾಡ್ಬೇಕು. ಬರೀಲ್ಲ ಅದನ್ನ. Who recommended this case for filing a petition under section 439(2)? And also blindly accepted by SPP office to file this, including ನಿಮ್ಮ SPP ನ ಅಥವಾ ಯಾರು ಅಡ್ವೊಕೇಟ್ ಜನರಲ್ ಯಾರು ನೋಡೋದೇ ಇಲ್ವಾ ಯಾವ ಕೇಸಲ್ಲಿ ಹಾಕ್ಬೇಕು ಹಾಕೋದ್ ಬೇಡ ಅನ್ನೋದನ್ನ? ಇಂಥ ಕೇಸ್ ಇಟ್ಕೊಂಡು ನಾವು ಅರ್ಧ ಗಂಟೆ 3/4 ಗಂಟೆ ಆರ್ಡರ್ ಬರೀಬೇಕು. ಅದಕ್ಕೆಲ್ಲ ಬರೀ ಗೈಡ್ ಮಾಡೋದು ಎಲ್ಲ ಮಿಸ್ಗೈಡ್ ಕೋರ್ಟ್ ಮುಂದೆ. ಹರೀಶ್ ಪ್ರಭು ಯಾರಪ್ಪ ಲಾಸ್ಟ್ ಟೈಮ್ ಪ್ರೇಸ್ ಟೈಮ್ ಟು ಗೆಟ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಟು ವಿಡ್ರಾ ಇಲ್ವಾ? ಕೇಸ್ ವಿಡ್ರಾ ಮಾಡ್ಬೇಕು ಕಂಟಿನ್ಯೂ ಮಾಡ್ಬೇಕು ಅನ್ನೋಕೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್. ಇವತ್ತು ಅದಕ್ಕೂ ಇಲ್ಲ. 29 ಅರುಣ್ ಕುಮಾರ್, ಇದು ಅಷ್ಟೇ ಡಿಸ್ಮಿಸಲ್, ಯಾರಿಲ್ಲ, ಪಾಸ್ ಓವರ್ ಮಾಡಿ. 30 ಮೊಹಮ್ಮದ್ ಉಮರ್ ಫರೂಕ್, ಎಂಟೈರ್ ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಮಾಡಿದ್ರೇನ್ರಿ? ಹಾಕಿಲ್ಲ ಯಾಕೆ? ಡೇಟ್ ಬೇಕಾ? ಆಯ್ತು ತಗೊಳ್ಳಿ. Petitioner counsel in the previous occasion took time to file entire charge sheet. Until date, entire charge sheet is not filed, and again seeks time. This matter week after next. 31 H Maltesh, ಇದು ಅಷ್ಟೇ ಡಿಸ್ಮಿಸಲ್ ಗೆ ಅಂತಿದೆ. ಏನ್ರಿ ಇದು ಲಾಸ್ಟ್ ಟೈಮ್ ಬಂದಿಲ್ವಾ? ಓಕೆ, ಒಂದ್ಸರಿಗೆಲ್ಲ ಡಿಸ್ಮಿಸಲ್ ಆರ್ಡರ್ ಬರೆಯಲ್ವಲ್ಲ? ಆಯ್ತು ಹೇಳಿ, ಏನ್ ಅಫೆನ್ಸ್ ಏನು? ಪೋಕ್ಸೋ ಅಫೆನ್ಸ್ ಇದೆಯಾ? ಪೆನೆಟ್ರೇಟಿಂಗ್ ಅಫೆನ್ಸ್ ಏನಾರು ಇದೆಯಾ? ಓನ್ಲಿ ಅಫೆನ್ಸ್ ಏನು? 6 ಇದೆ. ಯಾರು? ಆಯ್ತು, CDPO. ಇನ್ನು ಕ್ರೈಮ್ ಸ್ಟೇಜ್ ಏನ್ರಿ? ಇನ್ನು ಕ್ರೈಮ್ ಸ್ಟೇಜ್ ಏನು? ಸೆಪ್ಟೆಂಬರ್ 21 ಹಾಕಿದಾರ ಏನು ಚಾರ್ಜ್ ಶೀಟ್? ಆಯ್ತು, ಎಲ್ಲರಾಗ್ಲಿ. ಅದು ಈಗ ಗೊತ್ತಿಲ್ಲ. ಮೆಡಿಕಲ್ ಎವಿಡೆನ್ಸ್ ಏನಿದೆ ನೋಡಿದೀರಾ? She has refused to undergo for medical examination. ಮತ್ತೇನ್ರಿ? When the victim herself is not interested in going for, but complaint only CDPO complaint. 164 statement. So CCP seeks time to secure the 164 statement. This matter ಯಾವಾಗ್ರಿ? ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಡೇಟ್ ನಾನು ಫಿಕ್ಸ್ ಮಾಡೋದಿಲ್ಲ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಹಾಕಿರ್ತೀನಿ. ಅವ್ರು ಎಷ್ಟು ತಗೋತಾರೋ ಅಷ್ಟು ತಗೊಳ್ಳಿ. 34 ಶಿವಪ್ರಸಾದ್, ಹೇಳಿ. ಮಹೇಶ್ ಕುಮಾರ್ ಈಗ A3 302 201 504 201 ಬಿಟ್ಬಿಡಿ. 302 ಅಟ್ರಾಕ್ಟ್ ಆಗ್ತದ? ಆಗಲ್ಲ. ಹೇಳಿ ಏನ್? ನಂಬರ್ 2 ಏನು ಗ್ರೌಂಡ್ ಏನು? ಅದೇ 201 ಅಟ್ರಾಕ್ಟ್ ಆಗುತ್ತೆ ಅಂತ After committing the murder, they assisted the real culprit in ಎಲ್ಲಿದೆ ಆರ್ಡರ್ ಕಾಪಿ ಕೊಡಿ. ಅದಕ್ಕೆ ಕೇಳಿದ್ ನಾನು 302 ಇದೆಯಾ 201 ಅಂತ ಕೊಡಿ. Only 213 helped. Against accused number 1 alleged to have committed the deceased in respect of sleeping in the goods vehicle belongs to this petition. Accused number 3 and this petitioner said to have shifted the dead body. Same ತಗೊಳ್ಳಿ ಮೇಡಮ್. ಏನ್ರಿ ಏನಾರು ಇದೆಯಾ? ದಿ ಆರ್ಡರ್ ನಲ್ಲಿ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 4 ಅಲ್ಲಿ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 6 ಅಲ್ಲಿ ಕಾಪಿ. Allegation is that accused number 3 and this petitioner said to have shifted the dead body. ಅಷ್ಟೇ. Committed murder. A1 ಯಾವ ರೀತಿ ಮರ್ಡರ್ ಮಾಡಿದ್ರಿ? Stone, which reveals that section 302 of IPC and section 201 of IPC attracts against this petitioner. ಏನ್ರಿ ಇದು? ಆರ್ಡರ್ ಕರೆಕ್ಷನ್ ಆಗಿಲ್ಲ ನೋಡಿ. Considering the documents on record, which reveals that section 302 of IPC and section 201 of IPC attracts against this petitioner. Charge sheet column 302 attract ಆಗುತ್ತೆ ಅಂದ್ರೆ ಏನು ಕೊಡೋದು? ಅದೇ ಹೇಳಿದ್ದು. ಚಾರ್ಜ್ ಶೀಟ್ ಕಾಪಿ ಇದೆಯಾ ಮೇಡಮ್? ಚಾರ್ಜ್ ಶೀಟ್ ಇದೆಯಾ? ಚಾರ್ಜ್ ಶೀಟ್ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ ಅವ್ರೆ? 30. ಅಲಿಗೇಷನ್ ಇಷ್ಟೇ ರೀ. ನಂತರ ಅಲ್ಲಿಯೇ ನಿಂತಿದ್ದ A2 ಮತ್ತು A3 ರವರು ಗಿರಿಯು ಮೃತಪಟ್ಟಿರುವ ಬಗ್ಗೆ ಖಾತರಿ ಪಡಿಸಿಕೊಂಡು ಅವನು ಸತ್ತೋದ ಅಂತ ಹೇಳಿ ಉದ್ದೇಶಿಸಿ, ಲೋ ಈತನನ್ನು ಇಲ್ಲಿಯೇ ಬಿಟ್ಟರೆ ನಮಗೂ ನಿನಗೂ ತೊಂದರೆ ಆಗ್ತದೆ, ಅದಕ್ಕಾಗಿ ಈತನನ್ನು ಗಾಡಿಯಲ್ಲಿ ಹಾಕಿಕೊಂಡು ಎಲ್ಲಿಯಾದ್ರೂ ಬಿಸಾಡಿ ಬರೋಣ ಎಂದು ತಿಳಿಸಿ ಒಂದು ಸಮಾನ ಉದ್ದೇಶ ಗೂಡ್ಸೆ ಆಪೆಯಲ್ಲಿ ತಗೊಂಡು ಹೋಗಿ ಬೈಕ್ ವಾಟರ್ ಸರ್ವಿಸ್ ಮುಂಭಾಗದಲ್ಲಿ ಹಾಕಿ ಸಾಕ್ಷ್ಯ ನಾಶಪಡಿಸಿರೋದು ಅಂತ ಅಷ್ಟೇ ಇರೋದು. ತೊಗೊಳ್ಳಿ ಮೇಡಮ್, ಹೇಳ್ಬಿಡ್ತೀನಿ ತೊಗೊಳ್ಳಿ. How the petitioner, counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution against this petitioner, against prosecution of the case is that the A1 committed murder of the victim, and that this petition number 2 know that of the inflicting injury by the A1 against the victim lost his life. This petitioner and other accused assisted. Other accused number 2 assisted the accused number 1 in screening the evidence. That this coordinate bench already granted bail in favor of accused number 2 in criminal petition number 7279 of 2021. And in paragraph number 6 of the order made an observation that this petitioner as well as accused number 2 said to have shifted the dead body, and on that ground enlarged the bail. The case of the prosecution is also that this petitioner assisted accused number 1 along with accused number 2 in screening the evidence. In the state counsel appearing for the state would submit that blood stains of this petitioner also seized seized since this petitioner helped in screening the evidence. Having considered the factual aspects of the case and also the case of the prosecution allegation against this petitioner along with other accused number 2 that both of them body after committing the murder by accused number 1, when such being the factual aspects and when this court already exercised the discretion in favor of accused number 2, who is similarly placed, this petitioner is also entitled for bail on the ground of parity. He is also standing in the same footing. Chandra Kumare Goda Hitchan. ಇವರು ಯಾವಾಗಲೂ ಬರೋದೇ ಇಲ್ಲ. ಇಡಿ ಪಾಸ್ ಓವರ್ ಮಾಡಿ. 36 ಹರೀಶ್ ಕುಮಾರ್ HC. ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ ಡ್ಯೂ ಟು ಪಾಸಿಟಿವ್ ಆಫ್ ಟೈಮ್ ಇಲ್ವಾ? ಹೇಳಿ ಕೌನ್ಸಿಲ್ ಹೇಳಿ.
ಮೈಲಾರ್ಡ್ ಕೈಂಡ್ಲಿ ಪಾಸ್ ಓವರ್ ಮೈಲಾರ್ಡ್.
ಪಾಸ್ ಓವರ್. 37 ಲಕ್ಷ್ಮೀ ನಾರಾಯಣ ಶೆಟ್ಟಿ. ಲಾಸ್ಟ್ ಟೈಮ್ ಪ್ರೈಸ್ ಟೈಮ್ ಪಾಸ್ ಓವರ್. 38 ಇದು ಅಷ್ಟೇ ಪಾಸ್ ಓವರ್. 498 307 ಸೀರಿಯಲ್ ಪಾಸ್ ಇಲ್ವಾ? ಪಾಸ್ ಓವರ್. 39 ಏನಾಯ್ತು? ಡಾಕ್ಟರ್ ಬಂದ್ರ? ಇದ್ರಲ್ಲೇನೋ ಡಾಕ್ಟರ್ ಡೈರೆಕ್ಟ್ ಮಾಡಿದ್ವಿ, ಬಂದಿದಾರಾ? ತೋರಿಸಿ, ಅವರಿಗೆ ರಿಪೋರ್ಟ್ ತೋರಿಸಿ ಏನ್ ಹೇಳ್ತಾರೆ ನೋಡ್. ಒಪಿನಿಯನ್ ಕೊಟ್ಟಿದ್ದಾರಾ? ಕೇಳಿದಿರಾ? ಹಾ ಹಾ Incident, date of incident, alleged. June specific date ಇದೆಯಾ? ಡೇಟ್ ಹೇಳ್ಬಿಡಿ. ಫೋರ್ಟೀನ್ 6/21 ಮೆಡಿಕಲ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡಿರೋದು ಯಾವಾಗ? ವಿಕ್ಟಿಮ್ ಸೇಮ್ ಡೇ. ಹಾ 28/6 28 ಜುಲೈ 27. ಆಯ್ತು 27. ಹಾ ಹಾಕಿದ್ದೀರಾ ಮೆಡಿಕಲ್ ರಿಪೋರ್ಟ್? ಏನ್ ಹಾಕಿದ್ರ? ಎಕ್ಸಾಮಿನೇಷನ್ ರಿಪೋರ್ಟ್ ಎಲ್ಲಿದೆ? ಕೋರ್ಟ್ ಮುಂದೆ ಇಲ್ಲ, ನೋಡಿ ಅದ್ ನೋಡೋಣ. ಹಾಕಿದ್ದೀರಾ? ಸೆಕ್ಷುವಲ್ ಅಸಾಲ್ಟ್ ಸರ್ಟಿಫಿಕೇಟ್. ಹಾ FSL ಬ್ಯಾಡ್ರಿ, ನಮ್ ಡಾಕ್ಟರ್ ಹೇಳ್ರಿ ಫಸ್ಟ್. FSL ಆಮೇಲೆ ನೋಡೋಣ. ಡಾಕ್ಟರ್ ಆಫ್ಟರ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಏನ್ ಹೇಳಿದ್ದಾರೆ? ಅದೇ ಆಯ್ತು. ವಾಟ್ ಈಸ್ ದಿ ಒಪಿನಿಯನ್? ಜೆನೈಟಲ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡಿದಾರ? ಎಲ್ಲಿದೆ ಅದು? ಅದ್ರ ಬಗ್ಗೆ ಹೈಮನ್ ಬಗ್ಗೆ ಏನ್ ಹೇಳ್ತಾರ? ಇಲ್ಲಿ ಫಿಸಿಕಲ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಕಾನ್ಸಿಯಸ್, ಅಲರ್ಟ್, ಓರಿಯೆಂಟೆಡ್, ಮಾಡರೇಟ್ಲಿ ಬಿಲ್ಟ್ ಅಂಡ್ ಮಾಡರೇಟ್ಲಿ ನರಿಷ್ಡ್. ಆಮೇಲೆ 8 ಎಲ್ಲ ಆಯ್ತು. ಆಮೇಲೆ ಯಾರಿದೆ? ಇವಂದ್ರಿ ಇದು ಒಂದು ಅಕ್ಯೂಸ್ಡ್ ಇರ್ಬೇಕು. ಇದು ವಿಕ್ಟಿಮ್ ಎಲ್ಲಿದೆ? ವಿಕ್ಟಿಮ್ ಯಾವ್ದು ಪೇಜ್ ಹೇಳಿ? External genital well developed. Physical examination. No injuries. ಅದು ಮೊದಲೇ ಸೇರಿಸಿರೋದಲ್ಲ ಕೆಳಗಡೆ. No injuries noted. External genitals. ಹಾ ಒಪಿನಿಯನ್ ಏನು? ಫೈನಲ್ ಒಪಿನಿಯನ್ ಪೆಂಡಿಂಗ್. ಹಾ ಹಾ ಜೆನೈಟಲ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಬಗ್ಗೆ ಎಲ್ಲಿದ್ದಾರೆ ರಿಪೋರ್ಟ್? ಆಯ್ತು. ಆಯ್ತು. what doctor says, what is meant by sexual assault certificate ಅಂದ್ರೆ ಏನು? if not provided the prescribed format, what is meant by sexual assault certificate ಅಂದ್ರೆ ಏನು? ಏನ್ರಿ ಡಾಕ್ಟ್ರೆ? they have issued the sexual assault certificate. ಹೌದಾ? what is meant by sexual assault certificate ಅಂತಂದ್ರೆ You are meant only for noting that only moderately built external well developed ಅಂತ ಬರ್ದಿದ್ದೀರಿ. When the victim is produced before you, certificate is also sought from you. Sexual assault certificate. Now, what is meant by sexual assault certificate? ಏನ್ರಿ ಹೇರು ಏನಾದ್ರು ಬಟ್ಟೆನೆಲ್ಲ ಏನಾದ್ರು ಸ್ಟೈನ್ಸ್ ಸಿಮನ್ಸ್ ಏನಾದ್ರು ಇದ್ರೆ ಮಾತ್ರ FSL ಕಳಿಸ್ತೀರಿ, ಹೌದಲ್ಲ? FSL ಹಾಕ್ಬೇಕು ನಿಮ್ಗೆ ಅದಕ್ಕೆ. When the victim is produced before you, what is the purpose? ಆಕ್ಟ್ ಆಗಿದೆಯೋ ಇಲ್ವೋ ಅನ್ನೋದನ್ನ ನೀವು ಬರಿಬೇಕು. ಎಲ್ಲಿ ಬರ್ದಿದ್ದೀರಿ? ಎಲ್ಲಿ ಕೆಲಸ ಮಾಡೋದು ನೀವು? ಎಲ್ಲಿ ಯಾವ ಇದ್ರಲ್ಲಿ ಇದು? ಜಗಳು ಯಾಕೆ ಮಾಡ್ಲಿಲ್ಲ? ಯಾಕೆ ಒಪಿನಿಯನ್ ಕೊಡ್ಲಿಲ್ಲ? When the victim is produced before you and you have examined, nothing is mentioned, even genital examination ಬಗ್ಗೆನೂ ಏನು ಬರ್ದಿಲ್ಲ ನೀವು. ಇಂಜುರೀಸ್ ನಿಮ್ಮನ್ನ ಹತ್ರಕ್ಕೆ ಕಳ್ಸಿದ್ದವ್ರನ್ನ ಇಂಜುರೀಸ್ ಇದೆಯೋ ಇಲ್ಲ ಅಂತ ಬರೆಯಕ್ಕೆ ಏನೇನು ಪೋಸ್ಟ್ ಮಾರ್ಟಮ್ ಮಾಡೋದು ನೀವು? ಇಲ್ಲ ಅಲ್ಲ. ಹೇಳಿ. ಹಂಗಂದ್ರೆ ಏನ್ರಿ? I know you are too smart. ಹೇಳಿ, ಅದ್ರ ಒಪಿನಿಯನ್ ಇದೆಯಾ? You are representing the state, ರೀ. You are in part of dispensation of justice. What you are bringing to the court notice? Injuries ಇಲ್ಲ ಅನ್ನೋದು ನನಗೂ ಗೊತ್ತದ, ಮೊದಲೇ ಹೇಳಿದಾರೆ ಅವರು. I am asking him why victim is produced before him and he had issued although the sexual assault certificate. What is meant by sexual assault certificate? You are not here to defend the doctor or any police. You are also having the duty towards the society. I am asking specific question to him. What is meant by sexual assault certificate ಅಂತಂದ್ರೆ ಏನ್ ಕೊಟ್ಟಿದ್ದಾನೆ? ಬೀಯಿಂಗ್ ಎ ಡಾಕ್ಟರ್ ಎಷ್ಟು ವರ್ಷ ಆಯ್ತು ಕೊಟ್ಟಿದ್ದು? ಎಷ್ಟು ವರ್ಷ ಆಯ್ತ್ರಿ ನೀವು ಸರ್ವಿಸ್ ಡಾಕ್ಟರ್ ಬಂದು? 94 ಇದೇ ಮಾಡಿರೋದ? ಆಗ 94 ಇಂದ ಇಲ್ಲಿವರೆಗೂ ಯಾವ ವರ್ಷ ಕೊಟ್ಟಿರೋದು ನೀವು? 21 ಅಲ್ಲಿ ಇದು 30 ವರ್ಷ ಇದೇ ಕೆಲಸ ಮಾಡಿದ್ದೀರಾ? ಹೇಳೋದಿದೆಯಾ? ಬೇರೆ ಏನಿದೆ ಹೇಳಿ. ಐ ವಿಲ್ ರೈಟ್ ಟು ದಿ. ನಿನ್ನೆ ಏನೋ ಹೊಸಬ್ರು ಆಯ್ತು, 6 ತಿಂಗಳಾಗಿತ್ತು. ನಾಟ್ ಹ್ಯಾವಿಂಗ್ ಎನಿ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್. ದಿಸ್ ಮ್ಯಾನ್ ಈಸ್ ಹ್ಯಾವಿಂಗ್ ದಿ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಆಫ್ ಆಲ್ಮೋಸ್ಟ್ 30 years. 30 years ಎಷ್ಟು? 29 years, ಹೌದಲ್ಲ? ಇವಳು ಏನ್ ಹೇಳಿದಾನ್ರಿ? ಇವಳು 164 ಅಲ್ಲಿ ಒಂದು ರೂಮ್ ನಲ್ಲಿ ತಿಪ್ಪೇಸ್ವಾಮಿ 10 ದಿನಗಳ ಕಾಲ ಇದ್ದ ರೂಮ್ ನಲ್ಲಿ ಗಂಡ ಹೆಂಡತಿ ರೀತಿ ಸಂಸಾರ ಮಾಡಿಕೊಂಡಿದ್ದೆವು. ನಂತರ ಆಂಧ್ರದ ಗುಂತಲ್ಗೆ ಕರೆದುಕೊಂಡು ಹೋದನು. SLC ವರೆಗೆ ವಿದ್ಯಾಭ್ಯಾಸ ಮಾಡಿದ್ದೇನೆ. ಆಯ್ತು, ನೀವು ಇನ್ವೋಕ್ ಮಾಡಿದ್ರಲ್ಲ ಸೆಕ್ಷನ್ 6. ವಾಟ್ ಈಸ್ ದಿ ಮೆಟೀರಿಯಲ್? ಫಸ್ಟ್ ಆಫ್ ಆಲ್, ಇನ್ 164 statement, victim not stated anything that she was subjected to sexual act. Your IO has invoked section 6, that is penetrative assault anta. Doctor certificate also nil. What is the ground? You ಎಷ್ಟು ದಿವಸದಿಂದ ಜೈಲಲ್ಲಿ ಇಟ್ಟಿದ್ದೀರಿ? ಯಾವಾಗಿಂದ ಜೈಲಲ್ಲಿ ಇಟ್ಟಿದ್ದೀರಿ? ಜುಲೈ. Then you pay the state should pay the compensation. Okay? ಏನ್ರಿ ಇದು? ನೋ ಮೆಟೀರಿಯಲ್ ಅಟ್ ಆಲ್. ಸೆಕ್ಷನ್ 6 ಗೆ ನಿಮ್ ಡಾಕ್ಟರ್ ಬಂದ ಬರೀ ಹೋಗಿ ನೋ ಎಕ್ಸ್ಟರ್ನಲ್ ಇಂಜುರೀಸ್ ಇನ್ ದಿ ಜನೈಟಲ್ಸ್. And also you have invoked section 6 of the POCSO Act and keeping the accused in custody from last 7 months. What is the material? How you defend your case? Heli. How you defend your case? Doctor experience of 28 years, not given any report, but he has given the certificate. Sexual assault case pending FSL. FSL ಇಟ್ಕೊಂಡು ಏನ್ರಿ ಮಾಡ್ತಾನ್ರಿ? According to him 14/6/21 ನಲ್ಲಿ ಆಗಿರೋದು ಸೆಕ್ಷುಯಲ್ ಅಸಾಲ್ಟ್. ಎಕ್ಸಾಮಿನ್ಡ್ ಆನ್ 27/21. ಆಲ್ಮೋಸ್ಟ್ ಒನ್ ಮಂತ್ 1 month 7 days ಅವಳು ಬಟ್ಟೆ ಸೀಸ್ ಮಾಡಿದ್ರೆ ಬಟ್ಟೆನಲ್ಲಿ ಏನ್ ಇರ್ತದ್ರಿ? ನೀವು ಯು ಆರ್ ಡಿಪೆಂಡಿಂಗ್ ಆನ್ ದಿ FSL ರಿಪೋರ್ಟ್. 1 ತಿಂಗಳ ಮೇಲೆ ಬಟ್ಟೆ ಸೀಸ್ ಮಾಡಿ FSL ಕಳಿಸಿದ್ರೆ ಯಾವ ಬಟ್ಟೆನಲ್ಲಿ ಸೆಮನ್ಸ್ ಇರ್ತದೆ? ಅಂಡ್ ದಿ ಮಹಾನ್ ಭಾವ ಬರೀತಾನೆ, ನಾನು ಫೈನಲ್ ರಿಪೋರ್ಟ್ ಆಫ್ FSL ಪೆಂಡಿಂಗ್ FSL ರಿಪೋರ್ಟ್ ಅಂತ ಬರೀತಾರೆ. Orders against state as well as the machinery. You are depending upon this doctor. ಏನ್ ಕಂಡ್ರಿ ಮತ್ತೀಗ 6 ಇದೆಯಾ ಇಲ್ಲ? 6 ಆಫ್ ಪೋಕ್ಸೋ ಆಕ್ಟ್ ಇದೆಯಾ? ಇದೆ. ಅದಾಯ್ತ್ರಿ, ಆ ಸ್ಟೋರಿ ಇದೆ. ಸ್ಟೋರಿಗೆ ಏನ್ ಸಬ್ಸ್ಟೆನ್ಸ್ ಮಾಡ್ತೀರಿ ಹೇಳಿ? ಸೆಕ್ಷನ್ 6 ಗೆ ಏನಿದೆ? ಏನಿದೆ ಮೆಟೀರಿಯಲ್? ಡಾಕ್ಟರ್ ಒಪಿನಿಯನ್ ಇಲ್ಲ, ಹೌದಾ? You have invoked section 6. Victim girl also who has been examined, nothing she has stated. But she says they lived like husband and wife ಅಂತ ಹೇಳ್ತಾರೆ. ಬಟ್ ಅವಳೆಲ್ಲೋ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ 164 ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಹೇಳಿಲ್ಲ ಸಬ್ಜೆಕ್ಟೆಡ್ ಟು ಹರ್ ಫಾರ್ ಸೆಕ್ಷುವಲ್ ಆಕ್ಟ್ ಅಂತ. ನಿಮ್ ಪ್ರಕಾರ ಸೆಕ್ಷನ್ 6 ಗೆ ಏನಿದೆ ಪ್ರೈಮಾ ಫೇಸಿ ಮೆಟೀರಿಯಲ್ ಹೇಳಿ ಅಷ್ಟೇನಾ ನಿಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್? ರಿಸರ್ವ್ಡ್. I will pass orders against state as well as the doctor. ಇಂಥ ಕೇಸ್ಗಳೇ ಬರೀ ನೋಡ್ರಿ. ಏನೋ ಇನ್ನೇನ ಹೇಳತ್ತಿದ್ದೇನ್ರಿ ನೀವು? ಅಷ್ಟೇ ಅಲ್ಲ, heard the doctor is also secured before the court in view of the direction issued by the earlier dates also, and also heard the HCGP. ಸರ್ಕಾರಕ್ಕೂ ನಿಮ್ ಡಾಕ್ಟರ್ಗಳಿಗೂ ಬರೀದವ್ರು ಇದೇನು ರಿಪೇರಿ ಆಗಲ್ಲ. ನಾವು ಎಷ್ಟೊಂದು ಪೇಷನ್ಸ್ ಇಟ್ಕೊಳ್ಳೋಣ. ರಿಸರ್ವ್ ಮೇಡಮ್. ನೆಕ್ಸ್ಟ್ 40 ಅರ್ಜೆಂಟ್ 41 ತ್ರಿವಿಕ್ರಮ್ ಪಾಸ್ ಓವರ್. ಎಲ್ಲ ಪಾಸ್ ಓವರ್. ಆಮೇಲೆ ಎಲ್ಲ ಡೇಟ್ ತಗೊಳಕ್ಕೆ. ಆಯ್ತು, ನೆಕ್ಸ್ಟ್ ಬನ್ನಿ ಎಲ್ಲ 41 42 43 44 45 ಎಲ್ಲ ಆಗಿದೆ ಅನ್ಸುತ್ತೆ. 46 CG ಮಲೈಲ್. ಏನ್ ಇದು 420 ಇದೆ. ಏನು ಅಲಿಗೇಷನ್? ಏನ್ 420 ಗೆ? ಸಿವಿಲ್ ಇನ್ ನೇಚರ್. 21 ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್. ಡೇಟ್ ಆಫ್ ಅಗ್ರಿಮೆಂಟ್ 12th August. 12th August. Paid. Total amount 35 lakhs paid. ಆಯ್ತು. Whether those checks are honored or not? Not been honored. Three months. ಆಯ್ತು.
They don't come forward to complete this transaction because the remaining amount has to be paid.
Who not come forward? Why they confirm? Because according to you, these 2 checks which you have given, 10 lakhs and 25 lakhs, you have not honored those checks.
No, I am the purchaser. Sorry, I am the vendor.
Vendor.
This out of the 10 lakh, this is the check. This is got dishonored. Page number 28. And this another 3-4 checks. The reason for me to sell this property was being a bonus. I was in a financial crisis, and moreover, this property was.
Go to complaint governments. We'll see complaint government. ನಮಗೆ ಮಾರಾಟ ಮಾಡಲು ಒಪ್ಪಿ 50 ಲಕ್ಷ ಹಣ ಪಡೆದುಕೊಂಡು ನಿವಾಸವನ್ನು ಅವರಿಗೆ ಮಾರಾಟ ಮಾಡಿ ಮೋಸ ಮಾಡಿರೋ ಬಗ್ಗೆ ದೂರು. ಆಯ್ತು. ಯಾವಾಗ ಸೇಲ್ ಮಾಡಿರೋದು ಯಾವಾಗ್ರಿ? January 2021. Agreement 3 months. ಹೌದಾ?
Within 3 months. I sold this property to the other person.
Is
January 2022.
2022.
Page number 14. Prior to that sale, September 14,
Whether has he filed any suit for specific performance? Is there any condition in the agreement for refund of amount in non-execution of the document? Ilva? Refund of money? Not been honored. And thereafter?
The 135 lakhs which has been agreement purpose, it has not been honored. The 10 lakhs already have pointed out, the accounts that was gone. Remaining 25 lakhs. Virtually can we see this amount supposed to be deposited in my loan account and take release account?
Toli madam. Entry. Simple question. Agreement ಪ್ರಕಾರ 35 ಲಕ್ಷ ಕೊಡಬೇಕು ಹೌದಲ್ಲ ಈ ಕಂಪ್ಲೇನೆಂಟ್ ಏನಿದಾನೆ whether he has honored those two checks while entering into an agreement, he made the payment of rupees 10 lakhs and also the 25 lakhs by way of check dated 12/8 ಎರಡು date of agreement ಅನ್ನು whether your complainant has honored these two checks ಅದಾದ್ಮೇಲೆ ಬೇಡ ಅದಾಗಿದೆಯಾ ಮತ್ತೆ ಇಲ್ಲಿ 420 ಯಾರು ಅವನೇ 420 ಮತ್ತೆ ತಗೊಳ್ಳಿ ಆಯ್ತು ಅದೆಲ್ಲ ಆಗ್ಲಿ ತಗೊಳ್ಳಿ. Heard the petitioner counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution is that this petitioner entered into an agreement of sale with the complainant, where the agreement dated 12/8/2020, and he come forward to execute this so the property in favor of somebody else in 2022. Main allegation is that this petitioner has cheated the complainant. Based on the complaint, case has been registered. Appearing for submits that petitioner is a vendor, and the petitioner not disputes the fact that he entered into an agreement of late 2020. In terms of the sale agreement, earnest money of rupees 10 lakh paid of rupees 25 lakhs, and total sale ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಎಲ್ಲಿದ್ದಾರೆ ಅವ್ರು ಹೇಳ್ತಾರದು ಅಗ್ರಿಮೆಂಟ್ ಹೇಳ್ತಾರೆ ಆಯ್ತಾ ಏನಾಯ್ತು ಮೇಡಮ್ ಸೇಲ್ ಕನ್ಸಿಡರೇಷನ್ is rupees 2.70 lakhs and counsel would submit that though earnest money of rupees 35 lakhs paid by way of check, both the checks are not honored. Copy of the check as well as the memo is also produced along with the petition. The counsel also submits that in terms of the agreement, only 3 months period is provided to complete the sale transaction. And he did not come forward to pay the balance amount and also have the sale deed. And hence the property was sold in the month of 2022 January. And hence no question of any invoking of offense on 420 of IPC. And bail by invoking section 438 of CPC. Per contra, the counsel appearing for the state submits that in terms of the complaint, specifically stated that an amount of rupees total paid an amount of rupees 25 lakhs. An amount of rupees 25 lakhs paid as cash. Paid the amount of rupees 10 lakhs from Malleshwaram. Idenri Malleshwaram Cooperative Bank ಬಂದಿದೆಯಾ ದುಡ್ಡು ಬಂದಿದೆಯಾ ಅದು 10 ಲಕ್ಷ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಹೇಳಿದ ಪ್ರಕಾರ you answer to my question, have you received the amount or not? No, ಅದು ಹೇಳಿ ಅಷ್ಟೇ 10 lakhs was paid through Bank of Maharashtra and also an amount of rupees 7 lakhs. And also different amounts are paid in favor of the different persons. In all, total paid an amount of rupees 50 lakhs, having received the sale consideration while executing the sale agreement and committed breach. Having heard the respective counsel and also considering the material and record, the petitioner has relied upon the sale agreement dated 12/8/2020. And also in terms of the sale agreement, the time is the essence of contract as 3 months from the date of the agreement. And the council prima facie placed the documents of dishonor of check which have been given in terms of the said agreement. And also the complainant says that made some payment by way of cash as well as through other banks. And when such being the allegation, it is a matter of civil dispute between the parties, and hence it is a case to exercise power under 438 of CRPC. ಆಯ್ತಾ ಮಧ್ಯಾಹ್ನ ರಿಮೈನಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಮಧ್ಯಾಹ್ನ. Any submissions? Any mentioning? ಏನಿಲ್ಲ. Remaining matters are 2:30. ಮೇಡಮ್ ಇತ್ತಲ್ಲ ಇಲ್ಲಲ್ಲ ನಿನ್ನೆ ಅದಕ್ಕೆ ಕೇಳ್ಕೊಂಡು ಹೋಗಿ ಯಾವ್ದು ಇಲ್ಲಲ್ಲ ಸುಜಾತ ಮೇಡಮ್ ರಜಾ ಧಾರವಾಡ ಬೀಚ್ ಊರು ಎರಡ ಮೂರು ಹೇಳ್ರಿ ಸೀರಿಯಲ್ ನಂಬರ್ 51 petition files memo as not pressing since in the petition 482 filed by the petitioner already stayed and hence for the present dismissed. ಹೌದಾ ಹೇಳಿ ಏನಾಗುತ್ತೆ 62 ನಾಗಮಣಿ ಹೇಳ್ರಿ ವೈ ವಾಂಟ್ ಅರ್ಜೆಂಟ್ಮೆಂಟ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ ಅಬ್ಸೆಂಟ್ ಅಂತ ಇದೆ ಜೂನಿಯರ್ ನೀವಿದಿರಲ್ಲ ಎಷ್ಟು ಟೈಮ್ ಆಯ್ತು ಎನ್ರೋಲ್ ಆಗಿ 18 ಮತ್ತೆ ಅವರೇ ಮಾಡ್ಬೇಕಾ ಆಯ್ತು ಪಿಟಿಷನರ್ ಕೌನ್ಸಿಲ್ 6 ಟೈಮ್ ದಿಸ್ ಮ್ಯಾಟರ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಹಾಕಿರುತ್ತೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಎಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಹಾಕಿದ್ದೀನಿ ಆಮೇಲೆ ಅವ್ರಿಗೆ ಅಲ್ಲಿ ರಶ್ ಆಫ್ ವರ್ಕ್ ಆಗ್ತದೆ ನೋಡಿ ಹಾಕ್ಸ್ ಇದು ಮಾಡ್ಕೊಳ್ಳಿ ಅಷ್ಟು ಅಷ್ಟೇನಾ ಯಾವ್ದಾರು ಇದೆಯಾ ಇಲ್ಲ ಏನು ಹೇಳಿದ್ರು ಇನ್ನೂ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆಯಂತ ಮತ್ತೆ ನಾನು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ದೀನಿ ಮಾಡುವಾಗ ಅವರಲ್ಲಿ ಕೇಳೇ ಮಾಡೋದಿಲ್ವಾ ಅವ್ರ ಹತ್ರ ಮತ್ತೆ ರೀಸ್ಕ್ರೂಟಿನಿ ಮಾಡಿದಾಗ ಹಂಗಾಗಿದೆಯಾ ಆಯ್ತು ಬಿಡಿ ಏನ್ ನಂಗೆ ಹೇಳಿ ಅವ್ರಿಗೆ ಬಂದ್ರೆ ಅಡ್ವೊಕೇಟ್ ಏನ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆ ನಾವೇನಾದ್ರು ಕರೀರಿ ಅಂತ ಹೇಳಿದ್ಮೇಲೆ ಏನಾದ್ರು ಅಬ್ಜೆಕ್ಷನ್ ರೈಸ್ ಮಾಡೋರ ಏನ್ ಅಬ್ಜೆಕ್ಷನ್ ಕೇಳಿ ಯಾಕೆ ಮಾಡ್ತಾರೆ ಆ ಕೇಸಿನ ಯಾವ್ದ್ರಲ್ಲಿ ಬೇಲ್ ಕೇಳ್ತಾರೋ ಆ ಕ್ರೈಮ್ ಮಾತ್ರ ಫೈಲ್ ತರಿಸಿ ನೋಡೋಣ ಸಿ ಎಲ್ಲ ಸ್ವಲ್ಪ ಆರ್ಟಿಫಿಷಿಯಲ್ ಇಂಟೆಲಿಜೆನ್ಸ್
Sir.
Court officer.
Ameta clear la IK away neck Panda go the very watanda. Apaga and a Pukuna Manda.
Hello. Good afternoon, sir.
Try.
Court officer. Court officer. Court officer. No, we are going this. No, this week, ask them to take this one book. But ಇದು ಯಾವ್ದು AR online ಐತಿದೆ. ಅಲ್ಲ ಬಟ್ ಫಾರ್ಮ್ಯಾಟ್ ಯಾವ್ದು ಇರ್ತದೆ ಯಾರು ಅಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 2007 ಎಷ್ಟದ ಯಾರು ಮ್ಯಾಟ್ರಿಕ್ಸ್ ಅಲ್ಲಿ ಕೋಡ್ ಆಫೀಸರ್
ನಾ ಗುಲ್ಬರ್ಗದಿಂದ ಮಾತಾಡ್ತಾ ಇದ್ದೀನಿ ಸರ್.
ಸರ್ ನಾವು ಧಾರವಾಡದಿಂದ.
ಹೌದಾ?
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮ್ಯೂಟ್ ಐತೆ ಅವ್ರದ್ದು ಮ್ಯೂಟ್ ಐತೆ
Court officer. Court officer.
Court officer. Court officer. ಆರಾಮ್ ರೀ ಆರಾಮ್
ಹಾ ಸಾವಿರದಲ್ಲಿ
ಕ್ಲೋಸ್ ರೀ ಕೊಡಿ ಸರ್ ಇದಾಗ ಹುಣಸೆಟ್ ಇಲ್ಲ ಸರ್
ಕೊಟ್ಟಿಲ್ಲ ಸರ್
ಇದು ಕಾಂಪ್ಲಿಕೇಟೆಡ್ ಆಗಿ ಸರ್ ಮ್ಯಾಟರ್ ಇದು ನಿಮ್ಗೆ ಗೊತ್ತಿರಲ್ಲ ಅವ್ರು ಯಾರೋ ಮೊದಲು ಒಬ್ರು ಪಿ ಐ ಇದ್ರು ನೋಡ್ರಿ 8 months ಇದು ಅರೆಸ್ಟ್ ಆಗಿಲ್ಲ ಸಾಬ್ ಶೋಕಾಸ್ ನೋಟ್ಸ್ ಕೊಟ್ಟು ನೀವು ಇದಿಲ್ಲ ನೋಡ್ರಿ
ಇದ್ದೆ ಸರ್
ಪಿ ಐ ಕರೆಸಿ ಕೋಟಿ ಹಾಲ ಕರೆಸಿ ವಾರ್ ಮಾಡಿ ನೋಡ್ರಿ 8 ತಿಂಗಳ ಏನ್ ದೊಡ್ಡ ಪಾಲಿಟಿಷಿಯನ್
ಅರೆಸ್ಟ್ ಮಾಡೋದು ಸರ್
ಸೇಮ್ ಡೇ ಅರೆಸ್ಟ್ ಮಾಡೋದು ನೋಡ್ರಿ ಪಾಪ ಅವ್ರು ASI ಪ್ರಮೋಷನ್ ಆಗಿ ನೋಡ್ರಿ ಇದೇ ಕೇಸ್ ಬಹಳ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ ಸರ್
ಸರ್
ಅವಾಗ ವಕೀಲರು
ಸರ್ ಬೆಂಬರ್ ಸರ್
ಕೋರ್ಟ್ ಆಫೀಸರ್
ನಿಮ್ಗೆ ವಾಟ್ಸಪ್
ಸರ್ ಸರ್ ಅಡ್ಮಿಟ್ ಕ್ಲಿಯರ್ ಸರ್ ಬೇಸಿಕ್ ಕ್ಯಾಬಿನ್ ಇದ್ದಾರೆ
ಸ್ವಲ್ಪ ಕ್ಲಿಯರ್ ನಡಬರ್ಕೇನೋ ಸೌಂಡ್ ಹೊಂಟಿದ್ದು ಡಿಸ್ಟರ್ಬನ್ಸ್.
ಇಲ್ಲ ಇದು ಮಾಡಿ ಸರ್, ಇಲ್ಲೇ ಜಾಯ್ನ್ ಆಗಿರಿ ಮೊಬೈಲ್ ಆಗಿರಿ.
ಅದೇ ಮಗಳು ಏನೋ ಸ್ವಲ್ಪ ಡಿಸ್ಟರ್ಬ್ ಆಗಕತ್ತಿ.
ಓಕೆ
ಕ್ಲಿಯರ್ ಅದ ಈಗ.
ಓಕೆ ಸರ್.
ಸರ್ ಯಾಕೋ ರಿಸೀವ್ ಮಾಡ್ತಾ ಇಲ್ಲ.
ಹಲೋ, ಗುಡ್ ಆಫ್ಟರ್ನೂನ್. ಏನಿ ಹೆಸರು ಬರೀತಾರ ನೀವ್ರ ಬಂದವಲ್ಲ?
ನಮ್ದು ಬಿಸಿ ಕವಿನ ಕ್ಲಿಯರ್ ಮಾಡ್ತಿರಲ್ರಿ.
ಆಫೀಸರ್
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಇಲ್ಲ, ಯಾವ ಆಫೀಸರ್ ಇಲ್ಲ.
Court officer.
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಸರ್ ಹೇಳಿ.
ನಾವು ಸೀರಿಯಲ್ ನಂಬರ್ 2 ಅಂದ್ರೆ ಸರ್, ಗುಲ್ಬರ್ಗಿಂದ ಮಾತಾಡೋದು.
ಕರಿತೀನಿ ಸರ್.
ಹೌದ್ರಾ?
ಗವರ್ನಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಇದ್ದಾರಾ?
ಏನ್ರಿ?
ಗವರ್ನಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್.
ಬಂದಿನ್ ಮೇಡಮ್, ಗುರುರಾಜ್ ವಿ ಹಾಸಿಲ್ಕರ್ ಅಂತ.
BM ಕಿಣಿಕೇರ್ ಹತ್ರ ಪಿಟಿಷನರ್.
ಇದು ಧಾರವಾಡದ್ದು ಇದಾರಾ
ಮೇಡಮ್?
ಧಾರವಾಡ ಬೆಂಚ್ ಅವ್ರು ಇದಾರಾ ಸರ್?
ಇದೇವೆ ಮೇಡಮ್.
ಯಾರು ಗವರ್ನಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಹೆಸರು ಹೇಳಿ ಸರ್.
ಗೌರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಅಲ್ಲ ಮೇಡಮ್, ನಾವು ನಮ್ದೊಂದು ಇದೆ ಕ್ರಿಮಿನಲ್ ಆರ್ಟಿ 22/2/2012.
ಅಲ್ಲ, ಯಾರು ಗವರ್ನಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಇಲ್ಲ ಅಲ್ಲ ಅದ್ರಲ್ಲಿ?
ಇಲ್ಲ ಚೆಕ್ ಬೋರ್ಡ್ 138.
ಸರಿ ಸರ್.
ಫಸ್ಟ್ ಗುಲ್ಬರ್ಗದ್ ಕರೀತೀರಾ?
ಇಲ್ಲ, ಫಸ್ಟ್ ಧಾರವಾಡ.
ಗುಲ್ಬರ್ಗದ್ ಲೇಟ್ ಕರೆಯೋದು. ಹಲೋ ಮೇಡಮ್. ನಮ್ ಗುಲ್ಬರ್ಗದ್ದು ಸೀರಿಯಲ್ ನಂಬರ್ 3 ಕರೆಯೋದು ಲೇಟ್.
ಇಲ್ಲ ಸರ್, ಈಗ ಕರಿತೀವಿ. ಸಾಹೇಬ್ರು ಬಂದ ತಕ್ಷಣ ಕರಿತೀವಿ ಮೇಡಮ್.
ಹಲೋ
ಸರ್, ಎಲ್ಲ ದಯವಿಟ್ಟು ವಿಡಿಯೋ ಆಫ್ ಮಾಡ್ಕೊಳ್ಳಿ ಸರ್.
ವಿಡಿಯೋ ಆಫ್ ಮಾಡಂತ ತಗೊಳ್ರಿ. ಎಲ್ಲ ವಿಡಿಯೋ ಆಫ್ ಮಾಡಂತ ಹೇಳಕತ್ತಾರ ಅವ್ರು ಮೇಡಮ್. ಆಫ್ ಮಾಡಂತ ಹೇಳಕತ್ತಾರ.
ವಿಡಿಯೋ ಆಫೀಸರ್.
ಯಾವ್ದು ಇದು ಒತ್ತಬೇಕಾ? ಯಾವ್ದು ನೋಡಮ್ ಸರಿ.
ಗೊತ್ತಬೇಡ್ರಿ.
Court officer. DP entry. I'll mute my phone. Court officer. Court officer.
ಸರ್ ಇದು ತಗೋತಾರಂತ
ಸರ್ ಕೇಳ್ತಾ ಇದ್ದಾರ ವಿಶ್ವನಾಥ್
ಕೇಳ್ತಾ ಇದೆ.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಅವ್ರೆ, ಹಲೋ ಹಲೋ
Court officer. One mute ಐತಿ ಒಂದು mute ಇಲ್ಲಪ್ಪ. Court officer.
ಶ್ರೀನಂದ್ ಸರ್
ಸರ್ ಹೇಳ್ರಿ.
ಸರ್ ತಗೋತಾರಂತೆ ನಾ ಕೇಳಿದ್ದೇನೆ ಈಗ ಫಸ್ಟ್ ತಗೋತಾರಂತ.
ಹಾ
ನಾವಿದ್ದೇವೆ ಅಂತ ಹೇಳಿದ್ದೇನೆ.
ಅಲ್ಲ ಸೈಟೇಷನ್ ಹೇಳ್ಬೇಕಾಯ್ತು ಕೋರ್ಟ್ ಆಫೀಸರ್ ಅವ್ರು ಹೇಳೋಣ ಅಂತ ಇಲ್ಲ.
ಹೌದಾ ಹಾಗಾದ್ರೆ ಇದು ಮಾಡಿ ಸರ್ ಮಾಡಿ.
ಅಂತ ಕೇಳ್ತಾ ಇದ್ದಾರೆ. Court officer. Court officer. Something is wrong, madam.
Travel by session judge. Right. 60. What do you want? Charge sheet file ಆದ್ರೆ charge sheet file ಮಾಡಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಅಷ್ಟೇ. First time. Serial number 60. Petitioner counsel submits that charge sheet already filed and seeks time to produce the charge sheet. And hence, list after week after list. 88. Head. Accommodation. 88. Sorry. Petitioner counsel seeks time. Next week the bala week after next. 88 week after next. 88 ರೀ ಆಗಿಲ್ಲ 89 ಆಗಿದೆ. ಬೆಳಗ್ಗೆ ಯಾರು ಜಗದೀಶ್ ಅವ್ರು ಕೇಳ್ತಾ ಇರೋದು 88. 89 ಬೆಳಗ್ಗೆ ಆಗಿರೋದು. ಆಯ್ತು ಈಗ ಎಲ್ಲಿದೆ ಹೇಳಿ. ಕಮ್ ಬ್ಯಾಕ್. ಧಾರವಾಡ ಬೆಂಚ್ ಇದೆಯಾ?
Matter pertains to Dharwad bench. Srinand Pacha.
Millets, in this millets, Lordship have directed me to millets.
Srinand Pachapure, last time I asked you, where is
Criminal
the
Law Journal 2007 millets 1865.
18? Judgment 18? 18?
That's 2007 Criminal Law Journal 1865 millets.
2007. 2007 you are not furnished. Only you have furnished 2 citations. One is 2021 SC 807. Another is 1138 of 21.
Millets 2000 just now millets I tried to contact millets the court officer. I have sent one millet citation millets.
Which citation? Which citation, counsel?
2007 Criminal Law Journal 1865 millets. This is not though it is the single bench of Kerala High Court. What it says is at para 29. Para 29. The offence is compoundable. Parties have settled their disputes amicably. Complainants have voluntarily compounded the offence. If the powers under section 482 CRPC were not invoked by this court, the petitioners will have to necessarily undergo the dreadful or by being human and considerate and reversed his culpable conduct. The majesty of the law will not suffer at all. Quality of money in the most important decision of dimension of justice. I hold that these are the fit cases to invoke powers under section 482. I made this application 482. Today, the DD is also ready. You
have made an application 482. My question is, once the matter has already been disposed of on merits, whether the court can entertain the compounding of offences. So that is my question. You are not giving any citation on the point because this court becomes.
This is answered in 2007 Criminal Law Journal.
Kerala High Court.
This is answered in Criminal Law Journal. I'm sorry,
2007 Law Journal 2262. This is Delhi High Court judgment. Delhi High Court judgment. Any problem in your device? para 29 ನಂತರ para 29 ಇಲ್ಲ ನೋಡಿ. ಕೇರಳದೊಂದೇನೋ ಹೇಳಿದ್ರು. ಕೇರಳದ ಯಾವ್ದಾರು ಕೊಟ್ಟಿದಾರ ನೋಡಿ. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಮೇಡಮ್ ಇದು. ಏನಿದೆ? ಸ್ಟೇಟ್ ಆಫ್ ಕೇರಳ ಇದು ಅಷ್ಟೇ. ಇನ್ಯಾವ್ದಾರು ಇದೆ ಇದೊಂದೇನು? ಯಾವಾಗ ಕೊಟ್ಟಿದ್ದಾರೆ? ಓನ್ಲಿ ಪಾಯಿಂಟ್ ಮ್ಯಾಟರ್ ಡಿಸ್ಪೋಸಲ್ ಆಗಿದೆ ಮೇಡಮ್. ಇವೆಲ್ಲ disposed matter only now they seek permission to compound the offence. Whether this court can entertain that, that is the only question. Srinan, the device which the council is using is not proper and hence list this matter on next week. Support. Same is disconnected. Hence this matter on 3rd of March. Kalburgi put.
Kalburgi bench.
Kalburgi. Avinash.
Lord, I happy for the petitioner, my lord. My lord, this is a successive bail, my lord. The offense.
Where is the earlier order? Where is the earlier
order? At 74, my lord. At page number 74.
Page number 74.
Please, my lord. The operative portion is at 78.
78.
Please, my lord.
What is the reason for rejection?
My lord, your lordship has referred a medical report, my lord, and directed me to wait till examination of material witnesses.
And having taken the fact that victim is suffering from moderate mental retardation, he was subjected to homosexual activity and same is videographed and the material is also seized in the presence of CW6. When considering the facts, the prima facie material against the petitioner and RFSL report is awaited. Only medical examination report is available before this court. Hence, at this juncture, it is not a fit case of so dismissed. However, liberty is reserved to the petitioner to approach this court after. Where is the RFSL report?
My lord, now, my lord, the honorable trial court has examined, my lord, out of 19 witnesses, my lord, 16 witnesses have examined, my lord, and material witnesses, my lord, all the witnesses have turned hostile. Lord, including CW6, CW7, CW1, and my lord, CW8, CW9.
Where is? I am asking with regard to where is the RFSL report?
My lord, at page number 72, my lord, it's a final opinion given by the doctor.
72. What is the opinion?
My lord, I am permitted to read it. My lord, the final opinion, my lord, seminal stains was not detected in article number so and so, my lord. Spermatozoa was also not detected.
There is no evidence of.
Please, my lord, this was the final. And my lord, remaining opinion is, my lord, remaining one evidence, my lord, that is the investigating officer's evidence is remaining, my lord. Oh, kindly, my lord, he has undergone already 1 year, my lord.
Whether the victim is examined?
No, my lord, victim is not examined. My lord, he is
Then-
not a witness because as he is suffering from mental retardation, Lord,
Huh.
he is not the witness in the present case, my lord. And my lord,
Then who has been examined on behalf of the victim?
my lord, his father.
What is his evidence?
My lord, PW3, my lord. Lord,
Where is the evidence?
PW3, my lord, at page number 81, my lord.
Page number 81.
Please, my lord. Page number 81, my lord. He also turned hostile, my lord. Lord, at 87. At 87, my lord. And further, my lord, at page number 88, my lord, I may be permitted to read, my lord, page number 88. ನವೀನ್ ಆರೋಪಿತನು ಇದು ಮಾಡಿರೋ ಬಗ್ಗೆ
ಹೇಳಿದಾನಲ್ರಿ ನೀವು ಸಪೋರ್ಟ್ ಮಾಡಿಲ್ಲ ಅಂತೀರಿ ಅವನು ನೋಡಿ ಎವಿಡೆನ್ಸ್ ಏನ್ ಹೇಳ್ತಾನೆ
my lord.
ಆರೋಪಿತನು ದಿನಾಂಕ 9/2/2001 ನನ್ನ ಮಗನಾದ ನವೀನ್ ಶಾಲೆಯಲ್ಲಿ ಕರೆದುಕೊಂಡು ಹೋಗಿ ಅವನಿಗೆ ಮರ್ಮಾಂಗವನ್ನು ನೆಕ್ಕಿಸಿರುತ್ತಾನೆ ಅಂತ ನನ್ನ ಮಗ ಕೈ ಸನ್ನೆ ಮಾಡಿ ತೋರಿಸಿರುತ್ತಾನೆ. ಸದರಿ ವಿಷಯ ಮೊಬೈಲ್ ನಲ್ಲಿ ರೆಕಾರ್ಡ್ ಆಗಿದ್ದು ಸದರಿ ವಿಷಯವನ್ನು ನನಗೆ ಚಾಸ 8 ರವರು ತಿಳಿಸಿರುತ್ತಾರೆ. ಈ ಕುರಿತು ನಾನು ಪೊಲೀಸರಿಗೆ ದೂರನ್ನು ನೀಡಿರುತ್ತೇನೆ. ಸಾಕ್ಷಿಯು ದೂರಿನ ಮೇಲಿರುವ ಸಹಿಯನ್ನು ನೋಡಿ ಗುರುತಿಸಿದ್ದು
further, my lord, at page number 88, my lord, kindly your lord.
Whether this court can appreciate all this evidence?
My lord, my humble submission is.
This court can usurp the
my lord,
powers of the trial court.
My lord, my humble submission is, my lord, PW8 is also has turned hostile, my lord.
Then you get the orders and merits before the trial court. That's all.
My lord, I have waited, my lord. My lord, I have waited for all this.
Whether I can appreciate the
Because,
evidence
even,
before
my
the
lord,
trial
even
court,
recovery of mobile, that mobile phone is also turned hostile, my lord. The panchas also have turned hostile, my lord.
Then you get an order. That's all. You get an order on merits before the trial court. According to you, out of 19 witnesses, 16 witnesses already examined.
My lord, please, my
Only
lord,
IVA has to be examined.
your lordship, my lord, on the other day, my lord, was inclined to give a bail, my lord, but the only thing is, your lordship has directed me to wait the examination of material witnesses. That is why, my lord,
That's why now is also the material witnesses who conducted the investigation.
My lord, there is no question of tampering the witnesses, my lord. That is the, my lord. Please, my lords, I have waited
this
for all
is a successive bail petition. What is the change circumstances?
My lord, change circumstances, my lord. As per your lordship directions, my lord, I have come up before this court after examination of all the material witnesses, my lord. Please, my lord. My lord, otherwise I would not have approached this court. Oh, please, my
but
lord.
In the evidence they have supported.
My lord,
the father
kindly
is also
see, my lord.
supported.
Lord, kindly see page number 88, my lord. He himself has turned hostile.
But in the chief examination, he has stated that video was videographed also the incident. And also what act he has done, that is also he has stated in the chief evidence.
My lord, but there is no video, my lord. The panchas to the that mobile phone have also turned hostile. There is no, my lord.
That's why now I am sitting under section 439. I cannot appreciate the evidence available on record.
Lord, kindly,
liberty is given.
The other evidences also.
Hostile. Now the witness is supporting.
My lord, kindly, my lord, kindly.
And also the victim is unable to come and give evidence. Only father can give evidence.
Because my lord, he himself says
mentally retarded person.
My lord, even his mother has also turned hostile.
Who is appearing for the state?
His mother has also turned hostile, my lord.
My lord, this case, as per even initially complaint of that content of property is very heinous. This accused petitioner committing the heinous offense, my lord. Also PW1, because the father of that boy, my lord, was fully support to the prosecution, my lord. Even also, of course, there is no any medical evidence of this, but at time of the other witness, they have recorded the said incident, my lord. Bloodspotting the other people's, my lord. These are the main material evidence, my lord. Even also, still the partly the trial court order partially they examined the witnesses. The other some witness material witnesses pending, my lord. For this situation, the bail cannot be granted, my lord. If he is released on bail, my lord, definitely have temporary prosecution witness. Already some of they have influenced some witnesses, my lord.
For the petitioner counsel and also the counsel appearing for the state. This petition is a successive bail petition before this. Earlier, this court rejected a bail petition filed dated 18th day of October 2021 in criminal petition number 1208 of 2021. The very factual matrix of the case is that this petitioner subjected the mentally retarded person for unnatural sex. It offense 77 of IPC. And this court, while rejecting the earlier bail petition, comes to the conclusion that there is a prima facie material against the petitioner and RFSL report is awaited. Only medical examination report is available before this court. And hence, at this juncture, not a case for excessive powers of 439 of CRPC. While dismissing the petition, also made it clear that liberty is reserved to the petitioner to approach this court after receipt of RFSL report and after examination of some material witnesses. Now, the petitioner counsel submits that out of 19 witnesses, 16 witnesses have already been examined and only examination of IO is remaining, and hence it may be enlarged on bail. The notice of this court that victim father is examined and also submits that the witnesses have not supported the case. Perusal of the records, the father who has been examined before the court stated subjecting the victim for unnatural, and also the same is recorded in the same also videograph. Hence he gave the complaint. The accused counsel also cross-examined the witness. When searching the factual aspects of the case, when the witness father of the victim for the case of the prosecution, this court exercising the powers under 439 of CRPC cannot appreciate the evidence available on record. And also, this court cannot usurp the powers of the trial court. In the factual aspects, the evidence has to be analyzed by the trial court and not a case for exercising the discretion again in a successive bail petition and no circumstances case on hand. However, taking into note of the petitioner is in custody from Yavaginda idanre custody.
My lord, he is in custody, my lord, since from 6/3/2021, my lord.
6/3/2021,
my lord.
ಇನ್ನು ಒಂದು ವರ್ಷನೂ ಆಗಿಲ್ಲ. 6/3/2021.
You, my lord, your lordship, you are about
and
to
also in view of the examination of 16 witnesses as continued with the petitioner, the trial court is directed to dispose the matter as soon as possible, not outer than outer limit of
Lord.
6 months.
My lord.
3 months. 3 months. 3 months.
My lord, there is another one witness, my lord. Only one witness.
3 months ಒಳಗೆ ಮಾಡ್ಲಿ ಬಿಡಿ.
ಅಲ್ಲ ಅಂದ್ರೆ ಸಾಹೇಬ್ರ ಮೊಬೈಲ್ ಕೂಡ ಸೀಸ್ ಮಾಡಿದ್ದು ಅವರು ಹೋಸ್ಟೆಲ್ ಆಗಿದ್ದಾರೆ ಸಾಹೇಬ್ರ. ನಥಿಂಗ್ ಇಸ್ ಪ್ರೂವ್ಡ್.
ಆಯ್ತ್ರಿ, ನಾನು ಹೇಳಿದ್ನಲ್ಲ ನಿಮ್ಗೆ, ನಾನು ಇಲ್ಲಿ ಕೂತ್ಕೊಂಡು ಅಪ್ರಿಶಿಯೇಟ್ ಮಾಡಕ್ಕಲ್ಲ ಎವಿಡೆನ್ಸ್.
ನಮ್ಮ ಡೈರೆಕ್ಟರ್ ಮೇಲೆ ಬಂದಿದೆ ಸಾಹೇಬ್ರ, ಅದಕ್ಕೆ
3 months ಅಂತ ಕೊಟ್ಟಿದ್ದೀನಿ ನೋಡಿ. Serial number 2.
This petition is filed by the petitioner under section 439 CRPC.
ಎಲ್ಲಿದೆ ಆರ್ಡರ್? ಇದೆ ಅರ್ಲಿಯರ್ ಆರ್ಡರ್ ಇದೆ ಹೇಳಿ.
I have filed, my lord. The earlier order is filed before the honorable court was withdrawn as not present, my lord.
27 not withdrawn as not pressed. ಹೇಳಿ ಈಗ what is the change? ಏನು ಹೇಳಿ ಈಗ?
The police, the IO has filed charge sheet, my lord. And as per 164(5) statement, my lord, as per which the complainant himself was admitted on the next date in the government hospital, my lord. But and on the same day in the evening, police have recorded a statement in the general hospital, Kalburgi. But
164 statement, what she says, Ray?
My lord, I have produced the charge sheet, my lord.
Sheet number.
Sheet number, my lord. Sheet number 25 to 30, my lord. Page number 25 to 30, particularly in page number 27, my lord, para 3, wherein she states that
Yes, counsel. Srinand, your matter is urgent to third. Third.
Please.
You use good device while arguing the matter.
Please,
Last time also the very same problem.
Please not, sir. I'm sorry.
Yes. Continue, counsel. Kinikeri.
My lord. Is the same that statement is not coming forward before this court, my lord. Where is that statement? The IO has not filed that statement. Apart from this fact was not brought in the complaint also, my lord. Further, my lord, if it is quite unnatural to say that when a person entered in the house and committing such offense, no one will be kept quiet, my lord. She was sleeping with her children in the parents' house, my lord. How can it, any common man will keep quiet, my lord? Therefore,
That's all?
He is in judicial custody, 13/11/2021, my lord. And the prosecution apprehension is that he may tamper the prosecution witnesses and he may jump on the bail and he may not cooperate with the trial, my lord. If these conditions may, this apprehension may be, this apprehension may be by imposing stringent conditions on the petitioner, my lord. Therefore, my request the honorable court.
Yes, counsel, elder state.
Already the investigation is completed, my lord. It is as per the statement of all the witnesses. The rule of this accused petitioner is primary patient, as per primary patient, all the statement, my lord. Even also this victim, Kavita, she was given the statement under section 164 clause 4, my lord. Even also 164 clause 4, she was stated clearly stated against the this accused petitioner. Already definitely, as per the nature of this act, my lord, this petitioner, they have, as per the contents of the complaint, even also they have.
According to your charge sheet also filed. Where is that charge sheet?
Charge sheet they have filed.
Here is the copy of charge sheet. Yes.
Also, contents of the complaint or statement of the all the witness level. Initially, when they are committing the offense in the house of the victim, my lord, then after the committing of the offense, he was threatening to this victim, my lord. And therefore, delay of complaint, she was also stated, my lord. For him, there is
That is not before committing offense, my lord, as alleged by the prosecution.
The medical evidence?
Nothing is there in my lord, medical evidence.
However, it is waiting for the medical examination report, my lord. But FSL already there.
I agree. This was on 12/10/2020. When she was subjected to medical examination.
Next year, she was admitted in a government hospital and as a MNC, my lord. It is awaiting for correction. So charge sheet is filed, but medical examination report of the is awaited, my lord. I will submit
the alleged act of rape on 12/10/2020. When the victim examined.
Mostly
where is the medical records?
Page number 22, my lord, in charge sheet. 22 to 24, my lord, FSL report.
Medical report I am asking.
Not 5 months only.
3 days man, 3 days time ಇವತ್ತಿತ್ತು ಇವತ್ತೇ ಅವರು ರಿಸೀವ್ ಮಾಡ್ಕೊಂಡು ಇವತ್ತು ಒಂದು 3 days ಮೇಲೆ ಅವ್ರು ಸಬ್ಮಿಟಿಂಗ್ ಮೇಲೆ
HCGP 6 3 days time. List this matter on 3rd. ಇದನ್ನು ಒಂದು 3rd ಹಾಕ್ಬಿಡಿ ಮೇಡಮ್.
Serial number 3.
Serial number 3.
Lord, I am appearing for petitioner in this case, my lord.
Yes, counsel ಹೇಳಿ.
Petitioner is the accused number 2, my lord. Earlier he approached to this honorable court, my lord.
ಆಯ್ತು, FSL report ಬಂದಿದೆಯಾ?
In page
Where
number
is the FSL report?
But FSL report, my lord, in page number 50, my lord. 50. 50, my lord. Opinion of the, my lord, in the
due to hemorrhagic shock, cardiorespiratory arrest.
But because of the injury he sustained, that is the, my lord, the case of the prosecution, my lord. But cardiac arrest, my lord, it is the opinion of the doctors, my lord. The FSL report. Your lordship rejected my bail petition, my lord. In page number 55 is the, my lord, the observation.
Yes.
Only on the ground that, my lord, FSL report is awaited, my lord.
They took the deceased to lonely place and committed the murder by inflicting injuries with knife. Perusal of the postmortem report discloses the incised wound all over the body, and the report regarding cause of death is awaited. Now a report they have given an account of the injuries. FSL report is not reviewed.
After filing FSL report, my lord, I approached to the learned session judge, my lord. But learned session judge, without observation, my lord, without considering my FSL report, my lord, rejected the bail petition of the petitioner, my lord.
Where is that order?
That is, my lord, in page number 23.
23. Reason in.
Without
it was last seen by the complainant with the petitioners.
Opinion that there is no prima facie allegation against the prima petitioner concerned with the statement, so my lord. From the perusal of the material on record that the second bail petition filed on behalf of the accused and that the previous bail petition filed by them rejected, the present bail petition, I do not find any change circumstances except the change charge sheet, my lord. That is the opinion he has given, my lord.
Yes, counsel, appearing for state.
As per the there is an enmity between this accused and deceased man. Both are the husband and wife there. Just so many times there is a panchayati was conducted in Thanda, my lord. So many witnesses, the investigation officer collected who was present at the time of the panchayat, my lord. Both the panchayat, who was the elder member of the Thanda, my lord. They advanced to the this petitioner, my lord. Even also, mainly this complaint is the son of this accused, my lord. Son of this accused, my lord. It shows that the son of this complaint is filed against this accused, my lord. Hence, almost all charge sheet is completed, my lord. Almost charge sheet material witness, investigation officer connected the material witnesses, my lord. As per the statement of witness, as per the medical evidence, it was showed there is against this petitioner, my lord. And as per the primary, as per the evidence of the material witness, this accused petitioner was committing the murder that husband of this petitioner, my lord, along with his relatives.
Who is appearing for the petitioner?
I am for my lord.
FSL report in respect of the bloodstained cloths and bloodstained stick which were seized.
Please note.
We have produced only the cause of death. The FSL report is awaited in the paragraph number 5 of the earlier order. Where is that FSL report?
My lord, your lordship may kindly, my lord,
regarding bloodstains in his cloth.
For a moment, your lordship may kindly, my lord, in page number 42.
42.
Page number 42, my lord, as per column number 17 of the charge sheet, my lord. Last 3 lines, my lord. Last 3 to 4 lines, my lord.
Counsel, 42 is not the 17.
42 is there, my lord. 42, my lord.
Here, ಆಯ್ತು.
Charge sheet. Last 3 to 4 the lines. The allegation against the petitioner. Now the petitioner is accused number 2, my lord. The allegation against him is that, my lord, Sunilanu Vadruniಗೆ ಒತ್ತಿ ಹಿಡಿದು ಚಾಕುವಿನಿಂದ ಕುತ್ತಿಗೆ ಹಾಗೂ ಹೊಟ್ಟೆಯಲ್ಲಿ ತಿವಿದು ಚುಚ್ಚಿ ಭಾರಿ ಗಾಯಪಡಿಸಿದನು. ಚಾಕುವಿನಿಂದ ನೋ ರಿಕವರಿ ಆಫ್ ಚಾಕು ಮೆಲಾಡ್. ಚಾಕು has not been recovered.
That is recovered. That is also recovered. Even bloodstain cloth of the petitioner also recovered.
Knife, my lord, knife has not been recovered.
Huh?
Knife has not been recovered. Your lordship may kindly, my lord, in page number 29. In page number 29, your lordship, what are the recovery is concerned, my lord? What are the, my lord, seized articles? In page number 29, your lordship may kindly, my lord.
29.
29.
What about bloodstain cloth?
Bloodstain cloth is there, my lord.
Cloth of the petitioner.
The allegation, my lord, he has assaulted with knife, but no recovery of, my lord, knife is concerned. No recovery is not there, my lord.
No, knife was recovered, my lord.
29, what are recovered, my lord?
Knife was also recovered, and also the bloodstain cloths also recovered.
My lord, in page number 29, what are the recovery, my lord? These guys. Kallu, stones, my lord. The first is stone, second is stone, my lord. And third is bedige. My lord, 3 plastic glasses. My lord, again, neerin bottle, khali bottle, chappals, my lord. Peri pocket, my lord, Paragon company chappals. That are all recovered, my lord. But the knife is not there, my lord. In the recovery is concerned.
Knife was
Not seized, my
recovered.
lord. Knife has not been seized.
Page number 30, my lord.
30.
Serial number 19, my lord.
Page number 30.
Serial number 19, my lord.
19. ಒಂದು ಅಂದಾಜು 10 ಇಂಚು ಇರುವ ಚಾಕು ಏನ್ರಿ ಇದು?
No, that is
19 ಅಲ್ಲಿ ಇಲ್ವಾ?
Not there in the 29. Well, it has not been sent to the, my lord. It has not been sent to the FSL report, my lord.
ಈಗ not sent for FSL. ತಗೊಳ್ಳಿ. Order the petitioner of counsel and also the counsel appearing for the state. This is the successive bail petition filed by the accused. Earlier, this court rejected the bail petition filed by this petitioner in criminal petition number 201520 of 2021, dated 30th of November 2021. By dismissing the petition, they come to the conclusion that knife as well as bloodstained cloth was seized at the instance of the present petitioner. Hence, this court, while rejecting the bail application, comes to the conclusion that FSL report is not received. But given to the petitioner to approach the court after receipt of FSL report. Now the counsel would submit that final opinion is given. In terms of the final opinion, death due to hemorrhagic shock leading to cardiorespiratory arrest. And no such FSL report is placed before the court. Now the counsel contend that no knife was seized. But in terms of PF, serial number 19, knife was also seized. And knife as well as bloodstained cloths are also sent to the FSL. And when this court already made an observation that FSL report is not received and not placed before the court, liberty is given. Now only producing the final opinion with regard to the cause of death, the petitioner has approached this court. And hence, I do not find any subsequent changes. And no FSL report is received and placed before the court to consider the matter afresh again based on the FSL report. When judging the factual aspects, the case is made out by the petitioner to entertain the successive bail petition. In view of the discussions made up, I pass the following order. Bail petition is rejected.
At least early trial, your lordship may kindly.
FSL ಬಂದ ಮೇಲೆ ಬನ್ನಿ ಅಂತ ಹೇಳಿದೇವ್ರಿ. ನೀವು FSL ರಿಪೋರ್ಟ್ ಹಾಕೋಕ್ಕಿಂತ ಮುಂಚೆನೆ ಯಾವ್ದೋ ಫೈನಲ್ ಒಪಿನಿಯನ್ ಇಟ್ಕೊಂಡು ಬರ್ತೀರಾ? ಏನು
That is the FSL report, my lord.
That is cause of death ರೀ. ಎಷ್ಟು ಸರಿ ಹೇಳ್ಬೇಕು ನಿಮಗೆ? ಬ್ಲಡ್ ಸ್ಟೈನ್ ಕ್ಲಾತ್ ರಿಪೋರ್ಟ್ ಕೊಡ್ರಿ ಅಂತಂದ್ರೆ ಆಗೋದಿಲ್ಲ. ಈಗ ಬಂದ್ ಮತ್ತೆ ಚಾಕು ಸೀಸ್ ಮಾಡಿಲ್ಲ ಏನೆಲ್ಲ. ವೈ ಯು ಆರ್ ವೇಸ್ಟಿಂಗ್ ಟೈಮ್ ಆಫ್ ದಿ ಕೋರ್ಟ್.
It has not been sent for, my lord, the forensic report, my lord.
Serial number 15 ಡಿಸ್ಕನೆಕ್ಟ್ ಮಾಡಿ. ಆಯ್ತು ಹೇಳಿ ಕೌನ್ಸಿಲ್ ಹೇಳಿ. Since 5 years. What is the earlier order for no earlier order? First time. Remaining witnesses? ಆಯ್ತು ರೀ, ಯಾರಾಗ್ಲಿ ಚಿಂತೆ ಏನಾದ್ರು ಒಂದೇ. ಆಯ್ತು, ಈಗ ಎವಿಡೆನ್ಸ್ ಇನ್ನು ಎಷ್ಟು ಜನ ಇದಾರೆ ವಿಟ್ನೆಸಸ್? ಇವ್ರೇನ್ ಸಪೋರ್ಟ್ ಮಾಡಿಲ್ವ ಯಾರು? ಇವರ ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡಿದಾರೆ. ಈಗ ಎಷ್ಟು ವಿಟ್ನೆಸ್ ಮಾಡಿದಾರೆ? 7. ಮೆಟೀರಿಯಲ್ ವಿಟ್ನೆಸಸ್ ಯಾರಿದ್ದಾರೆ? ಡಾಕ್ಟರ್ನ ಎಕ್ಸಾಮಿನೇಷನ್ ಆಗಿದೆ. ಆಯ್ತು, ಡೈರೆಕ್ಷನ್ ಕೊಡೋಣ. 3 months ಅಲ್ಲಿ ಮುಗಿಸಿ ಅಂತ ನೋಡಿ. ಯಾವ ಊರ್ದು ಇದು? ಬೆಂಗಳೂರು. 302 ಏನು 5.5 ವರ್ಷದಿಂದ ಇದಾರಂತೆ. ಯಾವ ವಿಟ್ನೆಸ್ ಸಪೋರ್ಟ್ ಮಾಡಿಲ್ಲ. ತಗೊಳ್ಳಿ ಮೇಡಮ್, ತಗೊಳ್ಳಿ. Basically trial for the offense punishment section 302 302 of IPC. The counsel appearing for the petitioner submits that this petitioner is in custody from 5.5 years, and already trial has been commenced and 7 witnesses have examined before the trial court, including the doctor, and the independent witnesses have not supported the case of the prosecution. And the doctor who has been examined as PW5 deposed with regard to the nature of injuries and also the cause of death is also cross-examined. Keeping him in custody, even though the prosecution witnesses enlarge the petitioner on bail. For count of the counsel appearing for the state that merely because of some of the witnesses have turned hostile, and is not a ground. And CW7, 8, CW7, CW7, 8, 9 and 8, 9 are the eyewitnesses. But in CW7, support the CW7 who has been so also CW8 ಇನ್ನು ವಿಚಾರಣೆ ಆದಂಗಿಲ್ಲ ಆಗಿಲ್ಲ. CW8 and 9 have not been examined before the trial court. Who are the eyewitnesses? ಆಯ್ತ್ರಿ, ಅವ್ರು ಕ್ಲೈಮ್ ಮಾಡ್ತಾರೆ, ಬಟ್ ವಿಚಾರಣೆ ಆಗ್ಬೇಕಲ್ಲ. Touching the factual aspects, the question of enlarging him on bail in a heinous offense, having got the respective counsel and counsel appearing for the state. No doubt, 7 witnesses have already been examined before the trial court, and prosecution also contend that CW8 and 9 also eyewitnesses and also doctor has been examined. Unless the material witnesses are examined, this court in a case for the offense punishment 302, not a case for granting bail, having got the respective counsel and also considering the argument of the petitioner counsel that petitioner is in custody from 2017, and also taking into note of the witnesses who have been already examined as 7 witnesses, it is appropriate to give direction to the trial court to dispose of the matter within a period of 6 months from today. This observation petition is disposed of. 3 months hanga ಆಗ್ತದ್ರಿ, ಅಷ್ಟು ವಿಟ್ನೆಸ್ ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಬೇಕು. ಅದೇ ರೀ, ಅಷ್ಟು ಇನ್ನು 7 ವಿಟ್ನೆಸ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿರೋದು. 7, 8 and 9 ಐ ವಿಟ್ನೆಸ್ ಎಕ್ಸಾಮ್. ಆಯ್ತು, 4 months. Petitioner counsel is absent. Just after here, week after next. Sudarshan, ಹೇಳಿ counsel. ಏನ್ ಮೆಮೊ? ಯಾವ್ದಾದ್ ಮೆಮೊ? ಡಿಸ್ಪೋಸಲ್ ರಿಜಿಸ್ಟರ್ ಅಲ್ಲಿ ಏನೋ ಇದೆ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ ಅದಾ? ಆಯ್ತು ಹೇಳಿ. ನಿನ್ನೆ This is same ground. They are disputing the very same register. ಇದು ಇದರಲ್ಲೂ ಏನಾದ್ರು ಚಾರ್ಜ್ ತಗೊಂಡ ಬಗ್ಗೆ ಏನಾರು ಇದೆಯೇನ್ರಿ? ಚಾರ್ಜ್ ಅಲ್ಲಿ ಇನ್ಕ್ಲೂಡಿಂಗ್ ದಿಸ್ ಆರ್ಟಿಕಲ್ ಯಾವ ಡೇಟ್ ಅಲ್ಲಿ ಚಾರ್ಜ್ ತಗೊಂಡಿರೋದು? ಮೇಡಮ್ ನೆನ್ನೆ ಒಂದು ಸಂಬಂಧ ಮಾಡಿದ್ವಿ ನೋಡಿ. ಚಾರ್ಜ್ ತಗೊಂಡಿದ್ದೆ ಯಾವಾಗ? 6/7/2020. Where in the list whether these items are included or not? Charge ತಗೊಳ್ಳೋದು ನೀವು. On the basis of the superior instructions you have signed. You only took the charge of all these items. Huh? These two items are mentioned. That is they are disputing. Why I can summon him to produce those documents before this court? The document clearly speaks that item number 60 and 70, you took the charge on 6/7/2020 of these two items. Now you are telling that on the instructions of the superiors you took the charge. Procedure, established procedure ಮಾಡಬೇಕು. ಆಯ್ತು 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 ಆಯ್ತು. Heard the petition of counsel and also the counsel to appear for the state. The factual matters of the case of the prosecution is that on 27/2021 at about 4:45 p.m. based on the case has been registered invoking the offence on section 409, 420, resolution 34 of IPC against this petitioner. Based on the complaint of Superintendent of Vigilance, wherein specific allegation is made that on inspection of the godown of the department, 729.690 grams of gold jewels for PD 13 and 1042. Same accused ಒಂದು ಎರಡು ಅವರೇನ್ರಿ? ಸೇಮ್ ಸಿಮಿಲರ್ ಅಲ್ಲ ಮತ್ತೆ ವೈ ಹ್ಯಾವ್ ಟು ಅಗೇನ್ ಸೇಮ್ ಸಿಮಿಲರ್ ಅದೇ ಯಾಕೆಂದ್ರೆ 1042 ಸೇಮ್ ಗ್ರೌಂಡ್ಸ್ ಸೇಮ್ ಆರ್ಡರ್ ರಿಜೆಕ್ಟೆಡ್ ಅಷ್ಟೇ. ಸಿಮಿಲರ್ ಸೇಮ್ ಡಿಫರೆಂಟ್ ಅಕ್ಯೂಸ್ ಅಷ್ಟೇ. ಇವನು A4 ನನ್ನ A3 ಆಯ್ತು. 55 JM ಅನಿಲ್ ಕುಮಾರ್ A15 406 420 489C against him. A15 ಏನಿದ್ದಾರೆ ಅಲಿಗೇಷನ್? Introducer. Commission from whom? Accused number 1. How much he has received? Cash. ಯಾವ ಕ್ಯಾಶ್ ಅದು ಯಾವ್ದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಿದ್ದು? ಫೇಕ್, ನಾಟ್ ಎ ಫೇಕ್ ನೋಟ್. ಇದ್ಯಾವುದೋ ಏನು ಸಿಮಿಲರ್ ಯಾವ್ದೊಂದು ಮಾಡಿದ್ವಲ್ಲ? ಏನಿಲ್ವ ITC ತೋಳಿ. Heard the petitioner, counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution is that the accused persons have indulged in collecting the genuine notes. ಏನ್ರಿ genuine note collect ಮಾಡಿ ಆಮೇಲೆ genuine note and also indulged in manufacturing the fake notes and general public. And allegation against this petitioner is that he used to get the customers. Customers, customers. Doubling the amount of doubling the amount. And this petitioner has received the amount of rupees 5,000. Recovery, fake note recovery 5,000. ಅದೇ ಕಮಿಷನ್ ಅಮೌಂಟ್ ನೀವು ಹೇಳೋದು. And this petitioner used to collect the commission from accused number 1. ಆಮೇಲೆ ಏನ್ ಮಾಡಿದ್ರು 5,000 ಆಯ್ತು. When this petitioner was arrested, an amount of rupees 5 recovered, and hence case registered and note of offense 406. That the alleged recovery is only rupees 5,000. He is not involved in any such acts, even for collecting any amount and also giving back the amount of rupees 18 lakhs. Petition ಅಲ್ಲಿ ಒಂದು ಗ್ರೌಂಡ್ಸ್ ಇಲ್ಲ, ಏನಿಲ್ಲ. ಇಲ್ಲಿದೆ ಗ್ರೌಂಡ್. ಇನ್ ಪೇಜ್ 7 ಡಾಕ್ಯುಮೆಂಟ್ ನಂಬರ್ 1. ಏನಿಲ್ಲ. This petitioner has been arraigned, implicated as accused number 15 without any basis. He is in custody from 12/12/21. Work under the counsel appearing for the petitioner who submits that. The respondent submits that. Respondent state submits that an amount of rupees 5,000 is recovered at the instance of this petitioner commission which has been received from the accused number 1. No other criminal antecedents against this petitioner. Having heard the respective counsel and also on perusal of material, only allegation against this petitioner that he used to secure the customers and also used to get commission, and commission amount of rupees 5,000 is recovered. Then there is no any antecedents against this petitioner. It's a Telecast to exercise the powers and report the create of CRPC conditions. 439 conditions. 56 ಬಸವರಾಜು ಟಿ ಎ ಕೆಂಪೆ ಎಂಕೆ ಇಬ್ಬರು ಇಲ್ವಾ? ಅಮೌಂಟ್ ಅದಕ್ಕೆ ಬಂದಿಲ್ಲ. ದುಡ್ಡು ಎಷ್ಟೋ ಲಕ್ಷ ಅಂತ. ಕಾರಿದು 4 ಲಕ್ಷ. ಹೌದಾ? ದುಡ್ಡು ಕೊಡಿ, ಬೇಲ್ ಕೊಡ್ತೀವಿ, ಕನ್ಸಿಡರ್ ಮಾಡ್ತೀರಿ ಅಂತ ಹೇಳಿದ್ದೆ. ಆಯ್ತು ನೋಡಿ. ಪಿಟಿಷನರ್ ಕೌನ್ಸಿಲ್ ಆಬ್ಸೆಂಟ್. No absent, and hence list this matter week after next. 57 Mohammed Pasha. Charge sheet filed. 17. ಎಂಗೇಜ್ಮೆಂಟ್ ಆದ್ಮೇಲೆ ಫಿಕ್ಸ್ ಮಾಡಿದ್ರಾ? ಮತ್ತೆ ಆಯ್ತು, ಮದುವೆ ಆಗಿದ್ ಯಾವಾಗ ಹೇಳ್ರಿ ಡೇಟು? ಚೆನ್ನಾಗಿ ನೋಡಿಕೊಳ್ಳುತ್ತೇನೆ ಅಂತ ಹೇಳಿ ಬಲವಂತವಾಗಿ ಆಟೋದಲ್ಲಿ ಕರೆದುಕೊಂಡು ಮೆಜೆಸ್ಟಿಕ್ ಬಲವಂತವಾಗಿ ಅರಿಶಿಣ ದಾರವನ್ನು ಹಾಕಿ ಎರಡೂರವರ ಕುತ್ತಿಗೆಗೆ ಕಟ್ಟಿ ಮದುವೆ ಮಾಡಿಕೊಂಡು ನಂತರ ಅಲ್ಲಿಂದ ಆರೋಪಿ ಸಂಭವಕ್ಕೆ ಮಾಡಿರುತ್ತಾನೆ. ಏನ್ರಿ ಇದು? ಮದುವೆ ಮಾಡ್ಕೊಂಡವ್ರ ಬಲವಂತವಾಗಿ ಮದುವೆ ಮಾಡ್ಕೊಂಡು ಏನ್ ಹಂಗೆ ಹೋಗಿ ಕರ್ಕೊಂಡು ಹೋಗಿದಾರ? ನಾಟ್ ವಿಲ್ಲಿಂಗ್ ಫಾರ್ ಮೆಡಿಕಲ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆಲ್ಸೋ. ಏನು ಇಲ್ಲ ಈಗ ಮೆಡಿಕಲ್ ಎವಿಡೆನ್ಸ್ ಇಲ್ವಾ? ತೋಟ್ 164 what she says. I thought. Heard the petitioner, counsel, and also the counsel appearing for the factual matters of the case of the prosecution is that winner accused this petitioner forcibly took the guide Thali in a temple. Of the offense mentioned IPC and section. So also section 10, 11 of also appearing that the petitioner would submit that the is age about 17 years. If the and marriage was in the temple, and counsel in support of his argument also placed the photocopies of the marriage, and no medical evidence that she was subjected to. The victim also for examination. Under the counsel that the victim girl is aged about 17 years, but in one statement, witness says that ಈಗೇನು ಹೇಳ್ತಾರಲ್ರಿ ಮೋಸದಿಂದ ಮದುವೆ ಮಾಡ್ಕೊಂಡವ್ರೆ ಅಂತ ಇಲ್ಲೂ ಹೇಳ್ತಾರ ನೋಡಿ. ಇದೇ ನೋಡ್ರಿ 164 ನೀವೇ ಹಾಕಿದ್ರಲ್ಲ ಪೇಜ್ 14 ಅಲ್ಲಿ. ನನ್ನನ್ನು ಮೋಸಸ್ ನನ್ನ ಮನೆ ಹತ್ತಿರ ಬಂದು ನನ್ನನ್ನು ಕರೆದುಕೊಂಡು ಹೋಗಿದ್ದರು. ಮೆಜೆಸ್ಟಿಕ್ ಹತ್ತಿರ ಒಂದು ದೇವಸ್ಥಾನದಲ್ಲಿ ಮೋಸಸ್ ನನ್ನನ್ನು
state submit will be age about 17 years, but in the 164 statement witness says that
after the marriage only both of them have led their marital life. As a result, she became pregnant. Now she is staying in the house of her mother. Not the respective counsel and also the material on record. It discloses that marriage was solemnized in the temple. Thereafter, both of them have led marital life, and as a result of the same, she became pregnant, and now she is staying in. There is no any medical evidence also with regard to whether she was subjected to sexual act or not. But she also refused to subject for medical examination. When judging the fact, the medical for also the statement of the victim girl says that marriage she became pregnant, and taking into the note of the clear circumstances of the case and subjecting her for sexual act only after the marriage, it is a fit case to exercise the powers from 439 of CRPC. 58 Praveen C. Yes, counsel Praveen Hedri, dismissal on the NDPS ಎಷ್ಟಿದೆ quantum 115 grams of ash oil, 116 grams of ganja. Charge sheet ಆಗಿದೆಯಾ? 4 cases. ಇವನು ಏವನ ಇವನ ಮೇಲೆ 4 ಕೇಸ್ ಅಫೆನ್ಸಸ್ ಏನು? A2 ಮೇಲ ಇವ್ರ ಮೇಲೆ ಏನಿಲ್ವಾ? ಇದರಲ್ಲಿ ಸ್ಮಾಲ್ ಕ್ವಾಂಟಿಟಿ ಎಷ್ಟು? 116. ಕಮರ್ಷಿಯಲ್ ಕ್ವಾಂಟಿಟಿ ಎಷ್ಟು? 10 grams. Third, additional counsel and also the counsel. The factual matters of the case of the prosecution is 9:15 p.m. The complainant has received the credible information regard to trafficking of hashish, and after obtaining the permission, the complainant went along with staff and also the gazetted officer. One person was found where he was On checking his bag, 4 plastic containers found containing hash oil. And weighing the same, it was found to be 216 grams of hash oil and also 415 grams of ganja. Hence, case has been registered and matter is under investigation. The counsel appeal for the petitioner submits that the very seizure itself is doubtful and not complied with mandatory provisions as enshrined under the NDPS Act. The council also submits that the alleged hash oil seized is also intermediate quantity and not the commercial quantity, and ganja is also a small quantity. Hence, he may be enlarged on bail. For counter, the council appeal for the state would submit that the hash oil seized is 216 grams, and also 416 grams of ganja is also seized. And matter is under investigation, and further investigation of the matter, his presence is required. Having heard the respective counsel and also taking into note of the quantum of ganja seized, no doubt it is a intermediate quantity. And ganja seized at the instance of this petitioner is also 416 grams, and the same is also a small quantity, and no other criminal antecedents against this petitioner. When such bring the factual aspects of the case, it is a fit case to exercise powers of 439 of CRPC with conditions. 59, Shashidhara TP.
For the petitioner in this matter, my lordship.
Yes, counsel.
439 petition, my lordship. The offence is under section 309 and 498A. Charge sheet is already filed, my lordship. The same is placed on record as per the direction of this honorable court.
ಆಯ್ತು, ಕಾಪಿ ಎಲ್ಲ ಸರ್ವ್ ಮಾಡಿದಾರಲ್ಲ ಚಾರ್ಜ್ ಶೀಟ್ ಎಲ್ಲ ನಿಮಗೆ ಕೊಟ್ಟಿದೆ, ಫೈಲ್ ಮಾಡಿದಾರ ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ? ಆಯ್ತು, ಹೇಳಿ ಕೌನ್ಸಿಲ್ ಹೇಳಿ.
Lordship,
439 offense ಏನು?
306 498A.
306
and 498A read with section 34, my lordship.
ಆಯ್ತು, 34 ಆಯ್ತು ಹೇಳಿ.
The petitioner is arraigned as accused number 1. Lordship, he was married to the victim, my lordship. The allegation is that he has subjected her to harassment, which has led her to commit suicide, my lordship. As such, no allegation as to the incident that made her to commit suicide is not even alleged in the complaint. As such, my lordship, even in the medical report, no external ligature marks on the body of the victim which would indicate that she was subjected to any form of physical or other kind of harassment, my lordship. As
Date
such,
of marriage, counsel? Date of marriage.
They have been married for 5 years, my lordship. They have a child also, my lordship.
Yes. Any incident on the date of the committing suicide?
No particular incident as such is alleged, my lordship, even in the complaint.
Cause of death, what is the cause of death?
Is filed, my lordship, wherein it is stated.
Hanging entry.
Lordship?
Hanging. He committed suicide in the matrimonial home.
Yes, my lordship.
Is there any on the date of the
allegation is that because it was a love marriage, there used to be some animosity between the members of both the sides of the family. As such, accused number 2
ಬಿಟ್ಬಿಡಿ ಗಂಡ ಹೆಂಡತಿ ಮಾತ್ರ ಹೇಳಿ.
As such, my lordship, no incident is also alleged, my lordship.
ಚಾರ್ಜ್ ಶೀಟ್ ಎಲ್ಲಿದೆ ರೀ? ಪೇಜ್ ನಂಬರ್
Lordship,
additional charge sheet
in the counter yesterday, as per the direction of this honorable court on the last date of hearing.
ಆಯ್ತ್ರಿ, ಎಲ್ಲಿದ್ದಾರೆ ಪೇಜ್ ಹೇಳ್ರಿ ರೀ, ಯಾವ ಪೇಜ್ ಅಲ್ಲಿ ಇದೆ ಹೇಳ್ರಿ. ಒಂದ್ ನಿಮಿಷ 7 ಹೇಳ್ರಿ. ಹೊಡೆದ ಅಂತ ಇದ್ರಲ್ಲಿ ಕಟ್ಟಿಗೆಯಿಂದ ಏನ್ ಇಂಜುರೀಸ್ ಇದೆಯಾ ಕರೆಸ್ಪಾಂಡಿಂಗ್ ಇಂಜುರಿ ಏನಾದ್ರು ಮತ್ತೆ ಕಟ್ಟಿಗೆಯಿಂದ ಹೊಡೆದ ರೇಟ್ ಆಗ್ಲೇಬೇಕಂದ್ರೆ ಎಲ್ಲಿಗೆ ಹೊಡೆದ ಏನು ಇಲ್ಲ. ನೀಡುತ್ತಿದ್ದ ಕಿರುಕುಳದಿಂದ ಬೇಸತ್ತು 4:47ಕ್ಕೆ ತನ್ನ ವಾಸದ ಶೆಡ್ ಮನೆಯಲ್ಲಿ ಸೀಟಿಗೆ ಕಬ್ಬಿಣದ ಪೈಪ್ಗೆ ಸೀರೆಯನ್ನು ಹಾಕಿಕೊಂಡು ಇದು ಮಾಡಿದೆ. ಬೇರೆ ಏನು ಎಕ್ಸ್ಟರ್ನಲ್ ಇಂಜುರೀಸ್ ಏನಾದ್ರು ಇದೆಯಾ ಕರೆಸ್ಪಾಂಡಿಂಗ್ ಓನ್ಲಿ?
Page number 34 of the
ಯಾವಾಗಿಂದ
chart
ಕಸ್ಟಡಿಲಿ ಯಾವಾಗಿಂದಿದ್ದಾನ್ರಿ?
was appended since the date of the incident, my lordship. He is in judicial custody.
23/11. So, heard the petitioner counsel and also the counsel appearing to the state. So the case of the prosecution is that this petitioner had married the victim 5 years ago. In the said wedlock, the victim also gave birth to a child. That on 22/11/21, around 2 p.m., the victim came to house. This petitioner inquired her where she went. She replied that she went in search of the job. And she abused and assaulted with firewood and abused to die and not possible to lead a life with him. Hence, on the very same day at 4:47 p.m., she committed suicide, hanging herself. Based on the complaint, police have registered the case and investigated the matter and filed the charge sheet. The counsel appearing for the petitioner submits that there are no any external injuries except the cause of death of asphyxia as a result of hanging. And the very allegation that he inflicted injury with firewood is not corresponding with any injury in terms of the PM report. The counsel also submits that there is no any material to show that there was a proximity to cause of death and incident. And this petitioner is in custody from 23/11/2021, and investigation has already been completed and charge sheet is filed. For counter, the counsel appearing for the state would submit that specific allegation is made that on 22/11/2021, this petitioner assaulted the victim with firewood, and as a result, she takes step of committing suicide. Having heard the respective counsel and also on perusal of material and particularly on examination of PM report, no corresponding injury with the assault made by the petitioner with firewood. And apart and only cause of death is on account of asphyxia as a result of hanging. Taking into note of and record whether the death is on account of ill-treating the victim and subjecting her for cruelty or not, it is a matter of trial and the same has to be tested in trial. And no corresponding injury. The allegation made against the petitioner injury with inflicting assaulting with firewood on the victim. Telecast excessive powers 439 of CRPC since the petition from 23/11. Investigation has been completed and charge sheet is filed. 61 Samir SL ಹೇಳ್ರಿ. Why it was last time when we heard on directed? ಸೈಟ್ ಮತ್ತೆ ಚಿನ್ನ ಮಾರಾಟ ಮಾಡಿ ಎಷ್ಟು 3,35,000. ವಸ್ತುಗಳನ್ನು ಕೊಟ್ಟಿದ್ದೀರಿ ಅಂತ. ಆಯ್ತು, ತೊಗೊಳ್ಳಿ ಮೇಡಮ್, ತೊಗೊಳ್ಳಿ. Heard the petitioner counsel and also the counsel appearing for the state. The factual matters of the case of the is that this petitioner induced the company to part with the money. The petitioner had promised that is having the scheme to provide vehicle ಮತ್ತೆ vehicle gold and household articles. Also supplied the household articles to the tune of rupees 3,35,000. Collected an amount of rupees 13,75,600. The specific allegation is made that the said amount is paid by selling the property and gold ornaments. It is also alleged that when he demanded an amount of rupees 5 lakhs, they doubted the very act of this petitioner. And when they demanded to repay the amount which he has collected earlier, he did not return the amount and committed an offense of cheating. Under the counsel appearing for the petitioner would submit that the allegation made in the complaint discloses that complainant is a and the very fact of giving an amount of rupees 13,75,600 is not supported by evidence as well as any witness who has seen the transaction giving money to the accused. False allegation is made. The other allegation is that when the not repaid the amount, and hence the very complaint doesn't disclose the committing of any offense section 420 of CRPC. For counter, the counsel appearing for the state who submits that this petitioner had indulged in collecting the money. Only supplied the articles to the tune of 3,35,500 as against 13,75,600 which was received and committed fraud on the complainant. Having heard the respective counsel and also on perusal of material available on record in the complaint itself, the complainant has stated that she has received some articles, household articles to the worth of 3,35,500, and also she made the payment of rupees 13,75,000. And this court directed HCGP to any documents for having sold any property and gold any and also any sold since any gold since the complaint this said specific government is made. And counsel appearing for the state also would submit that when an attempt is made to secure those documents, the complainant also not place any material before the court. Having taken note of the allegation made in the complaint, it clearly discloses that there was a transaction between the complainant as well as petitioner here, and also there was a supply of 3,35,500 rupees gold or household articles, and whether an amount of rupees 13,75,600 paid or not also to be tested in trial. And having taken note of the allegations made in the complaint, it is a fit case to exercise the powers section 438 of CRPC with conditions. 62 Arjun Naika, 63 Jagdisha BN, A17 406 409 420. Last time mena ideno aitala idu andre yado bank okay pass over nodante 67 2 ಆಯ್ತು. 64 B Ravindra 20 B 20B offense for 20B 439 petition. ಏನು ಪ್ರೈಮ್ ಸ್ಟೇಜ್ ಎಷ್ಟಿದೆ? 2 kg ಗಾಂಜಾನ 825. ಏನಾದ್ರು ಕ್ರಿಮಿನಲ್ ಆಕ್ಸಿಡೆಂಟ್ಸ್ ಇದೆಯಾ ಸ್ಟೂಡೆಂಟ್ಸ್? ಕೊಡಿ ತಗೊಳ್ಳಿ. ಜಾಯಿಂಟ್ ರಿಕವರಿನಾ? ಎಲ್ಲಿ ರಿಕವರಿ ಆಗಿದ್ದು? ರೂಮಲ್ಲಿ ಎಲ್ಲ ಏನ ಟ್ರಯಲ್ ಎಲ್ಲರಿಗೂ ಕೊಟ್ಟು ಇವ್ನಿಗೆ ಯಾಕೆ ಕೊಟ್ಟಿಲ್ಲ? ಜಾಯಿಂಟ್ ರಿಕವರಿ ಅಲ್ಲ, ಎಲ್ಲರಿಗೂ ಕೊಟ್ಟು ಇವ್ನಿಗೆ ಯಾಕೆ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ. ಇವನು 439 ಎಲ್ಲ 439 ತೋಳ್ ಏನ್ 2 kg ಚಿಲ್ಡ್ರನ್. Heard the petition of counsel and also the counsel appearing for the state. The actual matters of the case of the prosecution is that on 28/12/2021, credible information was received that this petitioner and other accused persons are indulged in trafficking narcotic drugs and psychotropic substances. And when the raid was conducted, seized 2 kg 825 grams of ganja. And the matter is under investigation. The counsel appearing for the petitioner submits that the accused number 2 to 4 have already been granted bail by the trial court. This petitioner is also in custody from the date of arrest. And he is a student, Nimprakara, a student who is aged about 22 years. And the quantum of ganja seized is also a intermittent quantity, little higher than small quantity. Hence, he may be enlarged on bail and no need of custodial trial, and there is no any criminal antecedents. According to the counsel appearing for the state would submit that 2 kg 825 grams of ganja was recovered in the room from this petitioner and other accused persons. And the presence of the petitioner is required for further investigation. Having heard the respective counsel and also on perusal of material when the joint recovery is made at the instance of this, plus other accused persons and trial court already granted bail in favor of accused number 2 to 4. And apart from that, the quantum of ganja is seized is little higher to small quantity, that is 2 kg 825 grams. And taking into note of the petitioner is a student and also the quantum of ganja, it is a fit case to exercise the discretion in favor of the petitioner. Petitions. Venkat Reddy CM. ಯಾರು petitioner husband distant relative ಏನು ಇವ್ರ ಮೇಲೆ ಏನು ಅಲಿಗೇಷನ್ ಏನು ಇಲ್ವಾ? ಈ ಕೇಸಲ್ಲಿ ಏನು ಹೇಳ್ರಿ? ಈ ಕೇಸಲ್ಲಿ ಏನು 306 ಇನ್ವೋಕ್ ಮಾಡಕ್ಕೆ ಏನ್ರಿ? ಇವ್ರ ರಿಲೇಟಿವ್, ಡಿಸ್ಟೆಂಟ್ ರಿಲೇಟಿವ್. ಪದೇ ಪದೇ ಜಗಳ ಆಗ್ತಿತ್ತು. ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿರೋದ ಹಸ್ಬೆಂಡ್. ಏನ್ರಿ ಏನಿದೆ ರೀ? ಪ್ರಾಕ್ಸಿಮಿಟಿ ಟು ಕಾಸ್ ಆಫ್ ಡೆತ್ ಆಗಿಲ್ಲ. Heard the petitioner counsel and also the counsel appearing for the state. The factual matters of the case prosecution is that on 13/1/2022, the husband of the victim had filed the complaint that there was a frequent galata. Deceased and her relatives. Ravi Kumara. Petitioner and relatives, the petitioner and his wife. There was a civil dispute between them. And also they were giving false complaint against the victim as well as against him. Hence, his wife was depressed in spite of efforts to depression. But on 11/1/2020, she has committed suicide. Based on the complaint, police have registered the case. It is under investigation. The counsel appearing for the petitioner would submit that the very complaint to us that there was a frequent galata between them in connection with civil dispute. So, any taking extreme step of committing suicide. Nancy may be enlarged on that. For part of the counsel appearing for the state would submit that in the complaint specifically stated that there was a frequent quarrel between the victim as well as this petitioner. There is a prima facie material against the petition. Having heard the respective counsel and also taking into note of the contents of the complaint, wherein an allegation is made that they used to frequently quarrel with regard to the civil dispute. And apart from that, on the date of committing suicide, there was no any specific allegation of incident was taken place on the particular date. And such being the case, whether this petitioner abetted the offense of suicide or not is a matter of trial, and hence taking into prima facie it is a bit taking into no prima facie material with regard to the proximity of cause of death as well as except for committing suicide. It is a bit case to exercise the powers for the state of CRPC. 66. Chandraya, Henry. Four not 6, 4 not 9, 420. ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಾ? ಏನ್ ಕೊಟ್ಟಿದೀವ? A1 ಇವ್ರು ಎಷ್ಟನವರು? ಇವನ್ ಮೇಲೆ ಏನ್ ಸೇಮ್ ಅಲಿಗೇಷನ್? ಒಂದೊಂದು ಸೇಮ್. ಯಾವ್ದು ಆರ್ಡರ್ ಏನ ಕಾಪಿ ಇದೆಯಾ ಯಾರು ಕೊಡಿ. ಆಯ್ತು, ಒಬ್ಬನಿಗೆ ಕೊಟ್ಟಿರಿ, ಇನ್ನೊಬ್ರಿಗೆ ಕೊಡದೇ ಇರಕ್ಕಲ್ಲ. ಆಯ್ತು, ಅಲೌಡ್. 67 ಪಾಸ್ ಓವರ್. 67 ಯಾವ್ದು? ಇದು ಹರೀಶ್ ಭಂಡಾರಿ. ಅದೇ ಅಲ್ಲ ಪಾಸ್ ಓವರ್ ಕೇಳಿದ್ದಾರೆ. ಅದು ಎರಡು ಒಂದೇ ಪಾಸ್ ಓವರ್. ಆಯ್ತು ತೋಳಿ. 68 ಆಮೇಲೆ ತಗೊಂಡು ನಾನು ಪಾಸ್ ಓವರ್ ಕೇಳಿದ್ರಲ್ಲ. ಇದೆಲ್ಲ ಬಂದ್ರ ಅವ್ರು ಇದಾರ? ಇದ್ರ ತಗೊಳ್ಳಿ ಹಂಗಾರೆ. ಯಾವ್ದು ಅವ್ರು ಇಲ್ವಾ? ನಿಮ್ದೇ ಅಲ್ಲನ್ರಿ ಹೇಳಿ. ಅವ್ರು ಇನ್ನೊಬ್ರು ಇದಾರ? ಭಂಡಾರಿ ಬರ್ಲಿ ಬಿಡು, ಅವ್ರು ಬರ್ಲಿ, ಒಟ್ಟಿಗೆ ತಗೋಣ. ಆಯ್ತು. 68 69 ರಾಮಕೃಷ್ಣ, ಎ ವಿ ರಾಮಕೃಷ್ಣ ಹೇಳ್ರಿ. ಇದ್ರಲ್ಲಿ ಎರಡು ಕನೆಕ್ಟೆಡ್ ಇದೆಯಾ? ಲತೀಫ್ ಒಂದಿದೆ. ಡೂಪ್ಲಿಕೇಟ್ ಕೀ ಗೀ ಆಯ್ತು. ತುಪ್ಪ ಹೇಳಿ. ಯಾರು? ಹೇಳಿ. ಏನ್ ತಗೋಬೇಕು? ಅದ್ ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ. ಲೈಕ್ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದಾರ ಇಲ್ಲ, ಅವ್ರೇನ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಏನೋ ಕಲೆಕ್ಟ್ ಮಾಡ್ಬೇಕು ಅಂತಾರಲ್ಲ ಏನೋ. ಆಯ್ತು, ಯಾವತ್ತಿಗೆ ಹಾಕ್ಬೇಕು? 28 ಇದೆಯಾ? ಬೇರೆ ಮ್ಯಾಟ್ರಸ್ ಇದೆಯಾ? ನಾಳೆಗೆ ಇನ್ನೊಂದಿದೆ. ತೊಳಿ ಹಾಗಾದ್ರೆ. HCCP submits that one more connected matter is listed on 28th. And hence list these two matters are also on 28th. 70 Lilapi.
Waiting for the respondent.
Good. Again, what is it? Deputy Tahsildar. What is the demand? Oh, this nene here ಮಾಡಿದ್ವಿ ಸ್ವಲ್ಪ ಅದೇ ಮ್ಯಾಟ್ರಾ ಹೇಳಿದ್ವಲ್ರಿ ಇಲ್ಲೇನ 7,50,000 ರಿಸೀವ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಅಂಡರ್ಲೈನ್ ಮಾಡಿಟ್ಟಿದ್ದೀನಿ ನಾನು. ಹಾ ಇದೆಯಲ್ಲ ಇದು. ಹಾ ಈಗೇನ್ ಟ್ರ್ಯಾಪ್ ಆದಾಗ ಎಷ್ಟು ದುಡ್ಡು? 50,000 ಟ್ರ್ಯಾಪ್ ವಿತ್ ಅಮೌಂಟ್. ಡಿಮ್ಯಾಂಡ್ ಎಷ್ಟು? ಟೋಟಲ್ ಡಿಮ್ಯಾಂಡ್
14.5.
ಡಿಮ್ಯಾಂಡ್ ಇದೆ, ಟ್ರ್ಯಾಪ್ ಆಗಿಲ್ಲ. ಇವ್ನು ರಿಸೀವ್ ಮಾಡೋಕ್ ಮಾತ್ರ 50,000 ಟ್ರ್ಯಾಪ್. ಹಾ ಓವರ್ ದಿ ಫೋನ್ ಅಂತ ಆಯ್ತು. ಏನ್ ಕೆಲಸ? ವಾಟ್ ವಾಸ್ ದಿ ವರ್ಕ್ ಪೆಂಡಿಂಗ್ ವಿತ್ ಡೆಪ್ಟಿ ತಹಸೀಲ್ದಾರ್? ಪೊಡಿ ಹಾ ಪೊಡಿ ವರ್ಕ್. ಹಾ ವೈಫ್ ಇಸ್ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಕಂಪ್ಲೇನೆಂಟ್ ವೈಫ್. ಆಯ್ತು. ಹಾ ಡಿಮ್ಯಾಂಡೆಡ್ 1,50,000 ಫಾರ್ ಪೊಡಿ ವರ್ಕ್. ಹಾ ಅಷ್ಟು ಹಣ ಹೊಂದಿಸಲು ನಮಗೆ ಸಾಧ್ಯವಿರುವುದಿಲ್ಲ. ನಮ್ಮ ಬಳಿ ಕೇವಲ 50,000 ಮಾತ್ರ ಇರುತ್ತದೆ. ನಮ್ಗೆ ಲಂಚ ಕೊಟ್ಟು ನಮ್ಮ ಕೆಲಸ ಮಾಡಿಸ್ಕೊಳ್ಳಲು ಇಷ್ಟವಿಲ್ಲ ಅಂತ. ಮೊಬೈಲ್ ಅಲ್ಲಿ ಡಿಮ್ಯಾಂಡ್ ಮಾಡೋರ, ನಾಟ್ ಡೈರೆಕ್ಟ್ ಡಿಮ್ಯಾಂಡ್. ಹಾ ಕಂಪ್ಲೇಂಟ್ I have already read at page number 10. That's all. 18:1. That's all. Yes, counsel.
Yes, my lord. There is a clear demand in the call recordings on 17 and 18 January.
Any call conversation is there?
A conversation has been recorded, but it has not seen produced here, my lord, which has been very clearly mentioned in the trial court order also. So he demands 2.5 lakhs per acre out of for the 3 acres. And the surrounding Ottuvari
2.5 lakhs per acre.
Per acre, 2.5 lakhs. In respect
for
of
what? For what?
For transferring after the death of the father of the complainant to transfer it to Fauti Kate Mandlike.
Fauti Kategene 2.5 lakhs.
2.5 lakhs. And and he also makes an offer that the Ottuvari Bhumi of 2 acre
adjacent land also he will grant.
Yeah, he will grant. For that you give me another 7 lakhs. So total
7 lakhs, 3.5 lakhs each per acre.
Yes, so for total 14.5 lakhs. And he was trapped while paying 50,000 rupees. Investigation is still not completed, my lord.
Heard the petitioner of counsel and also the counsel appearing for the state. The complainant in the complaint dated 18/1/2022 made an allegation in the complaint that the complainant wife is the member of the Grama Panchayati. Spoken to the Deputy Tahsildar with regard to the application given by her. Hence, the petitioner had collected her mobile number and also collected the mobile number of her husband. That on 17/1/2022, the petitioner herein made phone call to the complainant wife at around 5:45 p.m. and asked her to come and meet him. And on that day at 6:30, went and met the complainant, petitioner. And he had promised that he would also grant the land which is adjacent to their land. Demanded an amount of rupees 2.5 lakhs for each acre, in all 7,50,000. Also demanded an amount of rupees 7 lakhs, granting the adjacent land. In all 14,50,000. And insisted to pay an amount of rupees 3,50,000 as advance of 20. So that if amount is not paid, going to reject the application. Recorded. Adene. ಈ ವೇಳೆ ಫಿರ್ಯಾದಿ ಪತ್ನಿ ಅವರ ಸ್ಯಾಮ್ಸಂಗ್ ಮೊಬೈಲ್ ನಲ್ಲಿ this correspondence was recorded in the mobile. Wife. It is also an allegation that on 18/1/22, this petitioner called wife of the complainant several times, insisted to make the payment. And the marriage of the complainant daughter was performed recently and hence expressed inability to pay the amount, and only told that only having an amount of rupees 50,000. And hence the complainant was not having any interest to give bribe amount and hence lodged the complaint. Based on the complaint, police have trapped the petitioner while accepting the amount of rupees 50,000. And the petitioner was taken to custody. The counsel appearing for the petitioner would submit that this petitioner is a government servant, that is a deputy tahsildar, and he is in custody from 18/1/2022, and already the bribe amount was recovered. Alleged bribe amount was recovered, and no need of further custodial investigation. And even he was also suspended from the service, and hence he undertakes to appear before the IVA as well as before the court regularly without any default. Hence he may be enlarged on bail. For counter, the counsel appearing for the case submits that demand was to the tune of rupees 14,50,000 to the favor, and also an application was pending before the petitioner. And in connection with the said application, only conversations were taken place between the petitioner and also the complainant and complainant wife. Content that demanded advance of rupees 3,50,000 are also directed. If they are not makes any payment, he is going to reject the application. Only on collected an amount of rupees 50,000 and he was redundantly trapped while receiving an amount of rupees 50,000. Hence there is a prima facie case, and in order to investigate and file the presence of the petitioner is required. Respective counsel and also the counsel and also the material and record. The material discloses that this petitioner has been trapped and also working as deputy tahsildar, and also not in dispute that application is also pending with him. In this connection, conversation also recorded. And when the factual aspect, demand was made to the tune of rupees 14,50,000, including for grant the adjacent land and other work, and also insisted to pay the advance of rupees 3,50,000. It expressed his inability to pay the amount to that extent. Of his 50,000 is paid as illegal gratification, and he was trapped. Having considered the material on record and also the nature of application and gravity of offences, particularly demand as well as acceptance of rupees 50,000, no doubt when the bribe amount was recovered. Huh?
Amount was recovered.
Madam, last sentence.
I considered the material on record.
Material available on record. The amount of rupees 50,000 was collected, and during the time of collecting the amount, he was trapped. The counsel appearing for the petitioner contend that recording was made by the wife of the complainant in her mobile regarding conversation, and the same is the subject matter of trial. Now, having taken note of the demand and acceptance, and when he was trapped while accepting the amount of rupees 50,000, taking note of the gravity of the bribe amount, it is not a to enlarge him on bail at this juncture unless investigation is completed. It is not a fit case to exercise the powers under 439. In view of the discussions, Madam, I pass the following order. Second, however, liberty is given to the petitioner to approach this court after filing of the charge sheet. 307 ಇದು ಏನು 143. A2 granted bail. What is the ground? What is the ground now against A2? Wicket. ನಿಮ್ಮ ಮೇಲೆ ಏನು? Long on head and hand. Patient, right? Simple in nature. Simple in nature. Even simple in. ಇಬ್ರು ಇದ್ದಾರೆ. You long all ಹೊಡೆದ್ರು injuries are simple in nature. Simple injuries and not taken treatment as inpatient. Hoda? Not the petitioner counsel and also the counsel appearing for the state. That is of the case of the prosecution is that on 24/11/2021 an incident was adidre adne ಮಾಡಬಹುದು madam facts all ade bartade. Having heard the respected counsel and also on perusal of material, a specific allegation is made against these two petitioners. This petitioner is that he inflicted injury with long and victim the simple injuries and also took the treatment as outpatient. And what act allegation made against the other accused that he inflicted injury with wicket on the left hand of the injured Shivaraju, and he had sustained the previous injury, and he had sustained previous injury, and this court already granted bail in favor of the said petitioner with order dated 31st day of January 2022 in single petition 304 of 2022. Having considered the nature of injury sustained by the victims in this case, in view of the assault made by this petitioner is the simple injury and took the treatment as an outpatient, it is a fit case to exercise the powers under 438 of CRPC with conditions. 72. ಅದನ್ನೇ ಆಯ್ತು. 73 Mohammad Umar Farooq.
My lordship, in this case, I may prefer petitioner, my lordship.
Yes, counsel, ಹೇಳಿ.
NDPS Act, my lordship.
ಹೇಳಿ ಹೇಳಿ.
3 kg 236 ಗ್ರಾಮ್ ಗಾಂಜಾ, my lordship. Complaint by the 3 kg 236 ಗ್ರಾಮ್.
ಎಲ್ಲಿತ್ತದು?
ಎಕ್ಸೈಸ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್, my lordship. ಅವನು ಬಸ್ ಸ್ಟಾಪ್ ಅಲ್ಲಿ ನಿಂತಿದ್ದಾಗ ಎಕ್ಸೈಸ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್
bus stop ಅಲ್ಲಿ he was having the bag in which he was having 3 kg 236 grams.
ಹೌದು ಸ್ವಾಮಿ, ಹೌದು ಸ್ವಾಮಿ.
ಏನ್ರಿ? ಇಲ್ಲ thought the petition of counsel and also the state. Credible information conducted the raid at a two-wheeler parking lot near KSRTC bus stand, Guppy town. This petitioner was found in possession of 3.326 kg of ganja containing dry flower and seeds in 3 plastic covers in a college bag. Same as been. ಅದೇನು ಅಫೆನ್ಸ್ ಏನು? ಅದು ಅಫೆನ್ಸ್ ಏನು? ಕ್ರೈಮ್ ನಂಬರ್ ಏನಿಲ್ವಾ? ಕ್ರೈಮ್ ನಂಬರ್ ಏನಿಲ್ಲ ಏನ್ರಿ? ಬೇರೆ ಇನ್ನೊಂದು ಕೇಸ್ ಇದೆಯಾ ಅಂತಲ್ರಿ
ಸ್ವಾಮಿ? ಅದ್ರಲ್ಲಿ ಬೇಲ್ ಆಗಿದೆ ಸ್ವಾಮಿ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲೇ ಬೇಲ್ ಆಗಿದೆ.
ಬೇಲ್ ಆಗಿದೆ ಸರಿ, ಸೇಮ್ ಕೇಸಾ?
ಸೇಮ್ ಕೇಸ್.
ಅದ್ರಲ್ಲಿ ಎಷ್ಟು ಕೆಜಿ?
ಅದರಲ್ಲಿ ಗೊತ್ತಿಲ್ಲ.
Petitioner counsel submits that this petitioner was apprehended on 7/12/21 and from the date of apprehension he is in custody. And the very seizure itself is doubtful and he has been partially. The quantum of ganja seized is also not an intermediate quantity, not commercial quantity, and hence it may be enlarged and bail. For content, the counsel appearing to the state would submit that the seizure of ganja is 3 kg 236 grams at the instance of this petitioner. And apart from that, he is also accused in another similar offense. And he is a habitual offender. Having heard the respective counsel and also on perusal of material available, the seizure from the conscious possession of this petitioner is 3 kg 200 when he was stopped. Having taken note and matter and the matter is under investigation. Having taken note of the quantity of ganja seized is 3 kg 236 grams. Also the other contention that he was also an accused in similar offences earlier. And counsel appearing for the petitioner would submit that he has already been granted bail in the said case. Taking into note of the gravity of the offence and the application, it is a fit case to exercise the powers in section 439 of CRPC. However, in view of the committing of similar offences, petitioner and grant the said case. If the petitioner indulges in committing similar offences, the state is given liberty to seek for cancellation of bail. 41 504 325 ಏನ್ ಮಾಡಿದ ಏನ್ ಅದೇನಿಂದ ಕಚ್ಚಿದನ್ನು ರಭಸಕ್ಕೆ ಎಡಗೈಗೆ ಹೆಬ್ಬೆರಳು ಹುಡುಗು ನರಕ್ಕೆ ತುಂಡಾಗಿ ರಕ್ತ ಗಾಯವಾಯಿತು. ಹೇಳಿ ಲಾಸ್ಟ್ ಟೈಮ್ ಅದೇ ಕಟ್ ಆಗಿದೆ, ಆಂಪುಟೇಷನ್ ಆಗಿದೆ ಅಂತ. ಇದೇನು 438 ಬೇರೆನಾ? ಏನು ಇದೇನು ದಿ ರೀಸನ್ ಫಾರ್ 11 ನೋಡ್ತಾ ಇದ್ದೀನಿ. ಜಗಳ ತೆಗೆದು ಅರ್ಧ ನೀನು ನಮ್ಮ ಅಪ್ಪನ ಬಗ್ಗೆ ಮಾತನಾಡುತ್ತೆ ಎಂದು ಬೈದು ಸಿಟ್ಟಿನಿಂದ ಶಂಕರೇಗೌಡರವರ ಎಡಕೈನ ಹೆಬ್ಬೆರಳಿಗೆ ಬಾಯಿ ಹಾಕಿ ಬಲವಾಗಿ ಹಲ್ಲಿನಿಂದ ಕಚ್ಚಿದನು. ಕಚ್ಚಿದ ರಭಸಕ್ಕೆ ಎಡಗೈನ ಹೆಬ್ಬೆರಳು ಉಗುರು ನೇರಳವಾಗಿ ತುಂಡಾಗಿ ರಕ್ತಗಾಯವಾಯಿತು. ಆಯ್ತು. ಊಟ ಮಾಡಿರ್ಲಿಲ್ಲ? ಎಷ್ಟು ಗಂಟೆ ಇಲ್ಲ ಊಟನ ತಿಂಡಿನ? ರಾತ್ರಿ ಇದ್ದಂಗಿದೆ ಮದ್ಯಪಾನ. ನಮ್ಮೂರಿನ ಒಂಟಿ ಮನೆ ಹರಗುಡಿಸಿದ ಹತ್ರ ಮದ್ಯಪಾನ ಮಾಡ್ತಿದ್ದವು. ಹಾ ಆಲ್ಕೋಹಾಲ್ ಬೇರೆ ಏನು ಕೊಡ್ಲಿಲ್ಲ, ಅದಕ್ಕೆ ಇದನ್ನೇ. ಆಯ್ತು ಆಯ್ತು. Or the petitioner counsel appearing for the state. The factual matters of the case of the prosecution is not on 18/11/2021 at about 7:30 p.m. The complainant and others were consuming the alcohol at that time. This petitioner came to that spot and started quarrel with him. And at that time, this petitioner suddenly hit the, ಯಾವ finger ಅದು? Thumb finger. Thereafter, he went and took the treatment in the hospital. Based on the complaint, police have registered the case. And 4:38 ಇದು. The counsel again to the petition would submit that the very complaint allegation discloses that the complainant himself is started quarrel with the petitioner, and there was no any intention, and suddenly quarrel was taken place, and the same also under the influence of alcohol. Submits that this petitioner suddenly bitten the thumb. As a result, the same is amputated. And there is a prima facie case against the petitioner here. Having heard the respective counsel and also considering the material available on record and also the circumstances under which incident was taken place, complainant himself went to the spot where the between them. Gravity of the offense and nature of injuries. The petition is allowed with conditions directing the petitioner to cooperate with IO. Sir, any civil suit is pending. According to you, RTC stands in the name of these petitioners. Next. ಏನ್ರಿ? But the petitioner, counsel, and also the counsel appearing for the state. The factual matters of the case of the prosecution is that the civil dispute between the parties in respect of survey number 1/81, the extent of 0.81 acre of land. And complainant is cultivating the said land, and that on 30/21 at around 3 p.m. All these petitioners trespassed the land of the complainant and destroyed the 500 recoconate trees worth of rupees 2 lakhs. Hence cases and cases been and the asked to the tune of ಇದು 2 ಲಕ್ಷ ರೂಪಾಯಿ ಮೌಲ್ಯದ ಹಣ್ಣು ಡಿಕೆಗಳನ್ನು ಅಡಿಕೆನೆ ಕಿತ್ತಿದ್ದಾರೆ ಅಂತನಾ? ತೊಳಿ ಏನಾಯ್ತು ಮೇಡಮ್? ಅರೆಕನಟ್ ನಾಟ್ ಪ್ಲಾಂಟ್ ಪ್ರವೇಶ ಮಾಡಿ ಇದನ್ನ ಹಾಕ್ಲಿ ಪ್ಲಕ್ಡ್ ದಿ ಅರೆಕನಟ್ ಟು ದಿ ಎಕ್ಸ್ಟೆಂಟ್ ಆಫ್ 2 lakhs rupees. And also caused the damage to the to the tune of rupees 20,000. Counsel appearing for the petitioner would submit that these petitioners have been falsely implicated in the case and no such incident is taken place. And apart from that, counsel would submit that who is residing at Udupi? Petitioner number 4. Petition number 4 is residing at Udupi, and other ladies of the family also included in the complaint with an intention to harass the petitioners. The court, the very conditions that may be imposed and hence they may be lodged on bail. For counter, the counsel appearing for the state something the petitioner counsel also placed the RTC extract to show that the RTC extract in respect of 1 acre 81 cents of land standing in the name of the petitioners and civil dispute is pending. For counter, the counsel appearing for the state would submit that the complaint is very specific that they have trespassed the land as well as they have caused the damage to the areca crop worth of rupees 2 lakhs and also fencing 20,000. Filed under 438 of CRPC and hence they have not made out any case to invoke section 438 of CRPC. Having heard the respective counsel and material on record, the specifically that there is a dispute in so an allegation that they have trespassed and plucked the areconet to the worth of rupees 2 lakhs, and the same is a matter of trial. And having considered the offences alleged in the complaint as well as the gravity of the offence and seriousness of allegations, and also considering the civil dispute between the parties, it is a fit case to exercise the powers under 438 of CRPC with conditions. Jagadish B. and held next trial. ಯಾರಿದು ಜಗದೀಶ್ ಪಿ ಎನ್ ಯಾರು ನಿಮ್ದೆ ಎಂಟ್ರಿ ಇದು 76 454 457 318 411 411 ಇನ್ವೋಕೆ ಮಾಡಿಲ್ಲಲ್ಲ ಹಾ ಏನ್ ಹಾಕಿದಾರೆ ಪೇಜ್ ನಂಬರ್ 16 ಹಾ FIR is not an accused. Remand ಅಲ್ಲಿ ಅದರ ಸ್ಪೆಸಿಫಿಕ್ ನೀವು ಹೇಳಿ ಈ ಅಕ್ಯೂಸ್ ಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಪ್ರಮೋದ್ ಆರೋಪಿ ಪ್ರಮೋದ್ ಎಂಬುವನನ್ನು 17 ಗಂಟೆಗೆ ದಸ್ತಗಿರಿ ಕ್ರಮವನ್ನು ಜರುಗಿಸಿ ದಸ್ತಗಿರಿ ಮಾಡಿದ ಬಗ್ಗೆ ಆತನ ರೂಮ್ನಲ್ಲಿದ್ದ ಜಯಶ್ರೀ ಎಂಬುವರಿಗೆ ಮಾಹಿತಿಯನ್ನು ನೀಡಿ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯದ ಆದೇಶ ಮಾಡಲಾಯಿತು. ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಏನು ಇನ್ಮೇಲೆ ಪ್ರಮೋದ್ ಎಂಬುವರನ್ನು ವಶಕ್ಕೆ ಪಡೆದು ವಿಚಾರಿಸಿದಾಗ ರಾಜನ್ ಚೆನ್ನತಂಬಿ ಎಂಬುವರು ಇವರ ಕೇರಳ ಲಕ್ಷ್ಮಿ ಮೆಸ್ ಎಂಬ ಹೆಸರಿನ ಕ್ಯಾಂಟೀನ್ ನಲ್ಲಿ ಅಡುಗೆ ಕೆಲಸ ಮಾಡ್ತಿದ್ದರು. ಹೆಚ್ಚು ರಜೆ ಮಾಡುತ್ತಿದ್ದ ಕಾರಣ ಆತನ ಕೆಲಸದಿಂದ ತೆಗೆದಿರುತ್ತಾನೆ. This man in this, Andre, he is the receiver and also he pledged it with the Manapuram Finance. ಇವನು ಅರೆಸ್ಟ್ ಆಗಿದ್ದಾನಾ? ಏನು 27/11 ಏನ್ರಿ it attracts ರಿಕವರಿನ ಮಾಡಿದಾರ, ರಿಕವರಿನೂ ಆಗಿದೆ. ಬೇರೆ ಏನಾದ್ರು ಕೇಸ್ ಇದೆ ಅಂದ್ಮೇಲೆ ಓನ್ಲಿ ಇನ್ ದಿಸ್ ಕೇಸ್ ಮಾತ್ರ ರಿಸೀವರ. There are 3 cases. All the cases is the receiver. ಮತ್ತೆ ಇವನು ಗೊತ್ತಿದ್ದು ಇವನು ಇದೇ ಕೆಲಸ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತಾನ. ಏನ್ 18 ಹೇಳಿ, ಅದು ಇದೆಯಲ್ಲ 208 grams. ಹೇಳಿ. ಆಯ್ತು, ಅವ್ನ್ ಮಾತ್ರ ಚಾಣಾಕ್ಷ ಅಂತ. ಅವ್ನ್ ಚಾಣಾಕ್ಷ ಆಗೋ ಹೊತ್ತಿಗೆ ಇಲ್ಲಿ ತಂದು ಕೊಡೋದು. ಆಯ್ತು. ಆರ್ ದಿ ಪಿಟಿಷನರ್ ಕೌನ್ಸಿಲ್ ಅಂಡ್ ಆಲ್ಸೋ ದಿ ಕೌನ್ಸಿಲ್ ಆಫ್ ಸ್ಟೇಟ್ ಕಂಡೀಷನ್ ಹಾಕೋಣ. ಮತ್ತೆ ಏನಾರು ರಿಸೀವ್ ಮಾಡಿದ್ರೆ ಕ್ಯಾನ್ಸಲೇಷನ್. ಮೇಡಮ್, the factual matter of the case of the prosecution is that 14/2/2021 the complainant left the house. That on 15/2/2021 comes to know that some miscreants breaking open the lock entered inside the house and gold ornaments weighing 8 grams. Also, quote of rupees 1,50,000. The counsel appearing for the petitioner would submit that this petitioner is not an accused in the FIR, but subsequently, when he was arrested, implicated as accused number 2, and he is the receiver of the stolen article. And also, he bets the same with the Manappuram Finance. Except that allegation, there are no any allegations. And offense under section 411 at 12 attacks against him. Hence, he may be enlarged and bail. For counter, the counsel appearing for the state would submit that immediately after the arrest of this petitioner, a recovery is also made, and there were 3 cases against him, and he is the habitual offender. He used to receive the stolen articles, used to pledge the same with the Manappuram Finance, and hence he is not entitled for bail. Having heard the respective counsel and also considering the material, he is not the part of the committing the offense of 144, 7 and 480 of IPC, but he is the receiver of the stolen articles. And also there were 3 cases, and it appears that he is regularly receiving the stolen articles and pledging the same with the Manappuram Finance. Having considered the allegation against him, it is a fit case to exercise the powers since he is already in custody from Yavaginda 28/11/2021. No need of custodial trial. However, this court can, in addition, if the petitioner offenses in future, the prosecution can seek for cancellation of bail. Meenakshi M. What is the age of victim? 6 years, sir. Medical evidence ಏನಿದೆ? Not detect. 64 ಮಾಡಿದಾರಾ? ಅದ್ರಲ್ಲೂ ಹೇಳಿದಾರಾ? ಒಪಿನಿಯನ್ ಕೊಟ್ಟಿದ್ದಾರಾ? 6 ವರ್ಷದ ಹೈಮನ್ ನಾಟ್ ಏನ್ ಇಂಜುರಿ ಏನಾಗುತ್ತೆ ಅವ್ರಿಗೆ? ಕುತ್ತಿಗೆ ಹತ್ರ ಏನೋ ತಿವಿದಿರ್ತಾನೆ. FSL ಏನು ಸೈನ್ಸ್ ಇದೆಯಾ? ಅದು ಬಂದಿದೆಯಾ? ತೊಗೊಳ್ಳಿ out the petition of council out the petition of council and also the council appearing for the state. The factual matters of the case of the prosecution is that this petitioner took the victim girl who is aged about 6 years offering chocolate to lonely place. Put his finger to her private part. Hence, invoke the offense punishment from 506, 376 of 5%, section 3 and 4. Is registered and the charge sheet. The council appearing petitioner would submit that case has been registered against this petitioner and this petitioner has not subjected her for any sexual act. Allegation that he inserted finger in her private part. And apart from that, except for the medical doctor that the hymen is not intact, no any report is given that whether she was subjected to sexual act or not. That the 164 statement is also not clear, and also when allegation is made only with regard to he was touching cheeks. Making the statement, she showed, she made the sign in respect to correct part. Yes, there is no any material. So, per contra, the council appearing to submits that victim girl is aged about 6 years. The doctor report is that is not intact. No provisional opinion is given when the victim was subjected to examination. ಎಲ್ಲ ಕೇಸಲ್ಲೂ ಹಿಂಗೆ ಮಾಡ್ತಾರೆ ಡಾಕ್ಟರ್ಸ್ಗಳು. And FSL report also confirms the same. Having heard the respective counsel and also taking into note of the peculiar facts and circumstances of the case, and in the case on hand also an allegation is that this petitioner inserted the finger on the proper part of the victim and not subjected for any sexual act as contended by the petitioner, and also medical evidence also only except hymen not intact. No other opinion of the doctor is available before the court, and apart from FSL report is also not supports the case of the prosecution, and hence it is a case to office the counsel 430. In 439 alla 439 of CRPC, since investigation already been completed and charge sheet is filed. 78 M Shashidhara ಹೇಳ್ರಿ. ಏನೋ 376 ಅಂತಿದೆ. ಈಗ ಅಫೆನ್ಸ್ 468 FIR
A1 is concerned,
Yeah?
earlier 376 and SCST Act is filed.
ಈಗಿದ್ರಲ್ಲಿ ಎಲ್ರಿ ಈಗಿನ FIR ಅಲ್ಲಿ 468, 471, 182, 341, 504, 506 ಅದೇನಾಗಿದೆ ಕನ್ಫ್ಯೂಷನ್. ಇನ್ನೊಂದು ಅರ್ಲಿಯರ್ ಇನ್ನೊಂದು ಕೇಸ್ ಏನಾಗಿದೆ. ಆಮೇಲೆ ಇವ್ರೇನ್ ಮಾಡವ್ರೆ ಫ್ಯಾಕ್ಟ್ಸ್ ಆಫ್ ದಿ ಕೇಸ್ ಹೇಳುವಾಗ ಎಲ್ಲ ಅಫೆನ್ಸಸ್ ಹಳೆ ಕ್ರೈಮ್ ಹೇಳ್ಕೊಂಡು ಕೂತಿದ್ದಾರೆ. ಇದ್ರ ಕೇಸ್ ಬಿಟ್ಟು ಫಸ್ಟ್ ಅದನ್ನ ಹೇಳವ್ರು ಹಳೆ ಕೇಸ್. ಹೌದಲ್ಲ? ಆಯ್ತು ನೆಕ್ಸ್ಟ್ ಹೇಳಿ. ಅಫೆನ್ಸಸ್ ಏನು ಈಗ ಅಲಿಗೇಷನ್ ಏನ್ ನಿಮ್ಮ ಮೇಲೆ FIR ಏನ್ ಮಾಡಿದಿರಿ ತಾ? ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಅರ್ಜಿ ಸಂಖ್ಯೆ ಇತ್ಯರ್ಥ ಸಲ್ಲಿಸಿ ನಾನು ಒಪ್ಪಿಗೆ ಪತ್ರ ಪಡೆದು ಸಹಿ ಮತ್ತು ಹೆಬ್ಬೆಟ್ಟಿನ ಗುರುತು ಹಾಕಿರುವುದಾಗಿ ಫೋರ್ಜರಿ ಸಹಿ ಮಾಡಿ ಸದರಿ ದಾಖಲೆಯನ್ನು ಕರ್ನಾಟಕ ನ್ಯಾಯಾಲಯದ ಜಾಮೀನು ಪಡೆದುಕೊಂಡಿರುತ್ತಾನೆ. ಸೀರಿಯಸ್ ಅಲಿಗೇಷನ್ಸ್ ಇದೆಯಲ್ರಿ. ಒಂದನೇ ಆರೋಪಿತನಿಗೆ ಮೈಸೂರು ಕೋರ್ಟ್ ನಲ್ಲಿ ಜಾಮೀನು ರಿಜೆಕ್ಟ್ ಆಗಿದ್ದು ಅಲ್ಲ. ಆಮೇಲೆ ಬೇಲ್ ತಗೊಳ್ಳುವಾಗ ಇಲ್ಲೆಲ್ಲ ಫೋರ್ಜರಿ ಡಾಕ್ಯುಮೆಂಟ್. ಈಗ A1 ಹಾಕಿಲ್ವಾ? A1 ಇದಾನ ಇಲ್ಲಿ. ಅವನ ಮೇಲೆ ಸೀರಿಯಸ್ ಇದೆಯಲ್ಲ. ಹಾ
ಸೆಷನ್ಸ್ ಕೋರ್ಟ್ ಅಲ್ಲೂ ಸೇಮ್ ಕಾಪಿ ಹಾಕಿದೆ. ಅದೇ ಅದು ರಿಜೆಕ್ಟ್ ಆಗಿದೆ. ಅದನ್ನ ನೋಟ್ ಮಾಡಿದ ಅದೊಂದು ಪಾರ್ಟಿ ಮಾಡಿದ 27 ಇಯರ್ಸ್ ಇಲ್ಲ. ಅದು ಪ್ರಾಮಿಸ್ ಟು ಮ್ಯಾರೇಜ್.
ಈಗ ಅದ್ ಬೇಡ ನಮಗೆ.
ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ನೋಟಿಸ್ ಸರ್ವ್ ಆಗಿದೆ. ಕಾಪಿ ಹಾಕಿದ್ದೀವಿ. ಕಾಪಿ ಹಾಕಿದ್ರೆ ಸರ್ವ್ಡ್ ಬಟ್ ನಾಟ್ ರೆಪ್ರೆಸೆಂಟೆಡ್ ಬೈ ದಟ್.
ನಾನು ಗುಜರಿ ಬಳಿ ಇರುವ ಚಾಮುಂಡೇಶ್ವರಿ ದೇವಸ್ಥಾನದ ಬಳಿ ಹೋಗುತ್ತಿದ್ದಾಗ ನೋಂದಣಿ ಕ್ರಿಯೇಟ್ ಕಾರ್ನಲ್ಲಿ ರಾಕೇಶ್ ಯಾದವ್ ಅಡ್ಡಗಟ್ಟಿ ಚಾಕು ತೋರಿಸಿ ನೀನು ನೀಡಿರುವ ದೂರನ್ನು ವಾಪಸ್ ತೆಗೆದುಕೊಂಡು ಇಲ್ಲದಿದ್ದ ರೌಡಿಗಳನ್ನು ಬಿಟ್ಟು ನೀನು ಕೊಲೆ ಮಾಡುತ್ತೆಂದು ಅವರ ಶಬ್ದ ನಿಂದಿಸಿ ಬೆದರಿಕೆ ಹಾಕಿರುತ್ತಾರೆ. ಅಲ್ಲದೆ ದಿನಾಂಕ 4/9 ಶನಿವಾರ ಮಧ್ಯಾಹ್ನ 12 ಗಂಟೆ ಸಮಯಕ್ಕೆ ನಾನು ಚಾಮರಾಜಪುರಂ ಸ್ಟೇಷನ್ ಬಳಿ ಹೋಗುತ್ತಿದ್ದಾಗ ರಾಕೇಶ್ ಯಾದವ್ ಎಂಬುವರು ಕೆಂಪು ಬಣ್ಣದ ಆಕ್ಟಿವಾ ಗಾಡಿಯಲ್ಲಿ ನನ್ನ ಬಳಿ ಬಂದು ನನ್ನನ್ನು ಅಡ್ಡಗಟ್ಟಿ ನೀನು ಠಾಣೆಗೆ ನೀಡಿರುವ ದೂರನ್ನು ವಾಪಸ್ ತೆಗೆದುಕೊಂಡಿದ್ದರೆ ನೀನು ಮುಖಕ್ಕೆ ಆಸಿಡ್ ಹಾಕುವುದಾಗಿ ಬೆದರಿಕೆ ಹಾಕಿರ್ತಾರೆ. ಆಯ್ತು ಆಯ್ತ್ರಿ ಇದಾಯ್ತು. ಆಮೇಲೆ ಈಗಿನ ಅಫೆನ್ಸ್
ಡಾಕ್ಯುಮೆಂಟ್
ನೀವೇನ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕರ್ನಾಟಕ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನೋ ಫೋರ್ಜ್ ಮಾಡಿ ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ಟಿದ್ರಿ ಅಂತ.
ಸೇಮ್ ಡಾಕ್ಯುಮೆಂಟ್ ಸೆಷನ್ಸ್ ಕೋರ್ಟ್ ಆಲ್ಸೋ ಅದರೊಳಗೆ ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿದೆ ಕೇಸಿನ ಅಲ್ಲಿ. And payment was received by the victim earlier. 376 earlier coming to marriage and received by the victim girl. Thereafter 376 is filed by the victim girl. In that regard except A1 other cases granted by the lawyer court. A1 approach this are before.
ಅದಾಯ್ತ್ರಿ. ಹಳೇದ್ ಬಿಟ್ಬಿಟ್ಟು ಈಗಿಂದ ಹೇಳ್ರಿ. ನೀವು ಅದೆಲ್ಲ ಹಳೇದ್ ಹೇಳ್ತಾ ಇದ್ರಿ. ಈಗಿನ ಬಿಟ್ಟು ಈ ಕೇಸಿಂದ ಹೇಳಿ.
ಈ ಕೇಸಿಂದ ಆ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ ನಾವು ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಅವ್ರು
ಕಂಟೆನ್ಷನ್.
But it was given by the trial court also mentioned and high court also mentioned.
ಆ FIR ಯಾವಾಗ ಆಗಿದ್ದು?
ಅದು FIR is 2020
ನವೆಂಬರ್ 2020 ಅಲ್ಲಿ ಏನೋ ಕೊಟ್ಟಿದೀವಿ ಬೇಲ್.
28 2020 2 years back. That is very also in last page. In page 38.
ಅದೇನೋ ದುಡ್ಡು ತಗೊಂಡು ಆಮೇಲೆ ಏನೋ ಕನ್ಸೆಂಟ್ ಕೊಟ್ಟು ಏನೋ ಮಾಡಿದ್ರು ಅಂತ. Heard the petitioner counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution is that the accused number 1, when the bail petition was rejected in respect of crime number 35 of 2020, had opposed this by filing criminal petition number 4 of 20, wherein he has produced the consent letter. The document is not executed by the complainant. The signature obtained the bail. On 26/7/21 also he was proceeding near the Chamundeshwari temple. The other accused persons restrained her and showed out the knife, and threatened to invoke the earlier complaint, or otherwise they are going to take away the life with the language. That on 4/9/21 again, this petitioner came in one petition, first petition, that is first petitioner came in the two-wheeler, restrained him, and again threatened that if he fails to take back the complaint, going to pour the acid. Based on the complaint, police have registered the case. The matter is under investigation. The counsel appearing for the petitioner who submits that the complainant has indulged in filing a false complaint. There also case crime number 35/2020 is registered invoking the offense punishment. CST. ಈಗ SST ಇದ್ರಲ್ಲಿ ಇಲ್ಲಲ್ಲ? ಇಲ್ಲ. ಆಯ್ತು. Already this court granted bail in criminal petition number 4766 of 2020. Once again, the false complaint is filed against this petitioner, and no such incident is taken place, either causing any threat or abuse. And allegation of fabrication of document is also a matter of trial. The state would submit that the serious since earlier complaint 376 was invoked, and hence the petitioners are causing the not in one occasion, in several occasions threatened. Hence there is a prima facie case. Having heard the respective counsel and also on perusal of material available on record, and also taking into note of earlier claim number 35/2020, wherein this court already granted bail with order dated 2020 based on the complaint filed by the present complainant. And apart from that, one more complaint is filed making an allegation that causing life threat and abuse in a filthy language. And hence, having considered nature of allegation and gravity of the offense alleged in this complaint, it has to exercise the powers and support the state of CRPC with conditions. 79. Aita 80. Nehru P. Absent. Idara? ಇದರಂటే ನೇರು ಹೇಳ್ರಿ ನೇರು
Milord. Yeah. The offenses is 376 subclass 2 and 6 of your POCSO Act, Milord.
ಏನು ಮಾಡ್ತೀರಾ ಅಥವಾ ಟೈಮ್ ಬೇಕು?
ಅಲ್ಲ ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ, ಎಲ್ಲ ಆಗಿದೆ, ಏನಿಲ್ಲ. ಅದು ಏನೋ ಸ್ವಲ್ಪ ಸ್ನ್ಯಾಗ್ ಆದ್ರಿಂದ ಐ ಕುಡ್ ನಾಟ್ ಇಮಿಡಿಯೇಟ್ಲಿ ರಿಪ್ಲೈ. Milord, the petition under section 439 of CRPC, Milord. The petitioner is innocent of the alleged offences. Is relative of the complaint, Milord. Complaint aged about 16 years.
ಏನ್ ಮೆಡಿಕಲ್ ಎವಿಡೆನ್ಸ್ ಏನೋ ಇದೆಯೇನ್ರಿ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅವಳೆ 164 ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಯಾರೋ ಸಮ್ ಅನ್ನೋನ್ ಪರ್ಸನ್ಸ್ ಹ್ಯಾವ್ ಟೇಕನ್ ಮೀ ಟು ಸೈಡ್
164 ಸ್ಟೇಟ್ಮೆಂಟ್ ಇದೆ, ಹಾಕಿದಿರಾ?
ಇದೆ ಸ್ವಾಮಿ, ಅದರಲ್ಲಿ ನಾನೇ ಹಾಕಿದ್ದೀನಿ, ಪೇಜ್ ನಂಬರ್ 30.
ಪೇಜ್ ನಂಬರ್ 30 ಅಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರಲ್ಲ ಅವಳು?
ಅದೇ ಅದು ಸಮ್ ಅನ್ನೋನ್ ಪರ್ಸನ್, ನಾನು ವೆನ್ ಶಿ ವಾಸ್ ಅಲೋನ್
ಹೊಲಕ್ಕೆ ಹೋಗಿದ್ದು, ಹಿಂದೆ ಹೊಲಕ್ಕೆ ಹೋಗಿದ್ದು, ಆಗ ಸಮಯ ರಾತ್ರಿ ಆಗಿತ್ತು. ನಮ್ಮ ತಂಗಿ ಮನೆಗೆ ಹೋದ್ರೆ ನಮ್ಮ ತಂದೆ ನಮ್ಮನ್ನು ಕುಟಕ್ಕೆ ಹೊರಗಡೆ ಮೇಯಿಸಿ ಹೋಗ್ತಿದ್ದು. ಸರಿ, ನಮ್ಮ ತಂದೆ ಹೋಗಿದ್ದು ಎಷ್ಟು ಹೊತ್ತು ಬಂದು ಗೊತ್ತಿಲ್ಲ. ಆ ಸಮಯ ನಾನು ಒಬ್ಬಳೇ
ಅದೇ because they were in love when the family has not consented for love. ಅವಳು ಸುಮ್ಮನೆ ಇವನು the complaint is filed at page number 15.
Identification ante unknown persons ಅಂತಲ್ಲ, ಹೇಗಾಯ್ತು ಮತ್ತದು ಐಡೆಂಟಿಫಿಕೇಶನ್?
ಅದೇ ಮನೆಯಲ್ಲಿ ಹೇಳಿದ್ರು ಬೈತಾರೆ ಅಂತ ಹೇಳಿ she had named the petitioner Milord. In fact, petitioner and she was in love, which was not accepted by her parents. ಅದೇ ಯಾರ ರೀಸನ್ ಅಂತ ಹೇಳಿದಕ್ಕೆ ಸುಮ್ಮನೆ she has named.
ಏನು ಹೆಸರು ನೀವು? ಪ್ರವೀಣ್.
ಪ್ರವೀಣ್ ಸ್ವಾಮಿ.
ಗಣೇಶ್ ಅಂತಾನೆ ಇದು. ಪ್ರವೀಣ್ ಅದು
ಪ್ರವೀಣ್
ಏನ್ರಿ ಇದು 164 ಇಸ್ ನಾಟ್ ಫರ್ಮ್ ಅಬೌಟ್. ಸರಿ ರೀ, ಮೇಲೆಲ್ಲ ಯಾರೋ ಅನ್ನೋನ್ ಪರ್ಸನ್ಸ್ 2 ಪರ್ಸನ್ಸ್ ಅಂತ ಹೇಳ್ತಾಳೆ, ಕೆಳಗಡೆ ನಾನು ಅವ್ನ ಇಷ್ಟ ಪಡ್ತಾ ಇದ್ದೆ, ಅವನು ನನ್ನನ್ನು ಇಷ್ಟಪಡ್ತಿದ್ದ, ನಾನು ಆತನನ್ನು ಇಷ್ಟಪಡ್ತಿದ್ದೆನು, ಆದ್ರಿಂದ ನಾನು ಹೆದರಿಕೊಂಡು ಆತನೇ ಇದಕ್ಕೆಲ್ಲ ಕಾರಣ ಎಂದು ಹೇಳಿದ್ದೆ. ಮತ್ತೆ ಹಿಂಗ್ ಬೇರೆ. ಆಮೇಲೆ ನಂತರ ನಾನು ಪ್ರೆಗ್ನೆಂಟ್ ಆಗಲು ಅವನೇ ಕಾರಣ ಎಂದು ನಮ್ಮ ಅಜ್ಜಿ ಆತನ ಮೇಲೆ ನಾನು ರಾಣಿಗೆ ಹೋಗಿ ದೂರು ಕೊಟ್ಟಿದ್ರು ಅಂತ. ಈಸ್ ನಾಟ್ ಶೂರ್ ಅಬೌಟ್ ಹೂ. ಅದೇ ಹೇಳಿದ್ರಿ, ಈಗೇನು ನಿಮ್ ಪ್ರಕಾರ ಏನಿದೆ ಸ್ಟೇಟ್ಮೆಂಟ್? ಡಿಎನ್ಎ ಟೆಸ್ಟ್ ಕಳ್ಸಿದಾರ? ಬಂದಿಲ್ವ ಏನು?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಇದು ಆಮೇಲೆ ಅಬಾರ್ಷನ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅವ್ರ ಪೇರೆಂಟ್ಸ್ ಕರ್ಕೊಂಡು ಹೋಗಿ. ಮೆಡಿಕಲ್
ಅಬಾರ್ಷನ್ ಅಂತಾರೆ, ಡಿಎನ್ಎ ಟೆಸ್ಟ್ ಅಂತೀರಿ, ಕರೆಕ್ಟ್ ಮಾಡಿದ್ರ ಇಲ್ಲ? ಹೌದಾ? ಡಿಎನ್ಎ ಏನ ರಿಪೋರ್ಟ್ ಬಂದಿಲ್ಲ ಇನ್ನು? ಕಳ್ಸಿದಾರಂತಲ್ಲ ಡಿಎನ್ಎಗೆ?
ಆಗಿದೆ ಸ್ವಾಮಿ.
ಬಂದಿಲ್ಲ ಅಂತಾರಲ್ರಿ, ಬರೋ ಚಾನ್ಸಸ್ ಇದೆಯಾ ಏನು?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಇದರಲ್ಲಿ ಅವರೇ ಕೊಟ್ಟಿದ್ದಾರೆ.
DNA report is awaited.
ಪೇಜ್ ನಂಬರ್ 69 ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಮೆಡಿಕಲ್
DNA ಟೆಸ್ಟ್ ಇನ್ನು ಬಂದಿಲ್ಲ ಅಂತಾರ್ರಿ. ನಾವು ಯಾಕೆ ಇನ್ ವ್ಯೂ ಆಫ್ ದಿ ಆಕ್ಟ್
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅವಳು ಅವ್ರನ್ನ ಇದನ್ನ ಪ್ರೆಗ್ನೆನ್ಸಿನ ಅಬಾರ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಪೇಜ್ ನಂಬರ್ 69 ಆಫ್ ಚಾರ್ಜ್ ಶೀಟ್ ಇದೆ ಸ್ವಾಮಿ. ದೇ ಹ್ಯಾವ್ ಟೇಕನ್ ದ ಡಾಟರ್, ದ ಕನ್ವಿನ್ಸ್ ಪೇರೆಂಟ್ಸ್ ಅಂಡ್ ದೇ ಹ್ಯಾವ್ ಅಬಾರ್ಟೆಡ್ ದ ಫೀಟಸ್ ಸ್ವಾಮಿ. ಅದನ್ನ DNA ಏನೋ ಇದಾಗಿ
ಫೀಟಸ್ ಅಬಾರ್ಟ್ ಮಾಡಿದಾಗ್ಲೇನೆ ಕಲೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ. ಅವ್ರು ವೆರಿಫೈ ಮಾಡ್ಲಿ ಏನಾಗಿದೆ ಅಂತ DNA ಟೆಸ್ಟ್ ರಿಪೋರ್ಟ್. HCP seeks time to verify with regard to the DNA report. This matter next week. ಗಣಪತಿ ಭಟ್ ಹೇಳ್ರಿ ಯಾರು?
ಪ್ಲೀಸ್ ಮೈ ಲಾರ್ಡ್.
509 ಕೊಡ್ರಿ, ಏನಿದೆ ಕೇಳೋದು ಇದೆಯಾ ಇದರಲ್ಲಿ?
ಪೇಜ್ 13 ಮೈ ಲಾರ್ಡ್ ಕಂಪ್ಲೇಂಟ್. ಪೇಜ್ 13 ಮೈ ಲಾರ್ಡ್.
ಬಾಕ್ಸ್ ಇದೆಯಾ?
ಹೌದು
7 and 8.
Section 7 and 8 my lord. Allegation is first informant is the mother my lord says her daughter aged 12 years had gone to the shop of the accused. He had kissed her and touched her body parts. This is the complaint. This complaint is dated 27/1/2022. And first complaint last make
ಇದ್ರಲ್ಲಿ ಏನ್ ಮೆಡಿಕಲ್ ಎವಿಡೆನ್ಸ್ ತಗೋತೀರಿ? ಬರೀ ಓನ್ಲಿ ಕಿಸ್ಟಾರ್ ಅಂತ ಇದೆ ಅಷ್ಟೇನೆ, ಅದಕ್ಕೇನ್ ಮೆಡಿಕಲ್ ಎವಿಡೆನ್ಸ್ ತಗೋತೀರಿ?
And incident is date of incident 1/12
went to shop, he kissed her ಅಂತೇನೋ ಇದೆ ಅಷ್ಟೇನೆ, ಅದ್ ಬಿಟ್ರೆ ಬೇರೆ ಏನೇನ್ ಮೆಡಿಕಲ್ ಎವಿಡೆನ್ಸ್ ತಗೋತೀರಿ?
ಅದು after 2 months complaint my lord. That
complaint also adds after ಇದು ಅಂತ 112.
And there was a first complaint lodged in page 30
given on 27/1.
First complaint page 30 my lord. First complaint. First complaint.
ಯಾರಿಗೆ? ಅವಳಿಗ? ವಿಕ್ಟಿಮ್ ಮದರ್ಗ ಅಥವಾ ಯಾರಿಗೆ?
ಮದರ್ಗೆ.
ಆಕೆ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ
ಪೇಜ್ 30 my lord. First complaint.
13 or 30?
30 typed copy, 29 first complaint 29 original copy, certificate copy complaint. She says ನಂ ಕೆಟ್ಟ ದೃಷ್ಟಿಯಲ್ಲಿ ನೋಡ್ತಾ ಇದ್ದ ಅಂತ ಹೇಳಿ ಪೇಜ್ 29.
earlier also the complaint ಆಯ್ತು, ಅದೇನಾಯ್ತು?
ಅಲ್ಲ, ಅದರಲ್ಲಿ ಎಲಿಗೇಷನ್ಸ್ ಇಲ್ಲ. ಆ ಕಂಪ್ಲೇಂಟ್ ನನಗೆ ಕೆಟ್ಟ ದೃಷ್ಟಿಯಲ್ಲಿ ನೋಡ್ತಾ ಇದ್ರು. ಕಂಪ್ಲೇಂಟ್ ಇಸ್ ಸೇಮ್ ಇನ್ಸಿಡೆಂಟ್ 1/12/2021 ಮಧ್ಯಾಹ್ನ ಅಂಗಡಿಗೆ ಹೋದಾಗ ಕೆಟ್ಟ ದೃಷ್ಟಿಯಲ್ಲಿ ನೋಡಿದ್ದಾರೆ, ಕೈ ಸನ್ನೆ ಮಾಡಿದ್ದಾನೆ. ಟು ದಿ ಮದರ್ ಆಶಾ ಸುಜ್ನೇಶ್ 35 years. Page 29 my lords. In this
complaint given by whom re?
Same first informant mother my lord, Asha Zudnesh.
ಅದೇ ಯಾರಿಗೆ ಅವನು ಈ ಮೇಡ್
ಅವಳಿಗೆ ನನಗೆ ಅಲ್ಲಿ ಈ ದಿನ 1/12
ಕಂಪ್ಲೇಂಟ್ ಗೆನೆ. This is the complaint dated 1/12/21.
ಹೌದು, ಫಸ್ಟ್ ಕಂಪ್ಲೇಂಟ್. ಆ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಆಶಾ ಹೇಳೋದು ಅವಳಿಗೆ ಕೆಟ್ಟ ದೃಷ್ಟಿ ನೋಡದ ಅಂತ ಹೇಳಿ. ಆಫ್ಟರ್ 2 months
ಈ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ
ಇದೆ ಸಮ್ ಟೋಟಲ್ ಇಂಪ್ರೂವ್ಮೆಂಟ್ ಮೈ ಲಾರ್ಡ್. ನನ್ನ ಮಗಳು had gone there to check chocolate, he kissed her. Entirely different. Totally
that is 27/1/22.
ಹೌದು, ಡೆಲಿವರೇಟ್ಲಿ ಫಾಲ್ಸ್ ಕಂಪ್ಲೇಂಟ್.
ತೊಳಿ ಈಗ ನೀವು ಅರೆಸ್ಟ್ ಆಗೋಣ?
ಹೌದು, ಈಸ್ ಇನ್ ಕಸ್ಟಡಿ ಆಫ್ ದಿಸ್ ಕಂಪ್ಲೇಂಟ್ ಮೈ ಲಾರ್ಡ್.
Heard the petitioner counsel and also the counsel appearing for the state. Fact, the factual matters of the case of the prosecution is that notice ಜಾರಿ ಆಗಿದೆ ಅಂತ ಬರ್ಕೊಬಿಡಿ ಮೇಡಮ್ ಕಂಪ್ಲೇಂಟ್ ವಿಕ್ಟಿಮ್ ಗೆ. ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ ಅವರು. ಅವರ ಸಬ್ಮಿಟ್ matters of the case of the prosecution is that the dated 27/1/22 allegation that when her daughter went to the shop, the daughter aged about 12 years went to the shop, this petitioner
touched her body and kissed her, my lord.
And when she returned while crying, on enquiry she reveals that he touched her body and kissed her, and he is repeating the same. And also he says that if the same is disclosed to anybody, the same to his mother also, cause the life threat. When the same was questioned, he also made signs, hand signs again, hand signs, and the complaint mode. Complaint was for the police, and the same is numbered as NC number 793 of 21. Petitioner going towards school, he used telling the said incident with the general public. And hence, he has lodged the complaint, and hence he did not give any complaint on 1/12/21, and hence the present complaint is filed. The counsel appearing for the petitioner submits that the very complainant has lodged the complaint on 1/12/21 before the police, making an allegation against this petitioner that he used to make that is, she has visited the shop. Hence, not the complaint. And now she has twisted the contents of the complaint, and in an improvised complaint is given that he committed the offense under Section 8 of POCSO Act. And hence, it is clear that only with the malafide intention the present complaint is filed. Further, the counsel appearing for state also not disputes the fact that earlier complaint was given, making the allegation against this petitioner by the complainant herself, stating that he used to look her in a indecent manner. It is not a dispute that to that effect. And now in the present complaint, different stories stated. The allegation is made against the petitioner that he is subjected her daughter for harassment. We heard the respective counsel and also of material available on record, particularly the complainant counsel relied upon the document of 2021, wherein an allegation is made against the petitioner subject in decent manner. But in the present complaint is filed. In present complaint, the incident dated 1/12/21 only mentioned, but wherein an allegation is made that this petitioner subjected her minor daughter for sexual harassment. I have taken note of the factual aspects of the case and earlier complaint, and particularly the allegations made against this petitioner. It is a big case to exercise the powers in 439 of petitions. 82. Was modern was
Grateful, my lord.
Next counsel note for the report. Huh? ಬಂದಿಲ್ಲ ಅಂತಾರೆ, ಏನೋ ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿಲ್ಲ ಅಂತಾರೆ. ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿಲ್ಲ ಅಂತಾರಲ್ರಿ ಇವರು. ಹ್ಮ್ 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 ಬಟ್ ಅವ್ರೇನು ರೆಕಾರ್ಡ್ಸ್ ಬರ್ಬೇಕು ಅಂತಾರಲ್ಲ, ನೀವು ಕೊಟ್ಟಿದ್ದೀರಿ ಬಟ್ ಅವ್ರಿಗೆ ಸಿಕ್ಸ್ ಟೈಮ್ ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್. ರಾಜು ಸಿ ಏನೇನ್ರಿ ಇದು ಮಂಡೇ ಅಂತ ನಾನ್ ಮಾಡಲ್ಲ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಹಾಕಿದೀನಿ. ನೀವು ಯಾವತ್ತಾರು ಪೋಸ್ಟ್ ಮಾಡಿಸ್ಕೊಳ್ಳಿ, ಆ ಕೋರ್ಟಲ್ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ತಿರೋ ಏನ್ ಮಾಡ್ತಿರೋ ಮಾಡ್ಕೊಳ್ಳಿ. ನಾನು ಐ ವಿಲ್ ನಾಟ್ ಫಿಕ್ಸ್ ದಿ ರೋಸ್ಟರ್ ಟು ದಿ ನೀವು ಕಮಿಂಗ್ ಜಡ್ಜ್, ಆಯ್ತಾ? ಅಲ್ಲಿ ಹೋಗಿ ನೋಡಿ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಹಾಕಿದೀನಿ. ಹೇಳ್ರಿ ಇದೇನು 83 ಸಿಂಪಲ್ ಇಂಜುರೀಸ್ A3, 4, 5 ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ. ಸೆಕೆಂಡ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಅವರೆಷ್ಟು ಅಕ್ಯೂಸ್ಡ್ A1 and 2 ನಾ ಇಂಜುರಿ ಏನ್ರಿ ಸಿಂಪಲ್ ನೋಡಿ. heard the petitioner counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution is that on 17/1/2022 at 11:30 p.m. this petitioner went near the house of complainant and threatened that allowed the complaint through one Abhishek and abused in a filthy language and caused the threat as well as also assaulted. The iron rod. Shelter in the house and went to hospital on 18/1/22 and lodged the complaint. Counsel appearing for the petitioner would submit that a false case has been registered against the petitioners who have been arraigned as accused number 1 to 5 in both the petitions. The allegation that assaulted with iron rod, nature of injuries sustained by them are simple in nature and they were discharged from the hospital on the same day. Hence, 438 438 and 439 of CRPC and no ingredients of offense under section 307 is made out. For counter, the counsel appearing for the state to submit that with an intention to take away the life only inflicted the injury with the iron rod. And though simple injuries are sustained, the court has intention in the offense. I got the respective counsel and also on perusal of material available on record, and particularly the wound certificate. The injuries are simple in nature, sustained by the all the three victims. More ಇದೆಯಲ್ರಿ ಒಬ್ಬನೇನಲ್ರಿ ಇದು ಮೂರಲ್ಲಿ ಮತ್ತೆ ಮೂರ್ ಕೊಡ್ತಿರಲ್ಲ ಯಾಕ್ರಿ? ಅಯ್ಯೋ ರಾಮ. ಒಂದೊಂದು ತಕೊಳ್ಳಿ. Sustained injuries, only simple injuries and already injured or discharged from the hospital and have taken note of the material on record and also the nature of allegation and the seriousness of allegation. Both the petitions are allowed with conditions. ಮಾಡೋಣ, ಮುಗಿಸ್ಬಿಡೋಣ. ಇದಾರ 85 ಅಲ್ಲ 84 ಶಶಿಧರ ಕೊಟ್ಟಿದೀವ. ಇದು ಇವನ್ ಯಾರು? ಯಾವ್ದು ನಂಬರ್ ಕೊಟ್ಟಿದಾರ? ಅದು ಆರ್ಡರ್ ಕಾಪಿ ಇದೆಯಾ? ಕೊಡಿ ಮೇಡಮ್. ಏನಾರು ಇದ್ರೆ ಡೌಟ್ ಇದ್ರೆ ನಾನು ಅಲ್ಲಿ ಹೇಳ್ತೀನಿ. ಆಲ್ರೆಡಿ ಅಲೌಡ್ ಅದು. ಕೇಸ್ ನಂಬರ್ ಕಾಪಿ ಕೊಡಿ, ಅದು ಕಾಪಿ ಕೊಡಿ. ಅರ್ಲಿಯರ್ ಆರ್ಡರ್ ಕಾಪಿ ಅನೆಕ್ಸ್ಟ್ ಮಾಡಿದಾರಂತ, ಅದ್ರಲ್ಲಿ ಅನೆಕ್ಸ್ಟ್ ಮಾಡಿದಾರಂತೆ. ಕೊಟ್ಬಿಡಿ. ನೆಕ್ಸ್ಟ್ ಗವಿಸಿದ್ದಯ್ಯ ಹೇಳ್ರಿ. 326 ಏನ್ ಇಂಜುರಿ? ನೋ ಏನು ನೋ? ಯಾರು ಹೇಳಿರೋದನ್ನ? ಡಿಸ್ಚಾರ್ಜ್ ಆಗಿದ್ದಾರೆ. ಯಾವಾಗ ಹೇಳಿ? ಎಷ್ಟು ದಿವಸ ಇದ್ರು ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಹೇಳಿ? ನಿಮ್ ಪ್ರಕಾರ ಡಿಸ್ಚಾರ್ಜ್ ಆಗಿದ್ದಾರೆ? ಯಾವತ್ತು ಡಿಸ್ಚಾರ್ಜ್ ಆದ್ರು? ಯಾವತ್ತು 16-12 10 ದಿವಸ ಇದ್ರಲ್ಲ ಏನು ನೇಚರ್ ಆಫ್ ಇಂಜುರಿ ಏನ್ರಿ? ಹೆಡ್ ಇಂಜುರಿ ಅಂದ್ರೆ ಫ್ರಾಕ್ಚರ್ ಇರ್ಬೇಕು. 326 ಇನ್ವಾಕ್ ಮಾಡಿದ್ದಾರೆ. Fracture and depressed fracture and what? ಎಲ್ಲಾರನ್ನು ನಿಮಾನ್ಸಿ ತಗೊಂಡೋಗೋರ ಇನ್ನೊಬ್ರು ಅವನು ಸರಿ. ಹೆಡ್ ಇಂಜುರಿನಲ್ಲಿ ಏನು ಸಿವಿಯರ್ ಹೇಳಿ of the respondent, police and lodge the complaint and so civil dispute between the complainant and family accused. There is a specific allegation that they have assaulted the injured and vital part of their body with iron rod and caused grievous injuries. Accused number 1 and 2. Therefore, I am of the view that petitioner is not entitled for his release on the ground of parity. This court has already rejected the bail petition of the accused number 1. And so on, so on. So I am of the view that it is ಆಯ್ತ್ರಿ. ಹೆಡ್ ಇಂಜುರಿ ಇದೆ 438 ಅಲ್ಲಿ ಬಂದಿದ್ದೀರಿ, ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ಹೌದು, ಫ್ರಾಕ್ಚರ್ ಈಗ A1 ಇಲ್ವಾ ಇಲ್ಲಿ ಫೈಲ್ ಮಾಡಿರೋದು A2ನ. A2 ರಿಜೆಕ್ಟ್ ಆಗಿದೆಯಲ್ಲ ಅದೇ ಗ್ರೌಂಡ್ ಮೇಲೆ. ಅವನು ಅಸಾಲ್ಟೆಡ್ ವಿತ್ ಏನು ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಇಲ್ವಾ? A2 ಹೊಡೆದವನೇ ಅಂತ ಟೈಪ್ ಕಾಪಿ. A2 ಯಾರು? ಅವನ ಮೇಲೆ ಏನಂತ ಹೇಳಿದ್ದಾರೆ? ಕೃಷ್ಣಪ್ಪ ಎಂಬರು ನನ್ನ ಬಲ ಕೆನ್ನೆ ಹಾಗೂ ಬಲ ಕೈಗೆ ಬಲಗವಾಗಿ ಹೊಡೆದು ಗಾಯಗೊಳಿಸಿರುತ್ತಾರೆ. ಇವ್ನು ಬರೀ ಕೆನ್ನೆಗೆ ಬಲ ಕೈಗೆ ಮಾತ್ರ ಏನ್ರಿ? ಅಲ್ಲ, ಮತ್ತೆ ಗುಂಪು ಕಟ್ಟಿಕೊಂಡು ಬಂದು ನಮ್ಮನ್ನು ಅತಿ ಕೆಟ್ಟ ಅವಶ್ಯಕತೆಗಳಿಗೆ ಬೈದು ಕಬ್ಬಿಣದ ರಾಡ್ನಿಂದ ಬೇರೆ ಬೇರೆನಾ? ನನ್ನ ಬಲಕೆನ್ನೆ ಹಾಗೂ ಬಲಕೈಗೆ ಬಲವಾಗಿ ಹೊಡೆದು ಗಾಯಗೊಳಿಸಿರ್ತಾರೆ. ಇದ್ಯಾರ್ದು ಸ್ಟೇಟ್ಮೆಂಟ್ ಅದು ಇಂಜೂರ್ಡ್ ಅಲ್ಲ, ಅವ್ನು ಬೇರೆಯವ್ರಿಗೆ ಇವ್ರು ಹೊಡೆದಿದ್ದಾರ? ಬರೀ ಇವ್ನಿಗೆ ಮಾತ್ರ ಹೊಡೆದಿರೋದ? ಕಂಪ್ಲೇನೆಂಟಿಗೆ ಮಾತ್ರ ಹೊಡೆದಿರೋದ? ಅಶ್ವತ್ಥನಪ್ಪನವರ ತಲೆಗೆ ರಾಡ್ನಿಂದ ಬಲವಾಗಿ ಹೊಡೆದಿರುತ್ತಾರೆ. ಬಿಡಿಸಲು ಮುಂದೆ ಯಾವ್ದು ಅಶ್ವತ್ಥಪ್ಪನವರ ತಲೆಗೆ ರಾಡ್ನಿಂದ ಬಲವಾಗಿ ಹೊಡೆದಿರುತ್ತಾರೆ. ಬೇಲ್ ಬೇಕು ಅಂತಂದ್ರೆ ಏನೇನೋ ಹೇಳ್ತಿರಲ್ರಿ. ಆಯ್ತಾಯ್ತು, ಇರ್ಲಿ, ಒಳಗಡೆ ಇರ್ಲಿ, ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕೋರಿಗೆ 438 ಬೇರೆನಾ? ತೋಳಿ ಸೀನಿಯರ್ ಸಿಟಿಜನ್ ಆದ್ರೆ ಇಟ್ಕೊಂಡು ರಾಡಲ್ಲಿ ಎಲ್ಲ ಹೊಡೀರಿ ತಲೆಗೆ ಅಂತಿದೆ. ಸೀನಿಯರ್ Sorry, madam. Heard the petitioner counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution is that on 5/12/2021, the complainant had lodged a complaint stating that on the same day at about 12 noon, passed into their house and again, when the father and mother of the complainant came to the house, some of the accused persons came near their house and abused them in filthy language. Assaulted the complainant on his right hand and also chin, leading the injury. Caused fracture of right hand. It is also an allegation that when his father came to rescue him, they assaulted with iron rod on the head of his mother, caused grievous injury. In the incident, 3 persons have sustained injuries, and hence immediately the injured persons were taken to the Nimans hospital, and the case has been registered. Counsel appearing for the petitioner would submit that the trial court already granted bail in favor of accused number 3 alla 3 to 6. Rejected bail petition of in the on the ground that assaulted the injured and vital part of the body with iron rod. With that, the allegation is against accused number 1 and not against this petitioner. And hence this petitioner is entitled for bail. After the counsel appearing for the state would submit that the specific allegation is made against this accused as well as one. Both of them assaulted with the head. As a result, injured persons were taken to Niman's hospital and total 3 persons have sustained the injuries. And the injuries are also grievous in nature. Having heard the petitioner counsel and also on perusal of material available on record, the specific Court Act allegation is made against this petitioner as well as accused number 1. But to assaulted with iron rod on the head. As a result, there was a fracture. When the injury is inflicted on the vital part of head, and the injured persons were also taken to the Nimans and they took the treatment in the hospital from 6/12/21 and 16/12/21. And it is not a fit case to exercise the discretion under Section 438 of CRPC. 86 Vishruth C. First time. Idara? Yenri? Excessive bail petition. Namundane barbo. What is the change circumstances? This petitioner is accused number 1. Where is the earlier order, rejection order? What is the reason for rejection? Specific allegations are made against accused number 1 and 2 that they have dropped the stone on the head of the victim, and this petitioner number 2, that is accused number 2. Is accused number 2 ಕೊಟ್ಟಿದ್ದೀರಿ ನೀವು? Not only dropped the stone but also cut off the hand of the victim. ಕೈ ಬೇರೆ ಕಟ್ಟಿ ಮಾಡಿ ಎಲ್ಲ ಮಾಡಿದಿರಿ ಅಂತ ಮಾಡಿದ್ವಿ. ಈಗೇನ್ ಚೇಂಜ್ ಸರ್ಕಮ್ಸ್ಟೆನ್ಸಸ್ ಏನು? accused number 2 ಆಯ್ತು ಹೇಳ್ರಿ. Where is the accused number 1 ಹೇಳ್ರಿ? one copy ಕೊಡ್ರಿ. Now 1 is before the court. 1 and 2 nalene accused number 1 dropped the stone on the head of the victim. What is the change circumstance now? Charge has not been framed. Then you keep the accused before the court and I will direct to frame the charge in the next state of hearing. But then why charge has not been framed? The count that charge has not been framed. ಯಾವ್ದು ಹೇಳಿ ಬೇರೆ ಬೇಗ ಹೇಳಿ ಕೌನ್ಸಿಲ್ 5 ಕಾಲು. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ನೋಡೋಣ. ನಾನು ರಿವಿಷನ್ ಅಲ್ಲಿ ಇರ್ತೀನಿ. ಲೀಸರ್ ಆಗಿ ಕೂತ್ಕೊಂಡು ಕೇಳೋಣ. ಆಯ್ತಾ? ಆಯ್ತು. ಯಾವತ್ ಬೇಕು ಹೇಳಿ. ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 2nd of March. 2nd ರಜಾನ? ಫಸ್ಟ್ ರಜಾ ಅಲ್ಲ? 2nd of March. ಆಯ್ತು, ಅವತ್ತು ಹಾಕಿ. Sudarshan L is absent. List this matter the week after. ಎಲ್ಲ ಅರ್ಜುನ್ ಆಗಿದೆ ಅಲ್ಲ? ನೋಡಿ 91. ಸುರೇಶ್ ಎಂ ಚರ್ಮಗೋಲ. ಏನ್ರಿ A13 392. ಏನಾರು ಇದೆಯಾ? ಬೇರೆ ಏನಾರು ಕೇಸಸ್ ಇದೆಯಾ ನಿಮ್ ಮೇಲೆ? 87/21 ನಲ್ಲಿ ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿಲ್ವಾ? 39 ಇದು.
Investigation officer same. Police station consent ಇದೆ. ಅವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ? ಅಡ್ವೊಕೇಟ್ ಮತ್ತೆ ಪೊಲೀಸ್ ಕಮಿಷನರ್ನ ಗಲಾಟೆ ಆಗುತ್ತೆ. ಯಾಕಂದ್ರೆ ಪೆಟಿಷನರ್ ಗೆ ಅವರು ಏನಾಗಿದೆ ಅಂದ್ರೆ ಅವ್ರು ಹೇಳಿದ ಅಡ್ವೊಕೇಟ್
ಜನ ಬಿಟ್ಬಿಡ ಅದ್ ನಾವೆಲ್ಲ ನೋಡೋದ್ ಬೇಡ. ಈಗ ಆಯ್ತು, ಅವ್ರಿಗೇನೋ ಒಂದು ಟೈಮ್ ಕೇಳ್ತಾರೆ ಸೆಕ್ಯೂರ್ ಮಾಡಕ್ ರೆಕಾರ್ಡ್ಸ್ ನೋಡೋಣ. ಆಯ್ತ್ರಿ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೋಣ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ನೋಡಿ HCGP 6 ಟೈಮ್ ಡಿಸ್ಮಿಸ್. ಯಾವಾಗಿದೆ ಅದು? ಹೌದಾ? ಆಯ್ತು, ಯಾವತ್ತಿಗೆ ಬೇಕು ನಿಮ್ಗೆ? ಮಂಡೇಗ? ಬೇರೆ ಕನೆಕ್ಟೆಡ್ ಸೇಮ್ ಕ್ರೈಮಾ? ಡಿಫ್ರೆಂಟ್ ಕ್ರೈಮ್ ಮಾಡಕ್ಕಲ್ಲ. ಒಂದೇ ಕ್ರೈಮ್ ಆದ್ರೆ ಹಾಕ್ತೀನಿ. ಆಯ್ತು, ನೆಕ್ಸ್ಟ್ ನಿಮ್ಗೆ ಎಷ್ಟು ದಿವಸ ಬೇಕ್ರಿ ಸೆಕ್ಯೂರ್ ಮಾಡಕ್ಕೆ? ಒಂದು ವಾರ. ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ ಹಾಕ್ಲಾ? ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ ಎಷ್ಟು ಡೇಟ್ ಮೇಡಮ್? 4th ಮಾರ್ಚ್. ಬನ್ನಿ. ಏನ್ ಪಾಸ್ ಓವರ್ ಬೇರೆ ಇದಾವ? 22 ಏನಕ್ಕೆ 22 ಪಾಸ್ ಓವರ್ ಆಯ್ತು ನೋಡಿ. ಏನಾಯ್ತು? ಅವ್ರು ಬರ್ಲಿಲ್ಲ ಇವತ್ತುವೆ. ಕಾಸ್ಟ್ ಕಟ್ಟಿದ್ದಾರೆ, ಬಟ್ ವೈ ಹ್ಯಾವ್ ನಾಟ್ ಕಂಪ್ಲೈಂಟ್ ಇಟ್ ಮೇಡಮ್? ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ನಾಟ್ ಎಟ್ ಕಂಪ್ಲೈಂಟ್ ಅಂತ ಬಂದಿದೆ. Earlier it was dismissed and the same is restored on payment of cost of ₹5,000. Now cost is paid, but during the scrutiny time objections are raised. You have not complied it. I thought petitioner counsel seeks 1 week time to comply the office objection. Yen recall? Order already recall ಮಾಡಿದೀನಲ್ಲ. Payment of cost ಅಂತ. And already cost has been paid and earlier ಅಲ್ಲಿಗೆ ಸಬ್ಜೆಕ್ಟ್ ಅಂದ್ರೆ ಪೇಮೆಂಟ್ ಆಯ್ತು ಅಂದ್ರೆ ಮತ್ತೊಂದ್ಸರಿ ಮಾಡೋದೇ ಬೇಕಲ್ಲ ಮೇಡಮ್. ಮತ್ತೆ ನಾನು ಆರ್ಡರ್ ಬೇಕು. ಪೇಮೆಂಟ್ ಕಾಸ್ಟ್ ಆಯ್ತು ಅಂದ್ರೆ ಇದು ಆಟೋಮೆಟಿಕ್. ಮತ್ತೆ ವೈ ಅಗೇನ್ ಐ ಹ್ಯಾವ್ ಟು ಪಾಸ್ ಕಂಪ್ಲೈನ್ಸ್ ಅಷ್ಟೇನೆ ಹಾಕ್ಬಿಡಿ. ಅಷ್ಟೇನೆ ನಾನ್ ಕಂಪ್ಲೈನ್ಸಿಗೆ ಪೋಸ್ಟ್ ಆಗಿದೆ ಅಷ್ಟೇ ಇದು. 6 ರಾಜಣ್ಣ ಅಂತ ಇದೆ. ರಾಜಣ್ಣ ತಗೊಳ್ಳಿ. ಪಿಟಿಷನರ್ ಕೌನ್ಸಿಲ್ ಆಬ್ಸೆಂಟ್. early occasion also took time and hence this matter week after next. ಅದು ಅಷ್ಟೇನೆ. ಗೆಟ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಅಂತ ಸೇಮ್ ಆರ್ಡರ್. ವೀಕ್ ಆಫ್ಟರ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಎಲ್ಲರಿಗೂ ಆಮೇಲೆ ಜಾಸ್ತಿ ಆಗೋದು ಬೇಡ. ಅವ್ರಿಗೆ 29 ಇದು ಡಿಸ್ಮಿಸಲ್ ಅಂತ ಇತ್ತು. ಕೊಡಿ ನೋಡಿ. The court in the previous occasion also noted that matter was called twice. However, one more opportunity is given. So made it clear that if the learned counsel for the petition doesn't appear on the next date of hearing, petition will be dismissed for non-prosecution. And when this matter called again twice, today also no representation and hence dismissed for non-prosecution. 35. Chandra Kumaregowda. ಯಾರ್ರೀ ಚಂದ್ರ ಕುಮಾರೇಗೌಡ ಅಂದ್ರೆ? ಕೋಟಿಗೆ ಬರೋ ಅಭ್ಯಾಸ ಇಲ್ವಾ? ಎಷ್ಟನೇ ಮೋಸ್ಟ್ಲಿ ಇವತ್ತೇ ಬಂದಿರೋದು. ನೀವು ಚಂದ್ರಕುಮಾರೇಗೌಡನ? ಮತ್ತೆ ಯಾರು ನೀವು? ವಿಶ್ವನಾಥ್. ಲಾಸ್ಟ್ ಟೈಮ್ ನೋಡಿ ಇದು ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೀನಿ ಅಂತ ಆರ್ಡರ್ ಬಂದಿದ್ದೀನಿ. ಈಗ ಯಾರಿಗೆ ನೀವು ಅಪೇರ್ ಆಗೋದು? ಪಿಟಿಷನರ್. ನಿಮ್ಗೆ ವಕಾಲತ್ ಇದೆಯಾ? ಹೌ ಯು ಮೇಕ್ ದ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್ ಆನ್ ಬಿಹಾಫ್ ಆಫ್ ಚಂದ್ರಕುಮಾರೇಗೌಡ? ಫೈಲ್ ಕೊಟ್ಟಿದ್ದಾನೆ ಅಂದ್ರೆ ನಿಮ್ಗೆ ಕೊಟ್ಟಿದ್ದಾರಾ? NOC ಏನಾದ್ರು ಕೊಟ್ಟಿದ್ದಾರಾ? ನಿಮ್ಗೇನು ವಕಾಲತ್ ಇದೆಯಾ? ಇಲ್ಲ ಅಲ್ಲ, ಮತ್ತೆ ನೀವೇಗ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀರಿ? ಬಿಹಾಫ್ ಆಫ್ ಹೆಂಗ್ರಿ ಮಾಡ್ತೀರಾ ನೀವು? ಆರ್ ಯು ಸೀನಿಯರ್ ಕೌನ್ಸಲ್? ಮತ್ತೆ ಆರ್ ಯು ಸೀನಿಯರ್ ಕೌನ್ಸಲ್? ಈಗ ಯಾರು ಬೇಕಾದ್ರೂ ವಕಾಲತ್ತಾಗ ಯಾರು ಬಂದ್ಬೇಕಾದ್ರೂ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬೋದಾ? ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲ, ಏನಿಲ್ಲ. ಡಿಸ್ಮಿಸ್ ಆಗುತ್ತೆ ಅಂತ ಇವತ್ತು ನಿಮಗೆ ಫೈಲ್ ಕೊಟ್ಟು ಕೂರಿಸಿರ್ಬೇಕು ನೋಡಿ. ಐ ಥಿಂಕ್ ಯು ಆರ್ ಸ್ಟಾಪ್ ಗ್ಯಾಪ್ ಅರೇಂಜ್ಮೆಂಟ್. ಹೌದಲ್ಲ? ಆಯ್ತು. ಆನ್ ಬಿಹಾಫ್ ಆಫ್ ದಿ ಪಿಟಿಷನರ್ ಕೌನ್ಸಿಲ್ ಒನ್ ಕೌನ್ಸಿಲ್ ಶ್ರೀ ಏನೋ ಹೆಸರು ಕೆ ವಿಶ್ವನಾಥ್ ಅಪಿಯರ್ಸ್ ಅಂಡ್ ಸೀಕ್ಸ್ ಟೈಮ್. ಯಾವಾಗ ಬೇಕು ತಗೊಳ್ಳಿ. ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ವೀಕ್ ಆಫ್ಟರ್ ನೆಕ್ಸ್ಟ್. 36 ಹರೀಶ್ ಕುಮಾರ್ HC. ಬೆಳಗ್ಗೆ ನಾವು ಡ್ಯೂ ಟು ಪಾಸಿಟಿವ್ ಆಫ್ ಟೈಮ್ ಅಂತ ತೊಗೊಂಡ್ಬಿಡಿ. ಮ್ಯಾಟರ್ ಇಸ್ ಕಾಲ್ಡ್ ಟ್ವೈಸ್, ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್. This matter week after next.
37. Lakshminarayan Shetty.
In this matter, earlier occasion also took time and no representation when the matter called twice. Week after next. 38. ಎಷ್ಟು ಪಾಸ್ ಓವರ್ ಆಗಿದಾವ್ರಿ? ಸಿರಿಲ್ ಪ್ರಸಾದ್ ಬರ್ಲೇ ಇಲ್ಲ.
Malad, I am appealing for Malad, in this the police invoked that section 498A and 307, my lord. As per the end, we got the information that 307 is dropped by the police. The investigation is completed, my lord, in this matter. So yes, my lord. 307 they dropped the
drop ಮಾಡಿದ್ದಾರೆ. ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದಾರಾ?
Charge sheet, the investigation is completed, my lord. So I am applying for certified copy of
the council would submit that the investigation has been completed and police have filed the charge sheet, and while filing the charge sheet, drop the offense 307 and hence applying for the copy of the charge sheet and 6 time, and hence this matter after 2 weeks. 41 Trivikram. Told in this matter, earlier council took time on the ground of filing the charge sheet. No representation when this matter called twice. This matter week after next. 53. ಏನ್ರಿ ಇದು? ಯಾವ್ದೋ ಒಂದು ಕನೆಕ್ಟೆಡ್ ಮಾಡಿದೀವಿ ಇದ್ರಲ್ಲ ಅದ ಯಾವ ಪಾರ್ಟ್ ಮಾಡಿ ಯಾವತ್ತಾರ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಯಾವ್ದಾರು ಕೇಳನ್ರಿ? ಏನ್ರಿ ಅಲ್ವಾ? ಯಾವ್ದೋ ಒಂದು ಬೇರೆ ನಾನು ರಿಲೀಸ್ ಆಗಿದ್ದಾನೆ ಅಂತ ಅಂದ್ರಲ್ಲ ಅದಲ್ಲ, ಹರ್ಡ್ ಇನ್ ಪಾರ್ಟ್ ಅಂತ ಮಾಡಿ ಮೇಡಮ್. ಅಲ್ಲ ನಾನು ಈಗ ಮಾಡ್ಬಿಡ್ತೀನಿ, ಈಗ ಯಾವ್ದೋ ಕನೆಕ್ಟೆಡ್ ಮಾಡಿದೀವಲ್ಲ, ಹರ್ಡ್ ಇನ್ ಪಾರ್ಟ್ ಅಂತ ಮಾಡೋಣ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ತಗೊಳ್ಳೋಣ. ಅಥವಾ ಬೇಡವಾ ಬೇರೆ ಬೆಂಚ್ ಮುಂದೆ ಹೋಗ್ಬಿಡಿ, ಯಾಕೆಂದ್ರೆ ನೀವೇನೋ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ನ ಹಿಯರ್ ಆಗಿದ್ದೆ ಅಂತ ಯಾರು ಅಂದ್ರು? ಅಲ್ಲ ಕೊಟ್ಟಿದ್ದೀನಿ, ಬಟ್ ಅದೇನೋ ಅದ್ರಲ್ಲಿ ಬರೀ ಓನ್ಲಿ ಅಮೌಂಟ್ ವಾಸ್ ನಾಟ್ ರೀಪೇಯ್ಡ್ ಅಂತಲೇನ ಇತ್ತು. ಅದಕ್ಕೆ ಅದ್ ನೋಡ್ಬೇಕು. ಹೋಗ್ಬಿಡಿ ಬೆಂಚ್, ಹೆಂಗೆ ರೋಸ್ಟರ್ ಚೇಂಜ್ ಆಗಿದೆಯಲ್ಲ. ಹೌದಾ? ಅದೇ ನೋಡೋಣ ಬಿಡಿ ಅವತ್ತು. ಅದಕ್ಕೆ 5:20 ಅದಕ್ಕೆ ಹೇಳಿದ್ದು ತಗೊಳ್ಳಿ ಮೇಡಮ್. ಹರ್ಡ್ ಇನ್ ಪಾರ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಯಾವ್ದಾರು ಒಂದು ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್. ಇನ್ನೊಂದು ಹಿಂಗಾಕ್ಬಿಡಿ. ಅಂಡ್ ಪೋಸ್ಟ್ ಸೀರಿಯಲ್ ನಂಬರ್ 63 and 67 ಇರ್ಬೇಕು. 67 ಅಲ್ಲ 67 and post both the matters together on ಹೌದು. ಯಾವತ್ ಬೇಕು? ಸೆಕೆಂಡ್ ಆಗುತ್ತಾ? ಆಯ್ತು, ಸೆಕೆಂಡ್ ಹಾಕ. Second of March. Post the matter together, arising out of same crime. Same crime. Since both the matters are arising out of same crime. ಮಂಡೆಯಿಂದ ಎಷ್ಟಿದೆ? ಎಷ್ಟು? 9,000 6,000 ಪೆಂಡೆನ್ಸಿ ಕೇಳಿ ನನಗೆ. ಪೋಸ್ಟ್ ಮಾಡಕ್ಕಿಂತ ಮುಂಚೆನೆ ಗೊತ್ತು 6,000 ಇದೆ ಅಂತ ನಮ್ಗೆ. ಗಿವಿಂಗ್ ರೋಸ್ಟರ್ ಇಲ್ಲ 6,000 ಇದೆ ಅಂತಲೇ ನಮ್ಗೆ ಕೊಟ್ಟಿರೋದು. ಸರ್ ಹಾಕಿ ಹಳೆ ಓಲ್ಡ್ ಮ್ಯಾಟರ್ಸ್ ಹಾಕ್ಸಿ. ಓಲ್ಡ್ ಎಲ್ಲ ತೊಳೆಯಲ್ಲ ತೊಳೆಯಲ್ಲ. ಓಲ್ಡ್ ಮ್ಯಾಟರ್ಸ್ ಹಾಕಿ ಫೈಲ್ಸ್ 30 ಇದೆ, ಅಷ್ಟು ಹಾಕಿ. ಅದ್ರ ಜೊತೆಗೆ ಓಲ್ಡ್ ಮ್ಯಾಟರ್ಸ್ ಒಂದ್ ಸ್ವಲ್ಪ ಹಾಕಿ ನೋಡೋಣ ಎಷ್ಟಾಗ ಡೈಲಿ ಎಷ್ಟು ಪೋಸ್ಟ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ ಗೊತ್ತಿಲ್ಲ. ಎಲ್ಲ ಡಿಸ್ಪೋಸಲ್ 6,225 ರಿವಿಷನ್ ಚೇಂಜ್ ಮಾಡುತ್ತೆ. 2009 ಒಂದಿದೆ, 2010 ಒಂದಿದೆ, 2011 23 ಇದೆ, 12 100 ಇದೆ, 1 ಡಿಕೆಟ್ 100 ಇದೆ. ಒಂದ್ 40 ಹಾಕ್ಸಿರಿ. ಆಮೇಲೆ ನೋಡೋಣ ರಿವಿಷನ್ಸ್ ನಾವೆಲ್ಲ ಹಿಂಗ್ ಬೇಲ್ ಪಿಟಿಷನ್ ಮಾಡ್ದಂಗ ಅಲ್ಲ, ಅದು 482 ಮಾಡ್ದಂಗ. ಯಾಕೆಂದ್ರೆ 2 ಜಡ್ಜ್ಮೆಂಟ್ ಆಗಿರುತ್ತೆ, 2 ಜಡ್ಜ್ಮೆಂಟ್ ನೋಡಿ ಮಾಡಬೇಕು. ಜೊತೆಗೆ ಆರ್ಡರ್ಸ್ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಹಾಕಿ, ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಆರ್ಡರ್ಸ್ ಎಲ್ಲ ಹಾಕಕ್ಕೆ ಹೇಳಿ. ಒಂದ್ 40 ಹಾಕ್ಸಿರಿ. ಎಷ್ಟಿರ್ತಾವ ನೋಡಿ. ಆರ್ಡರ್ಸ್ಗೆ ಎಲ್ಲ ಏನ್ ಲಿಮಿಟ್ ಇಲ್ಲ. ಏನಾಯ್ತು ಇದು? ಏನೇನ್ ಮಾಡಿದಾರ? ಸಿಗ್ನೇಚರ್ ಕೆಳಗಡೆ ಹೆಸರು ಬರ್ದಿಲ್ಲ.
ಅದೆರಡು ಟ್ಯಾಲಿ ಆಗ್ತಲ್ಲ ಅಂತ.
Officers raised the following objections. One, the first in offense mentioned in the FIR is a differ from the criminal misdemeanors number 67 of 22. ಅದೇ ಯಾವುದು? ಎರಡು FIR ಗೂ ಇದಕ್ಕೂ ಟ್ಯಾಲಿ ಆಗ್ತಿಲ್ಲ ಅಂತಲ್ಲ. Advocate name to be mentioned below their signature. ಅದು ಬರ್ದಿಲ್ಲ ಅಂತ. ನಾವೆರಡು ಇದಾ ಅಲ್ಲೆಲ್ಲ ಮಾಡಿಸ್ಕೊಂಡು ಮಾಡಕ್ಕಲ್ಲ. ಆಯ್ತು ನೋಡಿ ಕಳ್ಸಿ ಅಡ್ಮಿಷನ್ ಅಂಡ್ ಇದು ಹಿಯರಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ ಎರಡು ಹಾಕಿ. ಅಡ್ಮಿಷನ್ ಏನಾದ್ರು ಸ್ಟೇ ಅಂತಾರೆ ಬಂದು, ನಮ್ಗೇನೋ ಅಸಿಸ್ಟ್ ಮಾಡಲ್ಲ. ಸ್ಟೇ ಕೊಡಿ ಅಂತಾರೆ ಅಷ್ಟೇ. ನಾವೇ ಓದ್ತೀವಿ ಸ್ಟೇ ಕೊಡಿ ಅಂತಾರೆ. ಎರಡರಲ್ಲೂ ಕನ್ಕರೆಂಟ್ ಫೈಂಡಿಂಗ್ ಇರುತ್ತೆ, ಬಂದಿದ್ದು ಸ್ಟೇ ಕೊಡಿ ಅಂತಾರೆ. ನೋಡಿ ಅದೇ ಹೇಳಿದ್ದು ರೀತಿಂಗ್ ಸಿಗುತ್ತ್ರಿ. ಈಗ ನೋಡಿದ್ರಲ್ಲ ನೀವು, ಸ್ಟೇ ಕೊಟ್ರೆ ಈಗ 10 ವರ್ಷದ್ದೆಲ್ಲ ರಿವಿಷನ್ಸ್ ಪಿಟಿಷನ್ಸ್ ಇದೆ. ಅದಕ್ಕೆ ಅಕೌಂಟ್ಸ್ ಕೇಸ್ ಆದ್ರೆ ಬರಲ್ಲ, ಬೇರೆವೆಲ್ಲ ಇರ್ತಾವ. IPC ಅಫೆನ್ಸಸ್ ಎಲ್ಲ ಇರ್ತವೆ. ಆಯ್ತು
ಮಾಡಿಲ್ಲ ಅದನ್ನ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್. ಮೇಡಮ್ 73 ಅಲ್ಲ ಆಯ್ತಲ್ವಾ ಮೇಡಮ್?
ಹಲೋ
ಸರ್ 73 ಅಲ್ಲ ಆಯ್ತಲ್ವಾ ಸರ್? 73 ಅಲ್ಲ ಆಯ್ತಲ್ವಾ?
ನಿಮಿಷ ಅಲೋಡ್ ಆಗಿದೆ ಸರ್.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು ಸರ್. ಥ್ಯಾಂಕ್ ಯು ಸರ್.
Yeah.